Good morning, and surprise, I put out the big schedule yesterday, and then here I am just dipping in. Hi, I'm your host, Bob Mata, and welcome to Defense Diaries, the podcast. We are jumping in on this coverage. I did not know this was going on. This is a rare kind of unicorn hearing in that it isn't trial, it isn't a pre-trial hearing, it is post-conviction work. Allie's still under the weather and she has court. So no, she's not going to be joining us today. Hopefully she'll be with Josh Schiffer and I tonight, though. That'll be great. I would love to have Allie on this live too, because she does post-conviction work. So real quick, because I want to jump in because we're late. I saw this. It popped up on my feed. Somebody tweeted at me. They're like, hey, probably check this out. I did. I'm like, oh, so this is the CornRake Killer. Do you guys remember this trial? This is the farmer in Iowa. I think they lived in Greeley, Iowa. Claimed that his wife had stepped on a corn rake. It flew up and impaled her in the back, which led to her death. State's like, nah, you murdered her. You put her in there not once, but twice. He's like, no, I didn't. They go through the direct appeal, denied. I pulled that up. It's really short, the direct appeal. It might be worth us going through it. So this happens back in again, 2018, like in the fall. Goes to trial. Essentially what you're going to hear, because I'm going to start right where the kind of the brief opening statements of the post-conviction. So a post-conviction relief act petition comes typically after you have your direct appeal. Okay. In a post-conviction relief act petition, this is where you see the ineffective assistance of counsel claims, as well as new evidence, newly discovered evidence. So we're going to hear both of those things. Now, when I was listening early, it kind of blew my mind, and I was telling Allison, she was getting ready. I'm like, so apparently this guy's lawyers conceded that it was a murder when the client was always saying that it was an accident. So that's kind of brutal. So very high burden. It's a very, very high burden in a post-conviction petition. Okay. I mean, there's procedural hurdles that you have to clear before you get to a full hearing. It appears to me that they have cleared those hurdles, because this appears to be the full hearing. So we're going to hear some witnesses. I think it's going to be interesting. If it goes past today, obviously we're watching Reed. Obviously we're watching Donna Adelson. And I obviously want to watch Brian Walsh. So those things are still going to go down. I'll figure in place. I think that you guys are going to really, really find this interesting. It's not something that we commonly see. It's a different part of the process, one that you are not going to be accustomed to. And it's different because you're hearing the arguments about the ineffective assistance of counsel. You're hearing the arguments of that there's newly discovered evidence that at the end of the day, if you took out the ineffectiveness of his attorneys and you infused the new evidence that they've discovered, that the trial would have ended with a different result. I mean, that's what the argument is, in the hopes that ultimately that he can get a new trial. That's what the argument is. I mean, this guy's got some backing behind him. Like, this isn't like, he's got some Innocence Project behind him. So there's some people that are convinced that this wasn't a straight up murder, because if you know anything about this case at all, the state once again created the narrative that this was a miserable marriage, that she had cheated on him once, and then it apparently had cheated on him again, and that Todd was jealous and controlling, and that he wouldn't let her off the farm. And, then they found some text messages between her and somebody else where she's like, guess what I'm doing today? I'm cleaning fucking lights in the barn, or, so they're painting this picture that this is a miserable marriage, and they're putting in text messages and other witnesses that claim that Todd has been working on this family farm. It's his family farm since he's 11 years old, and that he's not losing the farm. So they're trying to build the motive, the state was, and obviously we're successful at trial, that he'd rather kill her than get a divorce where she's getting half the farm, which, if the guy would have consulted with an attorney, it was premarital. She wasn't getting any of the farm. So, but again, if that's, if your attorneys are conceding that it was a murder as opposed to accidental, I mean, where are you going to go? So without further ado, let's jump in. I think you guys will think it's interesting. I did pull up the appeal. If there's a break, I'm going to read through some kind of like the factual background. It's a really short opinion. It's only 16 pages, which is pretty short for an appeal. So let me get this up. I have it queued up right at the beginning of the hearing, and I'm going to do it at 1.25. So it's not too fast, but it's fast enough to where maybe we're catching up. It's not as if we're going to get a decision today, so we're really not missing anything if we're a little bit behind. All right. Let's get this guy going. All right. Mandy, see if you can cover the... Oh, Mandy's not even back here with me. I got nobody back here with me. Tracy, are you in chat? Come back, please. See if you can figure out how to cover the law and crime thing up. All right. Y'all ready? Let's go.
Your Honor, with the court's permission, I'll stand just for this opening portion of the proceedings today.
Certainly.
Good morning, Your Honor. Todd Mullis has always believed that his wife, Amy Mullis's death was a tragic accident. He always believed this because he was on his family farm the day that she was injured. He was there right after his son, Tristan, found her. He was there as he and his son, Tristan, tried to give Ms. Mullis emergency aid and rushed her to where EMTs could get her to the hospital. He was there when first responders treated her injuries like they were the result of an accident. And he was not aware of any information that would tell him that what happened to her was anything other than an accident. Even when police began an investigation and began to treat him like a suspect, he did not stop believing that what happened to Ms. Mullis was an accident. He knew he had nothing to do with her death, and he didn't believe that there was any evidence that anyone else did either.
All right, for the opening, I'm going to slow it down because I want you guys to have a clear understanding of, she's laying out what they're going to show today. So, and this is brief. It's like 5 minutes, 6 minutes long. So I'll speed it up when they get the first witness on, which is an EMT. And the prosecution gives a very short kind of opening remarks.
His account of what happened and his beliefs, unlike the accounts of some of the people that you're going to hear in this post-conviction trial during this week, has always been the same. But at trial, he did not have any way to present evidence to the jury that this was an accident. And that issue is what the court's going to hear about over the course of this hearing. The court's going to hear evidence that he begged his attorneys, begged them all through pretrial preparation to investigate this case as an accident. The court's going to hear evidence that his lawyers disregarded what he was telling them. The court's going to hear evidence that his lawyers did not talk to experts or fact witnesses that would have helped them understand and present a case that this was an accident. And the court's going to hear evidence that his lawyers did not listen to his explicit direction to investigate these issues and to pursue this case as an accident. And because his attorneys did not listen to him, because his attorneys did not investigate or present these issues, the jury did not hear important evidence that they needed to hear to understand that the state's case was simply wrong. The jury heard the exact opposite of what Todd Mullis asked his lawyers to present. They heard his own lawyer in opening statements tell the jury that Todd didn't know what he was talking about, that Ms. Mullis was murdered. They heard his own lawyer, in effect, tell the jury that Mr. Mullis was not credible. They heard his own lawyer make these concessions on day one, right when this trial began, and then really have no defense to present on Todd's behalf. His lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And
Bob, you're muted. Bob, you're muted.
If I could get rid of this cough, I'd quit muting. Thank you. So, did you guys hear that? I'm gonna replay it. It's that few seconds. It's kind of stunning in the sense that they decided to concede that it was murder when the defendant's telling him, no, man, this wasn't murder. She had to have stepped on the rake or something happened where it went in her back. It like to have the, but again, strategy, when it comes to strategy, how they're going to try the case, that is left in the purview of the lawyer. It's not one of the things that the defendant gets to choose. They get to choose whether or not it's going to be a bench trial or a jury. They get to choose whether or not they're going to plead guilty. And they get to choose whether or not they are going to testify on their own behalf or stand mute. So, you know, like that's what's in their purview. Like they don't make attorneys do the bidding of the defendant, meaning the defendant isn't going to control what the strategy is going to be. Because I mean, could you imagine, like, if defendants were controlling the strategy? That's where you get Daryl Brooks and Sarah Boone, like that. Like that's what's going on in cases like that. You've got defendants that are adamant about how they want the case tried, and then every lawyer that goes to them is refusing to do it that way because they think that it's a losing strategy. And so it creates a rift. So that's why you have lawyers dipping on, especially Sarah Boone, just dipping on her like, nah, like, and she was probably all over the place. I mean, that thing switched course like 2, 3, 4 times in terms of what they were saying. So it's kind of shocking to me, though. I mean, because that is a major thing. Like that is something, and I'm assuming, I don't know. I'd have to I don't know if he had private counsel or if he had public defenders. If he had public defenders, it's tougher to get rid of them if you're not in agreement. So I just wanted to point this out. I'm gonna, like I said, I'm gonna bloop it a little bit because I just want you to hear this, because it's a foundational piece of this, of the ineffective assistance of counsel.
his lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And at this point in the proceedings, the court has heard in various pleadings at other hearings that we've had, the PCR team for Todd repeat this to you over and over again in all of the filings, that this was an accident, that this is what this case is about. And we've repeated that to the court because it's true. And it's among just the many reasons that Todd Mullis deserves a new trial and what this court is going to hear at this hearing. On behalf of Mr. Mullis and his team, we're grateful that after all this time that we're here, that Mr. Mullis is able to be in court this morning to remedy this wrong. Nobody listened to Todd at trial, but this week he'll have an opportunity to be heard through this case. And the court is going to hear other important evidence as well that the jury never heard, that is going to create at least the reasonable probability that the outcome of his trial would have been different if the jury had heard everything that the court is going to hear.
That's your standard right there.
Over the course of this trial. The court also knows that this is the rare PCR case here in Iowa with an actual innocence claim. And that is what the court is going to believe and know about Todd after this hearing. The court also knows that all of Mr. Mullis's most important claims survived the summary judgment rulings that the court made, and that the court is going to hear his claims and his evidence this week. And everything that this court is going to hear is going to establish that the underlying trial that Todd had was nothing short of fundamentally unfair. It was unfair because of the actions that his trial counsel failed to take, that any reasonable attorney would have done on Todd's behalf. It was unfair because the state withheld from Todd important favorable evidence that would have undermined confidence in the outcome of this trial. And it was unfair because the trial prosecutors did things that resulted in misconduct in how they presented the case and what they presented. And the court's going to hear evidence that makes clear that Todd Mullis was right. As we said, the court will hear that Todd's attorneys conceded right at the beginning of this trial that this was a murder. And with that sort of tentpole in the state's case, the state telling the jury and nobody disagreeing that Ms. Mullis was murdered, that resulted in a situation where there was really no meaningful adversarial testing of any of the evidence that the state presented. And the court's going to hear evidence about each of these issues this week. The court is going to hear that the state then was allowed to present witnesses giving contradicted hearsay and innuendo that painted Todd in a bad light. The court's going to hear that that evidence painted a false image of Todd, of his marriage to Ms. Mullis and his family, and that made random Google searches that were done by a family with a house full of teens and preteens seem like evidence that Todd was planning to harm his wife. The court's going to hear the truth about those searches this week. Without Dr. Cruz, the state's main witness, telling the jury that this was a murder, that evidence is what it is, which is kind of silly, meaningless, evidence that really doesn't explain to anyone what happened to Ms. Mullis. The court's also going to hear from fact witnesses that have important details that help us understand what experts that the court is going to hear from this week are going to say, which is that Ms. Mullis's death was an accident. The court will hear from first responders and from other people through depositions and through live testimony who witnessed medical efforts for Ms. Mullis. The court's going to hear from those experts that I mentioned that are going to explain from a variety of disciplines how all of the objective evidence in this case demonstrates that Ms. Mullis's death was an accident and that the testimony that Dr. Cruz told the jury in this case was just wrong. The court is going to hear either live or through depositions from Todd Mullis's trial counsel. And the court is going to learn about the mistakes that they made and that those mistakes were not about strategy. They were just mistakes, things that were just wrong and cannot be explained by any strategy. The court's going to hear from an expert, Sean Castle, who's going to explain that the family's Google search history and electronic data from their home is exactly what it appears to be. Google searches from a family, from teens, from preteens that are using Google to search for things, sometimes random things, as we would all expect teens to do. And the court is also going to hear from depositions, from documentary evidence that makes clear that anything that anyone testified to about at trial about Todd is going to be a product of them being told that their friend was murdered. And believing their friend to be murdered made statements that were hearsay, that were innuendo, that don't aid in understanding what happened to Ms. Mullis at all. I want to say one final thing about the evidence that the court is going to hear during this trial. Mr. Mullis is here today because the state made the Mullis's private family tragedy public. And I say this because Mr. Mullis is here, his children are here, members of his family are here, and certainly for Todd and his family, they would have preferred that the investigation into Ms. Mullis's case was private, and that their family's privacy was respected, and Ms. Mullis's privacy was respected. If that had happened, and the authorities had made the right decisions in their investigation, then he would not have needed a public hearing like the one today to get the justice that he would deserve. And it is truly unfair to Mr. Mullis to his children who are sitting here today in support of Todd and his innocence, to have this be the forum to discuss the issues in this case. And I say that because the court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Ms. Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Ms. Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history. Those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week. And present them in a public way that Ms. Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved. But that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice. And that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us, and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Thank you, Ms. Thompson.
That's well
Counsel
done right
for the
there.
state,
Well
did
done,
you have an
counsel.
opening?
All right. So if you're coming in late, y'all, this is not a trial. There is no jury in the room. This is what they call a post-conviction relief act petition. It's a hearing. They've been able to clear the procedural thresholds that you have to initially to get to this hearing. This is going to be a full, they're saying it's going to take a full week. This is kind of like a hybrid between civil and criminal. It's a little bit of both. It's got elements of both. And again, I know I just said this for people that may be just coming in. I have like a law nerd boner on this thing. I don't know that I've ever seen a post-conviction relief act petition hearing streamed. This is super cool. This is super, super cool. This is going to be fascinating. This is a whole different thing than a trial. If you can't tell, I'm kind of excited. So now we're going to get into the short kind of opening statement by the state. It's always curious. I don't know if this was the actual prosecuting attorney that handled the trial. You know, this clearly is not his defense trial lawyers in terms of Todd Mullis. I am curious to know if this particular gentleman, I'm going to do a little research, or maybe Tracy can do a little research to see if this guy is the guy who tried the case, because you're going to get a different level of resistance depending on which, right? If it's the guy who tried the case, that guy is going to be bristling up, you know, I got it right. I got it right. You know, if it's another lawyer that's in the prosecutor's office that's handling it, and he's looking at what the new evidence is, and he's like, oh shit, you know, it will get a different level of resistance. Now, obviously, he's going to represent the interests of the state. However, you'll just be able to tell the difference. And like from at first blush, based on his opening statement, I kind of got the sense that he was not the guy. Mandy, is there any way that you can move that QR code to cover the law and crime logo? Is there any way you can do that? I like, that was the one thing I liked about whatever Jay used. You could just move shit. You could click on it and then drag it down. Click and drag. click and drag. All right, let's go.
You wish to present?
Briefly, Your Honor. Thank you.
Whenever you're ready, Mr. Duden.
Thank you. Good morning. My name is Josh Duden, along with Thomas Bakke and Scott Brown. I represent the state of Iowa in this post-conviction relief proceeding. As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding, which Mr. Mullis has brought and commenced to attack his conviction again.
Duh.
The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis's murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach or a shot in the dark, in a way, is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial and what has already been upheld on appeal. And that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to...
I disagree completely. If they put competent evidence on that this was accidental and not a homicide, how, in what world does he think that that wouldn't impact a jury? I'm really interested to hear the new evidence from medical personnel. It's going to be interesting. See, this guy just seems like he's mailing it in to me. Does he seem passionate? He's just making words.
Deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already, and find that his conviction of first-degree murder should stand. Thank you.
Thank you, counsel. Are you ready to call your first witness?
Yes, Your Honor. The applicant will call Carrie Pierce. Your Honor, is the court's preference that exhibits be put on the screen for everybody and the witness to see?
We can do it that way if you have them on your computer.
We do.
Okay.
I feel like you also have to allow or hit a special button. So.
I do. Let's see if we can get that rolling. Go ahead and have a seat. Ms. Piercebacker, if you want to pull that screen up in front of you just a little bit, because that's where the exhibits will display for you.
Okay, thank you.
Okay. Can you see the attorney? Yeah,
I can.
Okay, and you can adjust that so that
Okay.
it's not blocking you entirely.
Okay, thank you.
All right, and I'll swear you in.
Okay.
All right, you've been called as a witness. If you'd raise your hand, you've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
All right, Ms. Nichols-Cook, whenever you're ready, and just for your benefit, when you identify an exhibit, it will be displayed on my screen and the witness's screen initially. Once it's been admitted, then we can put it up on the big screen, assuming I initiate contact with all the right buttons. All right.
Thank you, Your Honor.
Okay, whenever you're ready.
Ms. Pierce-Bacher, could you state your name for the record today and spell it for the court reporter?
Yes, my name is Carrie Pierschbacher, K-A-R-I-P-I-E-R-S-C-H-B-A-C-H-E-R.
Thank you. We appreciate you being here today. Can you tell the court how you are employed?
I'm employed by Edgewood-Colesburg School District in Edgewood, Iowa as a music teacher. I'm currently the 512 band director is my current position.
And do you also volunteer in your community?
Yes, I do. I'm a volunteer fireman and EMT in Greeley and an EMT in Edgewood.
And Greeley and Edgewood would both be towns or their own municipalities?
Yes, they are two separate towns here in Delaware County. They're closely located together, and I work in Edgewood, so we kind of run with both services, and both services do work closely together, so a lot of our calls are shared. If one gets called, a lot of times the other one will as well. Not always, but often.
And both Greeley and Edgewood, are they entirely volunteer
Yes.
organizations? Okay. And does Greeley run at the EMT level or at a different level?
We run at an EMT level. That means that we're guaranteed to have at least one EMT on the rig when the ambulance leaves and arrives at a patient.
What can an EMT do?
An EMT does
All right, just factually, I just want to let you all know if you didn't watch the trial. So I think Todd's son discovered Amy in the barn. Todd discovered her in the barn. He yells at his kid to get the truck. The kid pulls the pickup up. Todd pulls the rake out of her back. He gets Amy on his lap and they're driving to the hospital. Okay. So on the way to the hospital, he calls 911. He says, "Oh my God, this is going on." The dispatcher tells them to stop the truck and to start performing CPR on him, which they do. EMTs show up while he's in the process of doing that. So just in case, because I don't know if they're going to give that backstory here. They might not.
basic life-saving support. We can do CPR, we can splint, we can do basic life.
Todd is a bad name. Bad name. It's not a good, it's a family name.
Saving care. We cannot do anything invasive, such as in IV, and we cannot administer any drugs through IV or through injection. We can give basic drugs such as oxygen, aspirin, Narcan for a suspected drug overdose, and we can give albuterol for a breathing difficulty or an asthma attack.
Okay.
And those are the 4 drugs that we carry in Greeley that we are allowed to give.
What's the next higher level of care?
After EMT, then you would get to the paramedic level, and they can do those extra things. They can start IVs, they can administer drugs, and that would be the next level up. Edgewood runs at a paramedic level, and then I believe Manchester is a paramedic level, and then Colesburg and Earlville, I believe, are provisional Ps, which means that they sometimes have a paramedic on board, sometimes don't, depending on the availability of their paramedic in town.
And would you consider all of these agencies to be emergency responders or first responders?
Yes.
And how long have you been an EMT?
Getting close to 25 years now. I think it was 2000, 2001, around in there is when I took my classes and completed them. I believe I started them in fall of 2000 and completed in 2001.
And you mentioned that you had to take a class.
Yes.
What are the components of that class?
The class, I don't remember the exact hour amount, but there's so many hours of class time instruction. It lasted 5 or 6 months when I took the class. It began in late September, early October, and ran through March. We met 2 to 3 nights a week for 3 to 4 hours a night. Sorry. Yeah. So we, 2 to 3 nights a week. And then
I just speeded it up or sped it up. And now the judge is telling her to slow down. So I hope that that's going to work for us. I want to try to eventually catch up. But we'll also have some bloop bloop time when they take a break. So it's a win.
And so that was the classroom portion. And then as we were taking the classes, you had to pass the different units within the class. Once you
Yeah, I CMB. This is a post-conviction relief act petition hearing. This is after direct appeal. He appealed, denied. This, it's a different proceeding altogether. It's a completely different thing. It's typically what you see after direct appeal, sometimes after an appeal to the state Supreme Court. A post-conviction is where you have to clear some serious procedural hurdles. It's typically where you see your most fervent argument as to ineffective assistance of counsel, much more than you see in direct appeals. You also are going to hear newly discovered evidence. So the question will become, is it truly newly discovered? And does the newly discovered evidence rise to the level in which, if a new trial was to occur and you didn't have the ineffective assistance of his attorneys who conceded that it was a murder, and it sounds like, and I don't remember Todd admitting that it was a murder on the stand, but if your whole defense has been that it's a murder, I mean, what are you supposed to do? Are you supposed to get up there and contradict what your lawyers are saying? I mean, he was put in a no-win situation where at the same time he wanted to be able to get up there and speak his piece. Yeah, Andy, it's a great question. Like, before I was putting this live up, Andy asked what the F is a CornRake. It was pulling up, like the leaf rakes. I'm like, okay, well, that's not impaling anybody. I saw like the kind of the garden rakes that are the real stiff ones that have like the teeth, the 6 teeth. I'm assuming that it's that, because like the bigger ones, cornflake trout. Oh my God. Thank God you didn't put that on the thumb, like a big box of cornflakes, big bowl, like Jethro bowl of cereal with thick neck Todd Mullis sitting up there pouring a big bowl of cornflakes. Would have been great.
You passed the class, then you had to also do ride time and clinical time, so many hours working at a hospital ER, making patient contacts and practicing your skills there. And then also so many hours ride time, which would be with an ambulance service, again, making patient contacts and practicing in ambulance situations. Then once that was all done, then you were finally qualified to take the state test, where you had to pass skills tests. And then if those were passed, then you went on to take the written test. And then if that was passed, you got your license.
Perfect. And then you could start.
And then you can start, yep.
And do you also like recertify or have continuing education?
Yes, we have to do the certifications just changed recently. Now the current level is it's 20 hours of recertification every 2 years for an EMT, but there are certain categories that have to be met. You have to do certain hours of cardiac, airway, trauma, etc. It used to be, it was just a blanket 24 hours of recertification, any topic. Now they have different topic categories that you have to hit in order to recertify.
Great. And for the paramedic services like Manchester, are they also volunteer, or are they employed or full-time employees?
Most of the services in Delaware County are volunteer, except Manchester is a paid service. They are run out of the hospital, and that is their job is to be on call in the ER and run with the ambulance.
And so as a volunteer, if you're not on a schedule or you're not being paid for certain hours, how are you notified when your assistance is needed?
We all carry pagers or radios. Greeley actually carries like radios similar to a walkie-talkie, that if it's set on page, you only get notified when your department is paged, or you can possibly open it up if you want to and listen to everything that's going on in the county, and then you would hear when other towns are getting paged as well. But then when that goes off, then we know that we have a call and we respond to the station.
And you also live here in Delaware County?
I do live in Delaware County.
And did you grow up here?
I did grow up in Delaware County as well.
And so are you familiar then with the geographic area and the roads and where different landmarks are?
Yes.
I want to ask you specifically about a call that, and about November 10th, 2018.
Okay.
Judge, can we approach for a quick moment?
All right, approachal.
The trial who are taking photographs with their firm that they're
Oh, little complaint.
I've just been informed that there are individuals observing the trial who are taking photographs with their phones. That is not permissible. Any phone in the courtroom is to be turned off and put away.
All right, all I can say is this person in this short-sleeved plaid shirt looks like they're shitting their pants. Yeah. This chick, she's kind of side-eyeing. She's got the downward face. I'm guessing this person seems guilty to me back there. Can you see it? Look, she's like, oh shit, you're fucked. And this person's like, oh my God. Did I fuck up?
Is to be turned off and put away. If photography, videoing, or anything is observed by any non-approved individual, there are obviously.
You think he was crying? I don't know. It's a little early, and this is like in the process. I can just tell you, this isn't a thing where you're crying necessarily. This is, I mean, the kid's already lost his mother. It was 2018. He's lost his father. And I'm just here to tell you, it is very difficult to get to this stage of post-conviction relief. Like this is a huge win. Todd Mullis is excited about this. Everybody in the family about the potential that this thing could go to a new trial. This is a big deal. So I don't know, maybe he is crying. Oh, he has been crying the whole time. All right. I stand corrected.
Members of the media who have been approved, but any other individual who is taking photos or recordings of any sort, if that is observed or it continues, you'll be asked to leave the courtroom.
Isn't it harassing the family? Just look guilty.
Thank you, Ron.
What is the
Yep,
guilty
you may
face?
continue, Ms. Nichols-Cook. Ms. Pierschbacher, you're very fast.
Slow down.
And I
apologize.
don't blame you. Nobody wants to be the first witness.
Yeah.
So if you can slow down just a little bit.
I will try.
Okay, thank you. All right.
Ms. Pierschbacher, I believe we were getting ready to start talking about November 10th, 2018.
Yes.
Do you remember that day and what you were doing?
Yes. That morning, my husband and I had gone to Cedar Falls to pick up our 3 kids. They had a sleepover with their grandparents the night before. And then as we were coming back from Cedar Falls and traveling north on Highway 38, just about home, my husband did have his pager open, as I'd said, you could just listening to traffic, and we heard a call from Manchester ambulance to the Earlville area for what appeared to be a farming accident at that time.
And so when you say he had his pager open, are you saying that it was open to the entire Delaware County
Yes,
traffic?
we could hear everything coming across. It's called County Fire. It's the channel that all the fire and EMS are paged on. We didn't necessarily hear what all law enforcement was saying or what anyone else in the county. It was the fire and the EMS paging channel is what he had open.
And you were with your husband, Dave.
Yes, Dave, my husband.
Same last name?
Same last name, yes. David Pierschbacher was his name.
Can you tell me a little bit about Dave and why he had a pager?
He was the fire chief in Greeley. He ran basically the fire side of our service. And at the time I was the EMS officers, which put me in charge of the EMS side of our service, but it was basically one combined service. So yes, we were both members of Greeley Fire and Ambulance. We both carry pagers. His happened to be open to the Delaware County channel at that point in time. Mine was closed to just page.
And do EMTs normally work together in twos or in pairs?
Our protocols is that you always go with at least 2. You never leave the station without 2. And since we are an EMT service, one of those 2 must be an EMT. We do have members of our service who are fire only. We have some people who are EMRs, which means emergency medical responders, which would be the next level below an EMT. There's a couple of skills that EMTs do that EMRs cannot. And we have a few of those. But our protocols are if the ambulance goes, there's a minimum of 2 people on board, and one of those 2 must be an EMT.
And was Dave an EMT?
He was as well, yes.
And it's my understanding he's unable to be here today.
No, he is not here today.
And why is that?
He passed away in 2022.
So while you were driving back from Cedar Falls, I think you started to say you were listening to traffic and you heard a call. Can you tell us about that call?
We heard, it sounded like Manchester ambulance getting paged for what at that time appeared to be a farming accident. It said that there was a male subject who was transporting a female subject to the hospital along 170th Street, that she had been hit by forks, and that Manchester was paged out to intercept with them. But also at some point it was said that the original location was somewhere near Earlville, because I remember Dave asked me, why is Manchester responding to Earlville? And I said, I don't know.
Was that unusual?
Not kind of. Usually Earlville would have taken that area, but we didn't know, were they out on another call or something else? There are circumstances where different ambulances cover different territories.
And is Earlville also a volunteer?
They're also volunteer.
EMS? And did you have any impression or recollection of what the demeanor was while you were listening to this radio traffic from dispatch?
I just remember everything just seemed very confusing. We were just listening to the traffic and we heard Manchester ambulance go en route, and we heard them continue to ask dispatch for a location, and that they said that they were coming in on 170th Street. And then at some point we heard them say that the subject had stopped so that they could start CPR on the female victim, that they were somewhere along the road on 170th Street. So Manchester ambulance headed in that direction. And so we were still continuing north on Highway 38 from Delaware to Greeley. And at some point, Manchester ambulance was continuing to ask for more directions, or how far out are they? And they really weren't getting any information. And then Manchester ambulance asked dispatch to page first responders. And that's when Dave and I said, oh, that's us. We need to get to the station, because we even flipped on our blue light, our light that we use to respond to situations. And we started heading right for the station, thinking that it was us getting paged and we had to get there. And then dispatch actually paged Manchester first responders. So we're like, oh, but we were already at the station at that point. So we just waited for a minute to see what would happen.
And for those of us that didn't grow up in Delaware County, how close is Manchester and Greeley, or along 170th Street?
Along 170th Street. 170th Street, it's also known as the Oneida Blacktop. It is a long road. I don't know, probably 12 miles, I'd say, between Greeley and Manchester-ish. I know it's 17 to my house, but I live a little bit further than Greeley. So,
at some point, while you and Dave were at the Greeley station, did you prepare to respond or leave the station?
At some point when we continued to hear the voice traffic back and forth of where they located, how far out, Dave did get on the radio and asked Manchester ambulance if he would like Greeley to respond from that side of 170th to see if we could find them. And figuring between Manchester and us coming from the two directions, eventually we would run into them at some point. And Manchester ambulance responded yes. So Dave and I got in the ambulance and took off, and we radioed to Manchester that we were en route. We radioed to Manchester dispatch that we were en route.
Okay. And so is it a fair characterization that the people needing help were somewhere on 170th Street, the Manchester ambulance left from the hospital in Manchester, and then you left from Greeley?
Went from Greeley.
And you guys, did you eventually meet?
At some point we were going to meet up. We actually found the victim first. They ended up being very close to Greeley. Actually, they had not gotten as close to Manchester as we had thought they had maybe gotten. We actually found them just south of Greeley, 2.5 miles, at kind of the intersection of 38 and 170th.
Great. What did you?
No, Julie, I'm at 1.25. We're kind of way behind. If you guys think it's a little too quick, 'cause she is a fast talker, I'd be willing to slow it down, because I think that we'll be able to bloop through breaks. So you guys let me know in chat if you do want me to slow it down. I do want us to be able to hear everything clearly, and she is definitely a fast talker. So let me know in the chat, please.
You see when you got to that intersection?
When we got to the intersection, the first thing we noticed is the flashing lights from the deputies' cars. At that point, the deputies had arrived. We had just passed that location a few minutes before, but didn't notice anything. Now we saw the flashing lights, and so we're like, that's where it is. And we radioed to Manchester where we were. We went to turn into the driveway, and one deputy ran to the road to meet us to make sure that we saw them and that we knew that's where we were going. So we pulled into the driveway. It was a driveway of a home that was under construction at the time. So there was nobody who lived there. And the driveway was very rocky and muddy. It was under construction. And so when we pulled in, we could see a deputy was performing chest compressions on the female victim, and there was a forklift nearby for the construction of the home. And so after being paged that we had heard somebody hit by forks, I was still thinking bale spears from a tractor. And then I started to think, oh, that forklift was somehow involved in this incident. And so Dave and I pulled the ambulance over as we pulled into the driveway to the left to get out of the way for the other approaching ambulances. I went directly to the victim to relieve the deputy who was giving compressions, and Dave got the equipment out of the ambulance, the Lucas device and the AED.
Okay.
And then he met me at the victim a few seconds later.
And if I missed this, did you know who was building that house or whose property you were on?
I did know whose property we were on. It's the property of Brian and Rachel Krogman.
Okay. And you mentioned that.
All right, I'm going to slow it down for this witness because she's a fast talker. I mean, the judge told her, "Slow it down, lady. You're really spitting here. So you gotta reel it in."
From the radio traffic and from the dispatch statements that you thought you were going to a tractor baling fork accident.
That's what I thought.
For those of us that aren't farmers, a baling fork, a larger item?
It's a large attachment that goes on the front of a tractor to move large round bales.
Okay. And did you have any concerns about a patient being transported by their family towards the hospital?
No,
And why is that?
because it's common in our area. We're very rural. We all know what the transport times are and what the response times are. I know just for our own department, our goal is from the time of the page to be at the patient within 10 minutes. And I think the community knows that too. So, and I know a lot of people kind of think, well, I can be at the hospital in 10 minutes. And so, no, it is not unusual for a family member to just take a loved one on their own, thinking that they could probably get there faster than waiting.
And in your 25 years of being an EMT, have you responded to other farming type of accidents?
Yes, it's not uncommon in the area. It happens. It's a farming community.
Okay. Circling back to what you saw when you were in the driveway, can you describe the patient and what you did next?
As I approached the patient was lying on her back. One of the deputies was doing chest compressions. I observed she was wearing, it appeared to be heavy chore type clothes, like a thick Carhartt coat. Underneath was a thick hooded sweatshirt. I believe I said she was lying on her back on the gravel driveway. Her head was turned slightly to the right, and her face, the right side, was covered with blood and a brown substance that appeared to be vomit. And the vomit was coming from her nose and her mouth. It was on the right side of her face, and it was also caked in her hair.
Okay. And what was the first thing you did when you reached the patient?
I took over compressions for the deputy.
Why did you do that first?
Because 2 minutes is about the limit that anyone can do good chest compressions. It's just standard that you try to relieve a compressor within 2 minutes if possible, just because after that fatigue starts to set in and then the compressions aren't always as effective. I had no idea how long he had been doing compressions. I was guessing probably longer than 2 minutes at that point. So I was trying to relieve him and get a fresh person on her until we could get the other equipment in place.
And when you started chest compressions, were you doing them over the sweatshirt or over the coat?
The coat was open, but I continued to do compressions over the sweatshirt.
And did you observe any other obvious injuries or wounds?
No, not at that time.
And were you expecting to see something else?
Well, I was picturing getting hit by bale forks. I was expecting to see very large wounds somewhere and that I was not seeing. And so I was confused as to how the bale forks came into this picture, because I wasn't seeing the massive trauma that I was expecting to see that I would expect bale forks to cause.
And did you know who the deputies were at the scene?
One was Deputy Thompson and one was Deputy Holub.
Okay. Did you guys have a conversation or exchange information about what had happened?
We just started talking. I do know at one point when I started compressions and I asked what happened, one of the deputies told me, I think we were dealing with a fall. And then I'm pretty sure at one point I asked, did this happen here? Because I was still under the impression that that forklift I saw sitting off to the side had somehow been involved in this incident. And then that's when Todd, who was in the background, he said, no, this didn't happen here. This happened at our farm a few miles east of here.
Did you know the identity of your patient at the time?
At that point, no, I did not.
Did anybody else from the Greeley EMT team respond?
Eventually, there was a third Greeley person who got to the scene of the patient, Steve Engelken. As I took over compressions, I did ask the deputy to page Greeley for more help because at that point, our pagers had not tripped yet. It was just Dave and I. I knew we had other people close by that we could probably get there faster, even the Manchester ambulance could, if they would just be paged. And the deputy asked for Greeley to be paged, and the dispatch replied with, Greeley's already on scene, they don't need to be paged. And so we asked again to have them paged for more help, and then Greeley was paged. By the time most of the responders responded, Manchester had already gotten there. So Steve Engelken is another member of our service who did get to the patient. I believe he got there at roughly the same time that Manchester ambulance arrived.
Okay.
But I know he was helping with resuscitation efforts at some point. The rest of the Greeley people arrived, but already saw Manchester ambulance and Greeley ambulance and everyone there. So they stayed on the road and conducted traffic control and did not approach the scene.
Okay. And then you mentioned that Dave got the Lucas device and the AED off the ambulance. Can you tell us a little bit about what a Lucas device is?
A Lucas device is basically an automatic CPR device. There's a board that resembles, I don't know, maybe a snowboard would be the closest comparison I can think of. Has a slight curve to it. It goes under the patient's back, like from armpit to armpit. And then there's another U-shaped device that comes down and clips over top of that. And then from that device, there's a plunger that goes down onto the patient's chest. And then once it's turned on, the plunger does the compressions for you. So then the manual compressions are no longer an issue and we don't have to worry about rescue or fatigue. The Lucas just keeps going with good quality compressions.
Okay. And so, and then what's, how is an AED different?
The AED is an automatic external defibrillator. That is the part that actually attaches to the person's.
Is there anything better than when Brooklyn comes in hot? I don't know if there's anything better than that. Like, it's very close between Mandy and Brooklyn as to who's funnier. They're both super, super funny and super, super bright, which helps when you're funny,
Chest and shocks the heart to try to get it back into rhythm.
Okay. And what did you do? What did you guys do first?
Once Dave got to us with both of those devices, the first thing we did is attach the AED. At that point, we pulled the victim's sweatshirt up and we attached the two pads. The pads go upper right, lower, and then on the right side, and then on the rib, lower rib on the left side. So we attached the pads, we turned it on, it analyzed, and then an AED is looking for a certain cardiac rhythm before it will issue a shock. So as it analyzed, we stopped our compressions and let it analyze, which is protocol. And then the first time it analyzed, it said no shock advised, which meant it did not pick up that shockable rhythm, continue CPR. So we continued CPR.
Okay. And when you pushed your patient's clothing up, did you make any observations about other injuries?
Yeah, as we lifted up her shirt, we were looking for some other things to see because I was still trying to figure out how this injury happened. There was what appeared to be possibly a slight bruise on the right rib cage. At that point, it was very faint. We thought maybe it was a bruise, but we weren't 100% sure. And then there was also a mark above her right breast that looked possibly like a very small puncture wound. But again, we weren't 100% sure what we were looking at. We saw something there, but had not, we're not able to determine what had caused that. So we made note of it in our report.
See her slow herself down. She is a fast talker. She caught herself. She's like, let me slow it down. Thanks for asking, Julie. She's better. Definitely better. She's improving.
Okay. Did you observe anything, any injuries on her face area?
Again, possibly a slight bruise on the right side that was noted in the report. Again, at the time that we saw her, it appeared very faint. We thought it was possibly a bruise, but we were not 100% sure. So again, we noted it in the report.
Okay. After you set up the AED, did you then do the Lucas device?
Yes, once we did the first analyzing with the AED and said no shock advised, continue CPR, I continued manual chest compressions, and then Dave and the deputy started setting up the Lucas device. Dave started and the deputy assisted with getting everything in place. I continued manual compressions until the Lucas was in place and could start.
Okay. And you were able to utilize the Lucas to do chest compressions?
Yes, and then once it was in place, we turned it on and the Lucas took over chest compressions.
What did you do after that?
Then I went back to the ambulance to get the airway bag to secure an airway and to start breathing for the patient. So I brought the airway bag back to the patient, opened it up. I took out a King LT. That was the intubation device preferred at the time. And so that's what I took out. At the time that I had gotten that out, then that's when Manchester arrived on scene.
Okay.
I apologize for the interruption, but could we have a quick sidebar?
Sure.
All right, let's bloop. Bloop. Bloop, bloop, bloop. What happened? What happened to the stream? Oh, there we go. Damn. If I would have known this was going, I would have just drove my ass right through Iowa. It's probably only a 3-hour ride for me. What's this camera guy doing? She does not look happy about being on camera there.
Go ahead.
No member of the media.
Wow.
That unless you are an approved member of the media, there is to be no photography, recording, social media posting,
Oh, no live tweeting.
or any recording of any kind of this proceeding. I am aware that there is a specific individual in this courtroom who has posted photos on a social media site from this trial this morning. It is only because I cannot ascertain specifically if that photo or those photos were posted before or after my preliminary warning that individual is not already being removed from the courtroom by a deputy. If there are any further posts, the individual will be removed, as will any others. We will not have this proceeding derailed by members of the public who are not following the restrictions on recording, photography, and the rules of this court.
You tell him, Judge. You
My
tell him.
apologies to the witness and to counsel.
She's not playing. She looked like she's
I
playing.
hope we have no further
Everybody in chat thinks
interruptions.
she's playing. I don't think she's playing.
Ms. Pierschbacher, again, if you can try to slow down. I think you just get faster and faster.
Yeah, the judge is taking copious notes. I mean, this, like I said, this is a post-conviction relief hearing, and or trial, if you want to call it. It's really a hearing, but she's the one who's making the decision here. So it's going to be up to the judge as to what happens.
Okay. All right. Ms. Nichols Cook, whenever you're ready.
Thank you, Your Honor.
It's like a thoughtful-
Ms. Spitzbacher, maybe act like we're high schoolers, I guess, and we don't listen the first time and just go slow for us. But we were talking about an airway bag, and could you help us all understand a little bit about what you were using? I think we've all seen mouth to mouth, and so tell me about the airway bag.
Okay, so our airway bag specifically carries all of the equipment that we would need if a patient were to have a breathing problem. There is an oxygen tank in that airway bag. There is also it's called an AMVU bag. It's the bag that you put over their mouth and squeeze to help ventilate them, that we carry in there. There is also nasopharyngeal airways, which go into the patient's nose, and oral airways, which are hard airways that go into the patient's mouth that are used to hold the tongue out of the way. Those airways are used for a patient who is still semi-conscious and would have a gag reflex, who would not tolerate anything down their throat. In this particular case, we used a King LT, which is a long tube that is inserted into the patient's mouth, and it goes into their trachea, and there are 2 balloons that blow up to hold it into place. And then there's a small opening at the top that AMVU bag I was talking about. If you take the mouthpiece off, the round tip goes right onto the top of the King airway, and then we can ventilate directly into the patient's lungs. So that is what I was getting, the airway bag, and that's what we had decided was our best option for that patient at that time.
Okay. And was your patient responsive at all?
No.
And in order to insert the tube then into your patient, did you have to do anything with her mouth or her nose?
Yes. So when I inserted the tube, what I did is I positioned myself at her head so that she was directly in front of me. I was at the top of her head. Other people were still working on doing things with her. I was kneeling on the ground above her head, and then what I do to insert is I reach through and I grab her lower jaw and her tongue, and I lift it up to pull the tongue out of the way and to open her mouth. And then with my other hand, I take the tube and insert it into her airway. And then we have a syringe that then blows up those balloons to hold that tube into place.
Okay. Earlier, you mentioned that the right side of your patient's face had blood or maybe a vomit substance.
Yes.
Was that still present when you were inserting the tube?
It was still present. And before the tube was inserted, we used a suction device to suction her mouth clean and clear so that we could get the tube in without getting any extra debris into her airway.
Okay. Would getting debris in her airway be harmful to your efforts to get her breathing?
Well, it could, because then it would be basically like aspirating whatever that was, and then it would just cause further problems for the patient down the road.
Okay. And I think you mentioned that as you were working to do this, the Manchester paramedics arrived.
Yes, the Manchester crew arrived because at first when they arrived, we filled them in on the situation and told them what we had done so far and what we knew. And then I actually backed off on the airway for a moment, just because at that time it was their scene to control. And I just said, we're about to insert an airway. And then that's when they said, well, you are an EMT, you can do that skill, right? And I said, yes, I can. And then they said, please do help us. And so we stayed on scene and continued to help them as they were doing what they were doing.
And in addition to suctioning out the mouth and the nose, did you also have to move her face or handle or wipe things off of her?
I don't remember if we did any wiping. I do know we did have to suction, and then her head was turned slightly to the right, so we would have pulled her head back to center to make it easier to insert that tube.
Okay. After you inserted the airway tube, what do you remember doing next?
At that point, then we hooked up the airway bag, and I started to ventilate for her. the ventilations were going in harder than I expected them to. I was feeling some resistance, which is not normal. But at that time, that's when we were getting ready to move the patient. They had brought a sheet from one of the ambulances. And so the way that we lifted her that day is we did something called a log roll, where we roll the patient onto her side, put the sheet under her, pull it back out from the other side. And now she's laying on a sheet instead of on the bare ground. And then we're able to use that sheet to lift her.
Log rolling's fun though. Did you guys ever log roll as a kid? It's great. I used to log roll down hills. So much fun.
And get her onto the cot and into the ambulance. So the sheet was the method that we used that day to get her up onto the cot and loaded. So at the time I got the airway in place was the time that we rolled her, got her onto the sheet, and moved her towards the ambulance. I was ventilating the whole way to the ambulance. When we got to the ambulance, I did tell the paramedic, please check this airway. There's more resistance than there should be. Make sure I got it right. And then I handed the airway bag off to one of the Manchester personnel, and they continued care to Manchester.
Did you note any other injuries during that log roll procedure?
During the log roll procedure, I did not see any other injuries myself. As the patient was rolled, I moved with her face to continue to give ventilations. I did hear one of the Manchester responders say, we have a through and through, when they saw her back. I personally never saw her back at the scene. I don't know what it looked like, but I did hear one of the Manchester responders make that comment.
Did you note any other injuries to her mouth, a cut or anything like that?
No.
And in your experience, is the act of performing CPR or using a Lucas device a traumatic event to the body?
It can be, yes.
Was your care ending then as the patient was loaded into Manchester's ambulance?
Yes, that is where our care of the patient ended. We handed off to Manchester. Shortly after Manchester ambulance arrived on scene, so did Manchester first responders, because they were paged out after. So between those two crews, they got enough people in the back of the ambulance to continue care all the way to Manchester. So it was Manchester's full ambulance crew. And then I believe a couple of their first responders who came out in the first responder rig also went back with them to be extra hands to help with resuscitation. So we were not needed to go in the ambulance with them. They had enough people.
Okay. And at some point, do you learn the patient's name?
Yes, as we were loading her into the ambulance, one of the Manchester responders or ambulance members said, we need a name and a birth date for the victim. And then that's when we asked, what is her name and birth date? And that's when we learned it was Amy Mullis. Up until that point, I didn't realize who we were working on.
Had you met Amy Mullis before November 10th, 2018?
Yeah, we were acquaintances. Amy's and Todd's daughter was in gymnastics with my daughter, so we would see each other at gymnastics events, and they also attended the same church as us.
Did you realize the individual providing information to you during your care was Todd Mullis?
I did not realize that either at the time. It was out of context. I was used to seeing him together with the family, and this was out of context. So no, I did not place that. That was Todd as well.
Can you describe Todd's demeanor while you were on the scene?
From what I observed, he seemed to be kind of anxious, nervous. He seemed to be pacing in the background. He wasn't interfering with resuscitation efforts at all, but he was close by to provide information as we would need it. As if we would start to talk about something or ask something, he would respond right away with information he had or knew. But yeah, he was close by enough to give information, was pacing.
Nothing that alarmed you?
No.
I'm sorry, start over. Did you also then know Todd and Amy's children?
I did. At that point in time, I knew the younger two children better. Wyatt and Taylor went to church with us. I was their Sunday school teacher for a while. I knew Tristan also at that point from seeing him in church with the family, but I did not know him as well as I knew the younger two.
Did you see?
What's up, Phil? I'm excited then. Still got this Butte, by the way. Remember, I took screen grabs like, I'm not giving this thing away until like I get a full wheel. So I haven't figured it out. I don't know. Maybe I'll do a little with Josh tonight. But this thing, Phil, I just want to tell you, I'm deeply, deeply in love with it. I really don't want to give it away, but I'm going to, in the hopes that maybe you'll send me another one.
See Tristan on November 10th, 2018.
Yes, a little bit later. Up until that
Or
point, I
Durable.
had not noticed him. After Amy was loaded into the ambulance and Manchester took off for the hospital, we turned to start getting our stuff picked up, and that's when I realized Tristan was there as well. He was standing back a lot further than Todd. There was a trailer attached to the pickup that they had been using to try to get Amy to the hospital, and he was on the back side of the trailer.
After the Manchester ambulance left, what did you and the other Greeley EMTs do?
Because some of the Manchester first responders had left in the ambulance service, or in the Manchester ambulance, that left a couple of their first responder vehicles unmanned. So our other responder, Steve, who was on scene, he actually helped Manchester to get the rest of their vehicles back to their station. Dave and I took the ambulance and we followed to Manchester because our Lucas device was still being used in resuscitation efforts. And so we said we would just follow and wait for it to be done to get it back. So we proceeded to Manchester. We stopped at the fire station we stopped at Manchester Fire Station to pick our other responder, Steve, up, because that's where they keep their first responder vehicles after he helped them drop those off. And then the three of us proceeded to the hospital to wait for the Lucas.
Okay. When you got to the hospital, where did you go?
We just went into the common area in the ER, the hallways. We were just planning to hang out in a corner and try to stay out of the way until things were done.
And did you observe Todd Mullis or any of the other family there as well?
Todd, I believe, was there and had a friend with him. And they were in kind of the family waiting room. They had a special waiting room, not the general public waiting room that everyone goes into. There's a separate one back in the ER for family to wait in. And so he was in there with a friend.
Okay. Did medical staff approach you and Dave or Steve?
One of the RNs came up to us as soon as we got there and
What did you and Dave do after you interacted with medical staff?
we waited. Dave we would take turns waiting in the family room with Todd. Dave spent most of the time in there. I went in, I believe, once for a couple of minutes.
And were you asked to go in? Were you instructed or informed that you needed to go into the waiting room?
Objection, calls for hearsay, relies on hearsay testimony.
Your Honor, it's been offered to show what she did and why she did it.
Overruled. The witness can answer.
We were told to make sure Todd was not left alone and to make sure one of us was with him at all times.
Hearsay again, ask that the objection precede the response, Your Honor.
Overruled. The answer will remain in the record.
In your 20 plus years of experience as an EMT, has that ever happened to you before?
No.
Phil, I sneezed into the crook of my arm, so my hands are clean. But then I did kind of wipe my mustache off. So good point, Phil.
Did you make any observations of Todd's demeanor while you were in the waiting room or at the hospital?
It was similar to on scene. He appeared anxious to me, was pacing.
At some point, were you able to not stay in the family waiting room any longer?
Another RN came in.
Are you familiar with former Sheriff LeClaire?
I am.
Did you see him at the hospital on November 10th?
I did.
Did you speak with him or see him speak to anybody?
I did not.
Objection, calls for hearsay response again, Your Honor.
Present sense
I didn't ask
impression.
what was said, Your Honor.
Plus, it's present sense impression.
I did not speak to him myself. I did observe he and Dave speaking to each other.
And since Dave was a fire chief in the county, was that unusual or alarming?
No.
At some point, were you able to retrieve your equipment and depart Manchester Hospital?
Yes, at some point when the Lucas device was finished being used, we got it back and then we left and returned to Greeley's fire station.
Okay. Did you respond to any other EMS calls that day?
We did have another EMS call later that night.
Did that take you back to the Regional Medical Center in Manchester?
Yes, we transported that patient there as well.
Did you ever learn that there was concerns or instructions?
Yeah, can we talk about the egg situation? I mean, what the fuck, dude? Like, I went to the Jewels. I mean, every place is out of eggs. This is catastrophic. Egg is my number one food group. Like, without question, it's Allie's number one food group. I might die if this egg situation doesn't resolve. I paid $12 for 12 eggs, $1 an egg 2 days ago. Who's that? Hi, love. Yeah, I mean, Dixie, what? Like, I don't know what's going. Yeah, I know what it's. I know why, Megan. It's. I'm not happy about it at all. See, we have a lot of fresh egg farms around us. So Allison was just talking about we need to go. They're gonna rake us over the coals, though. You know, it's that whole supply and demand thing. You know, these farmers that sell the fresh eggs are gonna really. Oof. Ooh. Oh, wow. Look at Mandy. She caught it. She caught it. Quick, Mandy. Can't slip anything by you. Fix the eggs. Fix the egg situation. Let's go.
To complete your report in a certain way?
When we returned back for that second EMS call that night, we were actually with Edgewood crew at that time. Edgewood was the transporting service. They needed extra help. So Dave and I both ended up being in the back with the patient on the way in. When we got to the hospital, I stayed in the rig and started cleaning everything up. Dave and the rest of the Edgewood crew members actually delivered the patient into the ER. When Dave returned to the ambulance after dropping the patient off, he told me that—
Objection, Your Honor, hearsay within hearsay.
Sustained. Let me try to rephrase a little bit there. Did you complete a report about the service call regarding Amy Mullis?
I did.
And did your husband, Dave Piersbacher, contribute to that report?
He did.
Did your colleague, Steve Ingleton, also contribute?
He did.
Okay. And did you have an understanding that you need to take some extra care or caution when writing your report?
Me too, spoogs.
Yeah, I most reports are completed thoroughly, though. I usually I always make a point that every report is completed thoroughly.
And at some point, did you learn that Amy's death was being investigated as a murder?
I did.
And do you recall when you learned that?
That evening at the ER.
I
feel like I need to clarify with Lisa. Log rolling is where you use your body like you're a log and you roll down a hill. It doesn't involve actual logs. Got that? I think you've misconstrued log rolling. It appears that you've skipped that entire part of your childhood. Didn't you have a big hill? You know, it's where you put your arms to your side like this and then you roll down a hill. They call that log rolling. The thing where they're like the lumberjacks are running on a log in water, I don't know what that's called, but it ain't log rolling. Maybe they call it log rolling. It's not the log rolling I did as a young man.
Copy of your report here marked as Exhibit 216. If we can show that to you to make sure we have the right report. We'll try to get it on the screen there for you.
Lisa definitely does not live in the city. She's got 25 acres. She's not a city girl.
Ms. Perpsarka, have you had an opportunity to look at Exhibit 216?
Yes.
Okay. And does this appear to be the report?
However, she may live somewhere with no hills. I mean, the Midwest is pretty flat, y'all.
That you wrote and submitted
It appears to
regarding,
be.
and can you tell the date that you submitted this report?
That's because you've never seen nature, Brooklyn. I mean, you live in New York City, man, or one of the boroughs. It's like, you guys have at least parks, right? You've seen grass before, I assume. I hope. That green shit. Gotta mow it.
I'm not sure it's on this front page, but if I remember correctly, it was November 13th.
And so that would have been just a couple of days after
Yes.
you responded to the call? And I think you just said you submitted it. Can you tell us a little bit about what that means? Like, how do you submit it? Where does it go?
The system that we use for EMS reporting is called Image Trend. We all go in and it's what every EMS service uses. We complete the report and then it stays open. And when we are satisfied that it is done, we hit lock and submit, and it is locked and submitted, and then it uploads to the state database. And at that point, then it is considered submitted.
Okay. And after you submitted your report here in Exhibit 216, did law enforcement ever talk to you about your observations from November 10th or your report?
No,
Did anybody from the Delaware County Attorney's Office talk to you about it?
no,
And I apologize, I said law enforcement earlier, specifically Delaware County Sheriff. Did anyone talk to you? The Iowa DCI?
no,
And have you ever spoken to anybody from the Iowa Attorney General's office about the substance of your report?
no,
And were you aware, or are you aware now that Todd Mullis was charged with Amy's murder and tried and convicted of that?
yes, I am aware of that.
And then we'll flip to Exhibit 215 and have you identify that for us.
Yeah, this is an affidavit.
So 215 is an affidavit that you signed regarding November 10th.
Yes,
And my copy is a little faint, so maybe yours is a little better, but is it dated in 2023?
I believe so. I don't see the signature page on my screen, but I believe that's when it was.
We'll scroll for you.
Yes, 2023.
And prior to this affidavit in 2023, did you speak with any attorney representing Mr. Mullis?
No,
This one.
Any private investigators or anybody talk to you?
no,
Was there anything about Todd's behavior or demeanor on November 10th that was alarming to you or caused you concern?
no.
Your Honor, if I could have one moment, and then I think we have already have an agreement to admit 215 and 216, but I would formally move to admit those exhibits. You just got one or two more. I apologize. Thank you for your patience. Ms. Piersbacher, while you were on the scene that day, providing care and waiting at the hospital, did you ever observe any or hear anything that caused you to think that Ms. Mullis's injuries were not an accident?
No.
And I know you said earlier that it's not uncommon for there to be farming accidents. And so can you expand a little bit on that? Like what types of accidents you have responded to over the years?
Your Honor, I am going to object on the grounds of beyond the scope of the lay witness's testimony. She's not a certified expert, and it's her testimony as to other incidents are irrelevant for her insight and for purposes of this proceeding.
Sustained. Let me re-ask that. Have you responded personally as an EMT to other farming accidents?
Yes.
And have those included things like falls?
Yes.
And onto whether it's a farm implement or a fork or some other tool?
Objection, Your Honor. Again, this is irrelevant. It's both beyond the scope, not an expert, and simultaneously leading.
Your Honor, I'm asking for her personal experience. I'm not asking for an expert opinion.
Yes, we have been called to emergencies that involved farm implement, and we have been called to emergencies where people have fallen. We've been called to emergencies where people have been trapped. Yeah, there's several different types of farming emergencies that happen.
Okay. One last question is, do you have any recollection of the weather on November 10th? It's winter in Iowa, but other than that, do you have anything?
It was very cold. I remember it was very cold, very bitter. I believe there was like a skiff of snow on the ground at the time.
Okay. Nothing further from me, Your Honor.
Counsel, any objection to exhibits 216 and 215?
Your Honor, no objection to the inclusion of 216, but we would object to the inclusion of Exhibit 215. As it is hearsay, includes hearsay within hearsay as well, and is inadmissible. I believe it also predates the filing of this case and therefore was not made as a part of the record for any sort of consistency.
216 is admitted. Counsel, did you want to respond to the objections 215?
Yes, Your Honor. I think there might be some confusion. I guess it was my impression the state had already didn't have any objections to 215, but additionally, it's a part of the original post-conviction relief application filing in this matter. Ms. Piersbacher has identified it, and I can ask her some additional questions as far as, where the information comes from in it. But I do believe it's an admissible document that this court should consider.
Well, to the extent it was identified as an attachment.
No. It would be a remand for a new trial, not I'm letting you free. Let's just be clear on that. Bob said the judge decides what happens. So could he be released after this, like immediately, depending on how she rolls? No, you get a new trial wherein you'd get competent counsel, and whatever new evidence was introduced at this hearing that she found competent, that would be introduced to trial. Because remember, the concept of this particular hearing / trial is to determine whether or not, if not for the ineffective assistance of counsel and had they introduced this newly discovered evidence, is there a high probability that there would have been a different decision by the jury. So that's the decision she ultimately needs to make.
And I guess to the petition, it's there. The court will consider it in that fashion. Generally, I'm not going to admit affidavits, though, of witnesses who are here to testify. So 215 is not going to be admitted as a separate exhibit. Cross-examination.
Yes, Your Honor. Good morning, Ms. Kirschbacher.
Good morning.
At the time of Ms. Mullis's death, you had been an EMT or volunteer firefighter for about 20 years. Is that fair to say?
Just shy of that, yes.
And since then, obviously, you are still a volunteer.
Correct.
On the day in question, you were dispatched around 11 minutes after noon, right?
Yes.
And you arrived somewhere around 12:14, 3 minutes later.
Yes.
According to your report, which has now been admitted as Exhibit 216, you reached Ms. Mullis or Amy Mullis for an assessment at 12:15, right?
I believe if that's what it says in the report, then yes.
And the Lucas device that you explained earlier was placed a minute later.
Yes, if that's what it says.
And at that time, you left Ms. Mullis's body, ceased compressions, and went back to the ambulance, right?
I did because compressions were being taken over by the Lucas device.
So you didn't visualize her during that period of time.
I did not.
And you didn't administer the AED shock at 12:17 either, did you?
Whoever was running the AED did at that point. That's the time that it was shocked.
And I believe if we turn to directing your attention to what is page 4 of Exhibit 216, I believe it references that David Kirschbacher was the one who placed that AED shock, right?
That is possible. Yeah, I don't have that page in front of me, but if that's what it says, then that's what happened.
And 1 minute later, Manchester Ambulance took over the care
Yes.
and administered the life-saving efforts for Ms. Mullis, right?
Yes, once they arrived. Yes.
So the entirety of your interaction spanned about 3 minutes.
Probably, yes.
And for the portion of those 3 minutes, you weren't actually with Ms. Mullis the whole time, were you?
Not the entire time, no.
And according to your report, as has already been admitted, you didn't see the injuries in question, right?
I did not.
And you didn't observe the full extent of any puncture wounds, right?
I did not.
You don't document any direct references to Todd Mullis in your report, do you?
No,
You never once reference Tristan Mullis in your report, right?
correct.
And you were familiar with them, as you mentioned, right? Because your focus was actually on Amy Mullis and preventing her or administering life-saving care.
Correct.
So what we do know from your report is that you'd agree that she had bruising documented to her face.
Yes,
And you didn't actually note anything about her hands in question, correct?
no,
In fact, based upon your examination, you had no reason to check her hands, fair?
we did not.
So you can't say whether or not she had any injuries to her hands, right?
That is correct.
Nor could you say that she has any injuries to her.
Wait, Mandy, that's a classic comb over. Of course it's balding in the back. Like that is all side hair that has been grown very long and then laid flat. Laid flat. Long hair, laid fat. Oh, did you, Pammy, you quit watching Joel over at STS? He's joining on Wednesday, so make sure you're nice to him if you're in chat. He's going to talk to you. He's pretty deep into the.
That was my hair.
Exactly. Does anybody know what that clip is from? Anybody know what that clip is from? One of my favorite movies. He's pretty deep into the Ellen Greenberg case, and I want to have him come over here and give us all the deets. It's tragic case, and one that a lot of people believe that justice has not been served. Good job, Afton. Afton wins.
Or legs or feet, right?
No, those, that was removed by Manchester ambulance. They cut the rest of her clothing off of her when they took over care. So that's why that is not in my report, because that was under their care.
So directing to your specific interactions with Amy Mullis on this day, you administered manual compressions
I did.
and you placed the King airway device, right?
I did.
Tube. How long or how many tubes have you placed, would you say?
Over the years.
Can we get a little, I'm sorry, objection, a little foundation as to like a time period? Are you talking the entire 20 years or?
Sure. In a general sense, without holding you to any specific number, over your 20 years time at that point, how many airway devices had you placed? How many tubes?
At that point, well, those were.
Speaking of which, if I wouldn't get a probably like a copyright thing, the greatest comb over scene in the history of motion pictures is from American Hustle, where Christian Bale does this just like 5 minutes of surgery of like some kind of spirit glue. And like, it's the best. If you haven't seen it, pull up the clip on your phone or your computer. It's from, just put in Christian Bale comb over scene from American Hustle. You'll thank me for it. It's amazing. It's amazing.
Were relatively new at the time. I mean,
and terrifying if you're a guy losing his hair. It's really trying to hold on to it with everything you've got.
we haven't had those in the entire 20 years that I had been an EMT, but I placed a dozen.
So you were fairly experienced or aware of how to place them.
Yes.
And to be fair, those don't come into contact with a patient's lips or anything like that specifically, right?
No, mostly it's my hand that comes in contact with her face or her lips as I'm moving her face out of the way to put the tube in.
And in this instance, Manchester Ambulance is the one who was doing the suctioning, not you,
Yes,
right?
that is correct.
So you weren't applying any force with an outside suction, right?
No,
And do you recall or have any reason to believe you caused an injury to her lips yourself?
no,
And generally, when you place a King airway tube specifically, do you cause injuries to the patients you place them or administer them to?
I have not heard of that.
And in your instance, that hasn't happened, right?
No, not that I'm aware of.
So you don't have any reason to believe that you would have caused any damage to Amy Mullis's face or mouth or otherwise, right?
No,
And you didn't ride with her to the hospital either, did you?
I did not.
So your care or interactions with Amy Mullis ended at 12:18 or so.
Yes, whatever time she was loaded in the ambulance, that's when my interaction with her stopped.
And so your total interaction with Amy Mullis would have been 3 minutes, right?
Probably, yes.
In your report, you don't call it a farming accident though, do you?
What did I reference it as? What did I put in my narrative?
I believe when you were dispatched, and you can correct me if I'm wrong, that, like you said earlier, you believe that a woman had been hit by forks, right?
Yes, that's what it was dispatched as.
You don't mention a forklift though, do you?
No,
And you don't mention any bale spears, right?
nope,
So overall, you had no reason to believe or any reason to look into the cause of Miss Mullis's injuries, did you?
just to ask what had happened, and again was told we weren't sure. We thought we were maybe dealing with a fall, was the answer that we got on scene.
Is it safe to say that the family members who are noted in your report, that would be Todd Mullis?
Yes, I believe I just referenced family members in general, correct?
Correct.
Yeah.
So in that sense, it would have been reported as an unknown incident to you, right?
Yes.
So it wasn't referenced as an accident by.
I've actually seen dudes that comb over their beard, I mean, at some point you just gotta be like, fuck it, I'm bald. You gotta shave, shave it. You can't try to pull this shit off. It looks ridiculous. It's crazy. I mean, the fight is over, bro. It's done. Just got to give into it. It's done. Shave your shit. If you want to keep your side shit real close cropped, but that shit on top, bro. I mean, no. I had a buddy that was he was pretty bald up top, and he like had like just like the few strands. I'm like, dude, Nick, it's over, bro. you just gotta shave that shit off. It looks absurd. Like, do you think that somebody thinks that you have hair? I mean, oh, as far as I mean, I'm gonna like don't bet on me for the Joel Bob talk off. If it was like both of us were on another show, that would be a good place to bet, because I guarantee you I'd out talk Joel. But no, for this, I mean, I'm going to ask questions. I want to try to get information about Ellen Greenberg. So Joel will do a lot of the talking. I'll just be asking questions. So obviously, if there's, which I'm curious as to what everybody thinks about that case. You know, it's interesting. It's an interesting case.
Mr. Mullis.
It's like anything that the prosecutor's podcast gets behind, though. Like I have to look at skeptically, because I don't know. I want to get all the facts on that case. I know that the stabbings in the back of the head are crazy looking, you know, and that there's a lot of argument that the angles would be impossible. I don't know, though. I don't know. I don't know. That's why I want to get the deets on that, because if she deserves justice, then I want to be a really loud voice for it.
Fair?
No.
I'm going to object at that point as asked and answered and beyond this witness's testimony.
And people think it's the boyfriend, Sam, right? Yeah, and then they decided, when they didn't like the fact that I was arguing about due process and fair trial for Richard Allen, like they started like listening to Murder Sheet, who was saying that I was screaming and yelling that Richard Allen was innocent. And I'm like, I don't know how many times I had to say, I have no idea. I wasn't there. I tend to think that he's innocent, but what I do know for a fact is the man did not get a fair trial. And if you don't get a fair trial in this country, in a case like that, with that type of evidence, how can you trust a conviction? It's pretty simple. It's pretty simple. And if they don't have the wrong, or if they don't have the right guy, they have the wrong guy in there, the family didn't get justice. Like, this is not a complicated conversation. And none of those people have the balls to have a discussion with me, which is bizarre. I will talk to anybody about anything. I'll defend my position and let people come to their own conclusions based on both sides of an argument. That's what we do. That's what I do. There's not one person that I would ever, if I'm wrong about something, I own it, whatever the case may be. Whatever the case may be. But I'm always up for the debate. I'm a lawyer, for God's sakes. I argue for a living. That's what I love to do. So, and I have a position. And as far as Richard Allen goes, like at this point, we're just gonna have to wait and see what the appellate court does. And if not them, the Supreme Court of Indiana, what they do. And then we'll see where it lies. And if, you know, they kick it back, then there's going to be a lot of people that are like, wow, guess Bob wasn't talking shit that whole time. But, you know, it's really, really hard to get a conviction overturned. Really, really hard. Really hard. That's why this thing is amazing. That's why I'm like so fascinated about this. Like, you guys, this is I'm telling you, this is like a unicorn type hearing. I've never seen a post-conviction relief act hearing / trial streamed. And I can guarantee that none of you have either. This is the first one that I've seen, and it's very, very interesting. This thing's going to pick up speed, y'all. It's going to pick up speed. Plus, Phil says that the hot doctor's coming on, so let's go.
Overruled. The answer will remain in the record.
That was you. Yes.
Sorry, could you please re-ask the question?
So Mr. Mullis had never referred to it as an accident or otherwise to you, right?
No, it was very confusing. We were trying to figure out what had happened. As you said,
Yeah, like I haven't watched the Hidden True Crime thing. I can just tell you, like I've never been anything but kind to Lauren. I gave her, she had been sleeping in a line for 7 days, and I got her a seat. Like, I don't know about her. I don't know about her. I mean, and if she would have simply sent me an email and been like, "Hey, can we use a clip?" I would have said, "Sure," no matter what it's for. I mean, I'm not trying to silence anybody. If Becky Patty wants to come out and I mean, she wants this to be the right result, and I don't blame her. How could you blame her? I mean, she wants Rick Allen to be the guy. I think in a perfect world, I hope to God that he is the guy, because otherwise we've got a nightmare going on. You know what I'm saying? But like I'm certainly not sweating Becky Patty for getting out there and talking. I think the criticism I've seen of that is that no one's asking any of they're all kind of like softball interviews. But I mean, in defense of people, like that's a hard thing to do. It's not easy. You're not going to go in and start grilling the victims' families. It's just not what you do. It's like tactless. So, I mean, like I get why there's softball interviews, and Becky Patty, like I said, is absolutely, hoping that that's the right result. I mean, she believes that it is. And who am I to say you're wrong? Because I don't know. All I can talk about, and all I've ever talked about, is that the process leading up to trial was jacked. So jacked that I believe that there's a very strong likelihood that he's going to get a new trial, which means that the families are going to have to sit through that shit again. So I'm a very straightforward, genuine guy. Like I like, it's like I feel like maybe I should defend myself more, but I just rely on my content to speak for itself. Like none of those people ever watch my content. They have no idea what I'm saying when they're sitting here saying that, whatever they say. I know they've never watched our content. Nah, I don't strike people. It's whack. I have a long memory because I have courtesy. And like, say, for instance, I wanted to use Josh's clip. He was a little late answering the other day, and I hit him up. I'm like, "Yo, man, you mind if I use a clip?" I knew Josh would be like, "Yeah, absolutely." But still, I have the courtesy of asking him if I can use a clip. I do that with anybody's content. It's not my content to share. I mean, streams from Court TV and Long Crime's a different thing. These are public, so I mean, it is what it is. But yeah, like I can't bring myself to watch the like, and it's mostly because like I've done nothing to deserve any kind of rancor from Lauren at all, ever. I've never been anything but a gentleman and a nice person, and done nice things for her. And I had a long conversation before they decided to start covering Delphi. Like they knew nothing about the case. They knew nothing about what happened. They still know nothing about what happened for 2 years preceding the trial. Lauren just floated in and, took the position that Rick Allen was guilty. And then there you go. It's like you get in with the family. So you could take that for whatever value you want to give it. I do something different here. Lauren and John are not lawyers. They have no idea about the legal process. People that are not attorneys cannot know anything about the legal process. I don't give a shit how many trials you watch. You just don't know how it operates. So that's all I have to say about that. And if somebody wants to say, "Lauren, you should have hit me up and asked me," and I would have said yes, of course. So there's that.
Said the 3 minutes that I was with her, we were trying to see if we could resuscitate her. So that was our primary cause. In my mind, I was running over what could have happened, but our primary focus was to get her back, get a heartbeat and breathing.
So your job wasn't to look into what caused the
No.
incident in question?
We asked the questions to help us figure out what we're dealing with. But in this case, it was very confusing. Nobody really knew. So we focused just on what we could see and took care of that.
So we've referenced your report extensively, which has now been admitted as Exhibit 216. Who do you submit that report to?
I believe it goes to the Iowa Department of Health.
So it doesn't go to any specific agency for inclusion, right?
No, it gets uploaded to the state.
And I believe you've previously referenced the National Emergency Medical Services Information System.
Mhm.
Fair?
Yes,
Is that also called NIMSIS?
yes,
And for NIMSIS, do you know who that goes to?
I do not.
So is it safe to say that you've never in your 25 years checked into where that goes, right?
No, I do know that when our service gets inspected every 3 years by the state, the Iowa Department of Public Health comes out and they do have access to all of those reports, and they have all of our information on when reports were filed and in what a timely manner, and that is checked into them. So I do know that at that point, the Iowa Department of Public Health Emergency Services Agency, who keeps track of the EMS services, they have those reports.
And so those reports don't actually go to anyone other than the state agency designated to receive them, right?
As far as I know.
And in that case, the NIMSIS program is actually administered at the federal level. Fair?
I believe so.
So that data is not being aggregated by, say, the hospital in Delaware County.
I'm speeding this dude
No,
up.
You have never provided the report specifically to a hospital in Delaware County, right?
not that final report. No.
Did you provide any other version of a report to a healthcare provider in this case?
Yes.
And so that would be documented in the medical records or referenced otherwise?
It should be in Manchester's report that they received ours. What we usually do is when we get on scene, we don't pull out our computers and do the final report there. We have handwritten notes and we pull off the top sheet and it goes with the patient. So in this case, when we handed off the patient to Manchester, our top sheet of notes went with Manchester to become part of their report.
And that's because it was Manchester who was in charge of her transport to the hospital.
Because they transported her, yes.
And in charge of handing over care to the hospital emergency room.
Correct.
So that wasn't you in this
We
case.
did not hand her over to the emergency room. No, we did not. We handed her over to Manchester Ambulance Service.
But on scene, you talked to Todd Mullis, correct?
Yes. Well, in passing, he was in the background giving answers. I did not specifically talk to him one-on-one.
You also confirmed some of the details with the deputies, yes?
Yes,
And so in question, you were also known to the Mullis family, weren't you?
I believe so. Somewhat more so Amy and the younger two kids at that point in time.
Because you went to the same church and your families interacted,
Yeah,
right?
yes.
So at that point, Todd Mullis and you were already familiar.
In passing, as an acquaintance.
Ultimately, it's safe to say you can't actually explain the full extent of Amy Mullis's injuries that she sustained that day, right?
No, I cannot.
And you can't describe the extent of the location of where her injuries were seen.
No,
And your report would only document the injuries that would already be noted in her medical records or by other care staff, right?
Objection beyond the scope of this witness's knowledge. There's been no foundation laid that she's ever seen medical records from a hospital related to Ms. Mullis.
Kelly, can you read me the question? I'm sorry.
Your report would only document the injuries that would already be noted in your medical records or by other care staff.
I'm not sure I understand the question.
I'm
Am I
happy to
understanding
rephrase, Your
one?
Honor.
Right, thank you.
You mentioned earlier that the extent of the injuries would have gone to Manchester Ambulance, right?
correct.
And that Manchester Ambulance would have provided that information also to the hospital, correct?
Yes, they should have. Yes, I assume they did.
And that's because they ultimately transferred care to the emergency room, right?
Correct.
So the bruising on Amy Mullis's face or the puncture wounds to her body or any other documented injuries would primarily be noted by her medical records or by that staff. Is that fair?
Possibly.
Because you would have provided or noted the same injuries that were noted by Manchester Ambulance, right?
No,
Yep.
Objection, Your Honor. I think the question is asking this witness to say what Manchester paramedics did or what's in the Manchester reports, which she has not seen or nor did she write. So this is an improper question and ask for speculation.
Sustained.
After you responded for those three and provided those 3 minutes or so of care,
Yeah, I think that the biggest takeaway from the trial was that Amy had cheated on Todd early in the relationship. You know, they had 3 kids. They reconciled, they went to counseling, and he became incredibly jealous and super overbearing. Like just all up in her shit. And, you know, like, so treating her like a kept woman, which is never a good idea. And he then, like, she was stuck on the farm essentially. Like he's like, I don't trust you. You know, it's like you screwing another dude. And so this whole thing goes on for years. And then I think there was somebody that was coming and tending to the hogs that he thought that she was having a relationship with. And there were these, you know, so the state builds the case like that, you know, I mean, in terms of like, there's clearly no actual evidence that he killed her, right? There's no eyewitness. There's nothing that really indicates that he buried this thing into her back. You know, the state had argued that it was not once but twice, which was a big point for them because that obviously nobody's stepping on a corn rake so that it's hitting him in the back twice, right? I mean that's crazy. So you know, like many times you'll see, like I tell you guys all the time, like states and defenses create narratives, theories, their theory of what happened. So obviously they're seeking to get in at trial all of the shit that was going on in the relationship in order to create a motive, even though they don't need to prove it, but it helps. It helps for a jury to understand why. Why would a husband do this to the mother of his children and his wife? So they're getting in the extramarital relationship and the other potential extramarital relationship. They're getting in the fact that there were these statements made by Mullis that, like, I'm not losing my damn farm to her. Like, you know, if I'm his defense team, I'm like going well, first of all, I'm asking, did you ever talk to a divorce lawyer? Like at any point, did you ever talk to a divorce lawyer? Because if you did, that divorce lawyer would have told you that's not marital property. You owned it. It's like a family farm. She has no claim to it. So whether you divorce her or not, she's not getting the farm, because that was the thing that they kept bringing up at the trial. And I got all this from reading the opinion on the direct appeal, which is very short, And I know people have been asking, yeah, I'm going to cover all this. I'm not going to do it in lieu of Karen Reed or Donna Adelson or Brian Walsh. But I want to watch it. Like, I really want to watch this. I think it's fascinating. And I think it's worth our time. And it's just a proceeding that you just don't see. And for those of you that love trial observation and watching the system at work, this is a rare opportunity for us to watch something that we don't get to see very often.
Did you have any other interaction with Amy Mullis?
No,
You did not provide the report to any law enforcement, correct?
no,
And you normally would not
Got you,
provide those
girl.
reports to
Got
law
you.
enforcement,
not
right?
unless asked.
I don't have anything further, Your Honor.
Any redirect?
Very briefly, Your Honor. Ms. Pierce-Bacher, law enforcement knew you were on the scene.
Correct.
You've been a member of the Delaware County community your entire life.
Correct.
Law enforcement spoke with you while you were providing care.
Yes.
Is it a normal protocol and or is it required by the Department of Public Health that you complete and submit a report?
Yes.
Do you have any obligation to send that report out to the law enforcement you interact?
Yeah, well, that's what's going to be at issue here, Pammy. They've had new doctors, and I'll just tell you, Mullis has innocent projects behind him. Now, I don't know if it's the OG IP or if it's an Iowa Innocence Project, as we learned with the Scott Peterson case. There is a difference. You know, the LA Innocence Project, which got involved with Scott Peterson's case, you know, the Innocence Project put out a presser like, hey, that ain't us. You know, which kind of speaks volumes. They were distancing themselves from that. So I'm not sure which Innocence Project it is, but apparently we're going to be hearing some new medical reports coming through that what was presented at trial was not accurate. So, I mean, that's what this is all about. Because I could just tell you, in order to get to where we're at in this proceeding, there are very, very high procedural hurdles that have to be cleared to get to where we're at right now. And they've been cleared. So this is going to be interesting, y'all. I promise. It really is.
interacted with?
No,
And you mentioned that you would have taken the top sheet of your notes and sent them with the patient. When you describe that, are you describing like a carbon copy where you also kept a copy of
Yes.
those notes? And we talked a little bit earlier about you submitted this report, but it included observations and actions of the other two EMTs from Greeley.
yes,
And is that normal protocol for an EMS EMT report?
yes,
And you were asked about your entire interaction with Ms. Mullis only being about 3 minutes. Is that unusual?
no,
You were asked a little bit about the dispatch and the farming records. And I believe you testified, so I just want to clarify that you heard over your pager, over the radio, and dispatch was calling it a tractor, baling, fork type of accident.
yes,
And you and Dave responded from Greeley in part because Manchester was not responding fast enough or could not find the patient. Is that your understanding?
yes. There was confusion on where exactly the patient was located and how long it would take Manchester to reach them.
Ms. Pierce-Parker, you heard us talk a little bit about your affidavit. Is there anything in your affidavit that you feel it is not accurate or reflective of your experience on November 10th?
No,
Objection relevance, Your Honor. This affidavit's already been excluded.
I'm going to make sure those affidavits. The objection's overruled. The answer will remain in the record.
Did you ever talk to anybody from the state medical examiner's office about Amy Mullis's death?
no.
Nothing further, Your Honor.
Any recross?
None needed, Your Honor.
Thank you. You may step down.
Thank you.
Let's go ahead and take a morning recess for about 15 minutes. I'll see you back then.
All right, we got some bloops. Nice. Nice. Bloop, bloop, bloop. 15 minutes. I don't even know the bloop. This is sweet. Look at this. Amazing. Amazing.
Dr. Cruz, you've been called as a witness. Do you swear the testimony you're about to give or get away?
How y'all like that?
Mr. Brown, you look poised maybe to get a witness. Okay.
We are going to call Dr. Cruz, Your Honor. One thing we neglected to do earlier this morning, which we should have done, is to give the court the file of all of our exhibits, Your Honor.
Right, thank you. Good morning, Dr. Cruz. You've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
Go ahead and have a seat, please. Ms. Thompson?
Thank you, Your Honor.
Whenever you're ready.
Good morning, Dr. Cruz.
Good morning.
We have not met. My name is Sarah Thompson. I'm one of the attorneys for Hot
Oh,
Dogs.
yep. I remember hot dog.
Please state your full name for the record.
My name is Kelly Cruz. It's Kelly
Hot dog.
Kruse.
Your, I may be the only person that's having this problem.
Sure. And I can't see.
I'm sorry, there's no light on it. But
If you did the, yeah, perfect. Okay. And Ms. Thompson, your microphone's not on either. There we go. That may help.
Thank you, Your Honor. All right, with that out of the way, Dr. Cruz, you gave testimony in Todd Mullis' trial, criminal trial back in 2019, correct?
Correct.
Get on the
And at
mic.
that trial, you testified about
Get
the
on the mic.
autopsy that you performed on Miss Amy Mullis back in 2018, right?
Correct.
And you prepared a report based on the autopsy that you conducted.
Correct.
In your trial testimony at Todd's criminal trial, you gave your opinions about the cause and the manner of Miss Mullis' death.
Correct.
And at that proceeding, you testified that the manner of her death was a homicide.
Correct.
And you testified that it was your opinion that someone struck her with a CornRake and that killed her.
I testify that she had injuries that would be consistent with those caused by the CornRake.
Was someone striking her with the CornRake and that causing her death?
Correct.
Those are opinions that you maintain today, Dr. Cruz, is that right?
Correct.
And you're not here at these proceedings to offer different opinions than the opinions that you've already given in your prior report and your prior testimony.
Correct.
You reached your opinions about the cause and the manner of Ms. Mullis's death at the autopsy that you performed on November 12th of 2018. Is that right?
Yes.
And you based your conclusions about the cause and the manner of her death on what you learned at that autopsy, right?
Yes.
Is there any disagreement in your mind or any confusion in your mind that Ms. Mullis was found with something called a CornRake that had been impaled in her back and her side?
Thank you.
That's information that has been consistent, so I don't have any reason to not believe that.
And it's also your understanding that after that occurred, that she was rushed to the hospital, right?
Yes.
And that it was her husband, Todd, and her son, Tristan, who took her to the hospital?
That's what I've been told, yes.
And it's your understanding that they got partway down the road to the hospital when they were met by emergency medical services, people who performed resuscitative efforts on Ms. Mullis?
Yes.
And then it's those EMTs that then took Ms. Mullis to the hospital?
Yes.
And she died at the hospital at 1:08 a.m.?
I'd have to check the time.
And sorry, I misspoke. She died at the hospital at 1:08 p.m., correct?
I would still like to check the time, but she died at the hospital.
Well, she died at the hospital.
Correct.
After she passed at the hospital, the medical examiner that was covering Delaware County at that time, Dr. Craig Thompson, he called your office?
Yes.
And he told you that he was sending Ms. Mullis's body to your office for an autopsy?
Judge, I'm going to object. These questions are all leading.
They are. Yes, I appreciate Ms. Thompson moving things along, if that's her intention in using leading questions. But since there's been an objection, if you could rephrase and avoid using the leading questions.
Your Honor, this was the subject of the pretrial motion that the applicant filed, and I do want to be heard on this issue. We filed a pretrial motion about this exact issue. We can take it up at sidebar or with the witness, but we filed a motion about this issue.
Okay. Did you want to take it up in a sidebar or just take it up on the record? Obviously, I assume you're referring to the issue of this witness being taken out of order.
Oh. Yes, I apologize because I truly thought this issue was resolved.
Okay. I guess I'll leave it up to you if you'd prefer to take it up in a sidebar or just on the record now.
I don't think it impacts the content of the witness's testimony, so I'm fine for the witness to remain.
Okay.
The motion that we filed addressed a couple of issues. One, that this witness is an agent of the state, and as such, under the rules, I'm allowed to cross-examine her because she's not a hostile person with respect to the witness, but she's hostile for purposes of the rules. This is also relevant to the burden that Mr. Mullis has to prove at this hearing about what her testimony, what the trial would have been like with additional information, and she would have been a state's witness at trial, and she would have been cross-examined by trial counsel. So a cross-examination is appropriate regardless of who is proffering the witness. We certainly are proffering this witness. But the issue of her being an agent of the state alone makes it appropriate for me to lead her.
Any response, Mr.
Judge, this is a witness they're calling regardless of what her position was at the previous trial. These are leading questions. Developing an issue and asking leading questions in some respect is fine. But we're going to be getting into other details relating to Dr. Cruz's opinion. They're calling her as a witness. I think they should be made to follow the rules of evidence. So that's why we're objecting.
Yeah, this is a different situation. I don't think there's been an issue of establishing Dr. Cruz as a hostile witness in any sense. As far as her being an agent of the state, counsel, if you want to lay some foundation to establish, again, that agency relationship, something that would support or demonstrate a rationale for treating her as a hostile witness, you may do so. But for now, let's proceed as if she's your witness.
I'd like to raise
Interesting.
for this issue, but it was my understanding that this was addressed in our motion and that this had been ruled upon. So I don't want to, this is an important issue for us, and that's why we briefed this issue and cited law and cited the statute, which says that a witness that's identified with an adverse party may be treated as hostile. And again, it's not about, obviously, Dr. Cruz's conduct on the stand, but her identity as the person that she is. I'll ask some questions on this topic, but this is an issue that for Mr. Mullis is important, and that's why we filed the motion that we filed. And we also discussed this at the pretrial conference, Your Honor, which is why, again, I apologize. When we addressed the issue of how the witnesses were going to proceed, it was my understanding this issue had been resolved.
Certainly. And I understand that there was discussion about calling witnesses out of order. And I think there was clarity in that regard. I don't recall a specific discussion about this particular issue. And I certainly could be wrong. Counsel, maybe you want to chime in here.
If I may, Your Honor, certainly Rule 5.611 sub C for leading questions would not permit them normally on direct examination. And we have hotly contested, I believe, as the court knows, whether or not Dr. Cruz is in fact an agent of the state, because the state for this purposes under Iowa's PCR Act is the Attorney General's office and the criminal justice section. Most of the witnesses, if not all of them, would have been in their concept then a hostile witness and would fall under too broad a scope. Certainly Dr. Cruz has been openly answering the questions and trying to be responsive to them. And certainly there should be no reason to believe she's hostile yet. Now, should a finding of hostility be found later on, then maybe this could change, but the court has no reason to grant that right now, as she is not associated or called by us at this point in time. And the court's pretrial ruling was not in reference to this as it related to the pretrial motions. So the state would resist that finding.
Your Honor, our motion on this topic is at B0290.
You say 290?
Is that right? Yeah,
From-
D0290.
From 20. That's the motion to admit deposition testimony, yes?
It addresses other topics as well, which includes being able to lead this witness.
All right. So if you guys are a little, if you don't know, so they're asking to treat Dr. Cruz as an adverse witness, which means that as opposed to direct examining, which does not allow for leading questions. Okay. That's the difference between a direct and a cross. Cross or leading questions. Leading questions allow you to control the witness. You can have them, you really try to keep them limited to yes or no answers. You're not allowing for long narrative answers during cross. It's a completely different examination. So it's their petition. So they're calling her and they want to be able to treat her, not because that's what the the defense counsel was saying. It's not because of her demeanor or that she's acting hostile on the bench or on the witness stand. It's because of the fact that during the trial, she works for the state. You know, I'm assuming she was the forensic examiner. I would consider that to be an agent of the state. So like this guy's making an argument that, well, we're the AG's office. She doesn't work for us. Come on, dude. Come on, dude. That's the shit you're coming at this with, because they want to be able to cross her. So they obviously have litigated that issue. So that's what they're trying to get through right now.
And Your Honor, again, I don't believe that the court ruled on that, and that wasn't pertinent to this at this point in time either.
No, you have to request the judge to treat the witness as hostile or adverse. And then the judge makes a ruling.
Since it is just about noon, I think probably the prudent thing to do is take our lunch recess. We will excuse the witness for now. We'll pick up any additional argument on this issue that we need to over the noon hour, and then pick back up with the witness's testimony once it's been resolved and everybody knows where things stand. Dr. Cruz, you may step down. Let's plan on resuming at 1:15. Council, if you can, well, why don't we take care of this right now? If that works for you?
Yes.
Okay. Ms. Thompson, any additional argument that you would like to make?
Well, two things, Your Honor. One is, Rule 5.611 is very clear that the issue about leading questions is not just about, I mean, we all understand the classic witness who isn't cooperating in the exam, but that's not what Rule 5.611 speaks to. It speaks to and literally says the court should allow leading questions when a party calls a witness identified with an adverse party. And that is also, as we cited in our motion, what Iowa Code 624.1 says, which allows parties to call agents of public corporations and to treat them as, you know, they are a representative of the adverse party. And we can lay some foundation for this, but it's really undisputed that this witness is an employee of the state of Iowa. There is evidence in the record that she was being advised by Scott Brown as to her conduct in the pre-trial litigation of this post-conviction matter, taking advice and direction from the Attorney General's office about how to respond to the issues in this case. There's no question that she's identified with an adverse party. And so it's not about whether she responds to the questions in an appropriate way. It's simply that she is a person who is associated with an adverse party by the plain text of the rule and by the statute. And that is why we are allowed to cross her, Your Honor.
There's just one more thing on this, and then I'll be done, if I may.
Go ahead.
So I'm well aware of the rule that is cited by counsel. But just because she is a state of Iowa employee or that she may have been called as a witness by the state does not substantiate the claim that she is somehow identified with us. The medical examiner goes to great lengths to remain neutral in their opinions. She is not employed by the Attorney General's office. They are completely separate. I would go back a little bit of a history lesson in that the ME's office used to be part of the Department of Public Safety, and they were moved out of the Department of Public Safety into to Health and Human Services, formerly the Department of Public Health, for that reason, so that they can maintain.
Bullshit. Everything that this guy just said is bullshit. Here's the thing with MEs. At the time of an initial autopsy with a medical examiner in a case where it is thought to have been foul play, there is a fucking cop or multiple cops or detective sitting in that examination, feeding information to the medical examiner in terms of what they observed at the crime scene, what they think happened, all that stuff. She is definitely an adverse witness without question. The judge should absolutely rule that they should be able to treat her as adverse. All it means is she gets to ask leading questions. That's all it means. The woman doth protest too much with this guy, and he's making a shit argument on top of it. Do better, dude.
Maintain their neutrality. She gave an opinion that we utilized at trial. They don't like it, and that's fine. But that does not mean that this rule has been, that the terms of this rule would allow them to ask the leading questions in the manner that counsel is claiming she can ask leading questions.
May I make one more point of record, Your Honor?
Go ahead.
I mean, the offer of proof that we'll make, which we can elicit from this witness on the stand, is that shortly before Mr. Mullis filed his post-conviction pleading in this case.
You guys are going to be so excited. I just checked. I saw Kai say that we're basically caught up. We are actually, when we're done with this argument, we have enough to bloop our way right till they're back in action. How you like them apples?
My colleague, Ms. Neshawat, wrote a letter to the medical examiner's office directed to this witness, giving this witness information about new material in this case and asking to speak with this witness. And the records that we have reflect that this witness consulted with the Attorney General's office, consulted actually with counsel to my left, and from that conversation determined that it would be inappropriate to speak with Mr. Mullis's counsel, and so she did not. And that reflects that she is taking legal advice or direction in this case from literally the attorney sitting to my left. She did not communicate with us. She is not a neutral party in this litigation. And she remains an employee of the state of Iowa whose office is in the same building as the Department of Public Safety, who is an employee of the state of Iowa, whose work in this case was in the context as an employee of the state of Iowa.
State agent.
So that's exactly what this rule talks about.
Come on, Judge. Show your chops right here.
And the last thing I'll say about this, Your Honor, is were she not a person who could take legal advice and direction from Mr. Brown, and I do not say this to impugn Mr. Brown at all, it's inappropriate for an attorney in litigation under the rules of professional responsibility to advise a neutral witness not to speak with the party. That is one of the core rules of our profession, is that I cannot tell a witness, don't talk to the other side.
100%.
The only way that it would be even appropriate for an attorney to do that is if that person can give that person legal advice because they are associated. And I certainly don't accuse Mr. Brown of having done anything improper. But the reason it was not improper for him to tell this witness not to speak to us is because they had a legal relationship. And so she's clearly identified with that party. If she wasn't, then there would be another issue that we'd be raising here in terms of professional responsibility, and we're not.
It's a good lawyer. It's a good lawyer.
At this time, the state is not planning on calling her as a witness. Is that correct?
Your Honor, Dr. Cruz is listed as the state's expert witness and would be handled at the same time. To my knowledge, that would go to the court's pretrial ruling as it relates to the breadth of the testimony. I guess on the point of the breadth of this objection is, one, citing the rules of professional conduct in this aspect would seek to wrongly impugn an attorney's testimony here or an attorney's questioning here. There hasn't been, I believe, proof provided in this case, and perhaps I'd love to see it, that would suggest that there was some sort of impropriety. But beyond that, the deposition testimony that they sought to admit into.
Hey, comb over. She just said she wasn't impugning or suggesting that there was anything untoward that happened. She's a state agent. She is a state agent, period. The judge, I hope she makes the right ruling here.
To the record already and sought stipulation too, for instance, regarding Dr. Cruz.
But I'm a prosecutor. We never lie. We're always truthful. How dare they?
Like, dude, no, shut up. Let's go.
They were, Mr. Mullis' counsel was completely comfortable asking open-ended questions there, and this sort of accusation would predate that. Again, we have extensively included in motions and resistances what the state means as a party here in this case. And this is just wasting the efforts. They certainly could ask about that in an open fashioned way. Before this case proceeded, were you contacted by Mr. Mullis' counsel with new evidence? That can all speak to what Dr. Cruz did, but it certainly isn't shaping the lead purpose or why leading questions should be permitted here. And that is just too broad and too improper, Your Honor.
Obviously, this isn't as black and white as it normally is because this is a PCR. And there's already been the underlying criminal trial where some of these people have already testified as witnesses for the state. It's also not as black and white as it normally is because some of these people are employees of the state, albeit in different offices. And some of them have no other place to turn for questions than the AG's office.
Well, they get independent counsel.
Looking not just at Dr. Cruz, but at the list of names that are included in the motion that was filed on February 3rd. Obviously, I assume there are some different arguments for some of these other people, but specifically with regard to Dr. Cruz, the responsibilities of state medical examiner are dictated and directed by statute and rule. They're not controlled by or directed by the Office of the Attorney General. In the absence of some foundation or finding that the state in this matter was directing Dr. Cruz's investigation or autopsy, I don't think she falls under this rule.
Oh, come on, dude.
So I'm not going to allow leading at this point. And I think generally speaking, it's probably going to be the same with regard to the rest of these individuals.
The defense counsel needs to look at the autopsy report and the corresponding police reports to see who was in attendance at the time of the autopsy. That's going to be the best proof they have. It's going to be the best proof they have. I'm just telling you, as a defense attorney, I read all the police reports. They are always in there for autopsies. They are always asking questions. They always want to hear the observations. It's a very instructive thing for the cops, and they certainly use it to plant seeds. So that's what I'd be doing if I was defense counsel.
I am assuming that similarly, there probably has been communication between these individuals and counsel at various points, but they are from different agencies. And you're free, obviously, to make whatever arguments you need to individually, whatever record you wish, either now or when we get there, but that's where things stand for now.
I understand the court's ruling. I think, and again, we truly believed, and I say this only because I apologize for this coming up now, because it was truly the belief of every attorney for Mr. Mullis that this had been resolved at the pretrial conference, and that the reason we were agreeing to call her today was because we were going to be able to call her in our case and leave her. I understand the court's ruling. Respectfully, we disagree, but that's why we called her now. And I do think we need to confer briefly about what this means for us, because the appropriate examination for her, in our view, is this one. And if this isn't the examination the court is going to allow us to have, I think we need to decide whether we're going to have the state caller. So we need to make a determination about that, Your Honor.
Okay, certainly. And we can, as I said, we'll take our lunch break at this time and plan on resuming at 1:15. And I'll be in chambers, so if there's anything that we need to talk about with regard to the schedule, you know where to find me.
Thank you, Your Honor.
Okay.
Your Honor, there's only one more issue that might be helpful
Sure.
to address while there's no witness on the stand. So just this morning, we were given a demonstrative exhibits for a witness that was initially identified earlier this morning that Mr. Mullis's counsel intended to call. These are demonstratives that were, to my knowledge, never provided to the state. 11 months ago, I believe the state did discovery requests, as the court knows, specifically requesting copies of any demonstrative aids intended to be used by Mr. Mullis's counsel or any of their witnesses. We received those exhibits, or demonstratives rather, at 9:42 a.m. today. It was never produced in discovery, and I know Mr. Mullis replied, because I inquired while trial was ongoing, whether these demonstratives were provided in discovery, and the response was that they got them this morning from the witness. However, given the late disclosure of these demonstratives, I believe that it is improper, especially considering this was a subject of months of discovery in this case and has resulted in numerous other motions related to the destruction or disappearance or what have you of other demonstrative aids. So I think it is unfairness to the state to have additional new demonstratives, including highly technical mathematical calculations in them, and we can show them to the court if that would aid in your ruling. But I believe any demonstratives that had not been produced in discovery prior to the start of trial would be improper and unfair. Thank you.
Did these demonstratives go with?
I believe it's with Dr. Hammers is the only one that we've been provided thus far.
Can I respond, Your Honor?
You may.
All right, what counsel's talking about are two photographs. The photographs are photos of Ms. Mullis from autopsy, and they have some measurements on them that are pre-marked. Those measurements come directly from Dr. Cruz's notes. They're on Exhibit 380, page 3. They're her measurements. This isn't something that is calculations. It's numbers. There's numbers written on a document that that we intend to use with a witness. It's they're literally transposed from Dr. Cruz's notes. While a party is entitled to, make whatever interrogatory and this document request they want in discovery, a party can't change the court's deadlines for providing materials by, asking for discovery that would require a party to anticipate, months and months, in this case, months and months and months before trial, every piece of paper they're going to show a witness at trial. There's not any new information here.
Demonstrative evidence, Malo, is, say, for instance, a chart, a graph, a video, a blown up photograph, anything that you're using to demonstrate or show something to the jury is typically considered demonstrative evidence.
It's literally a photo with numbers from Dr. Cruz pre-written on it. That's what it is. It's not a surprise. The idea of this being related to document destruction is, at that point doesn't make any sense. That's what this is. It's a photo with numbers from Dr. Cruz written on it. And we can lay the foundation for those numbers with Dr. Cruz.
And briefly, Your Honor, just to wrap this up, certainly I wasn't implying any document destruction was related to this. However, in reference to the counsel invoked the court's pretrial deadlines on giving exhibits, just this last Saturday afternoon, a day and a half before trial, we received a new exhibit that was never exchanged and never produced in discovery. And when I requested counsel specifically provide the day and time that it had been produced in discovery, no answer was given. So we would ask that the court put an end to the continuing production of new material and exclude evidence and materials that were not provided prior to the court's pre-trial deadline, which was 21 days before trial.
If somebody could please provide me with a copy of the demonstratives so I could take a look at it quickly over lunch, I will do so and let you know what we'll do with that. I'll see you back here at 1:15. Court's in recess until then.
Your Honor.
Look at that, kids. Look at that. So now we're going to find out whether or not they're going to continue their direct examination of her, or they're going to allow the state to call her. Now, if I'm the state, I'm thinking about not putting her on, but I mean, they really need to, because they have to be able to get out what her opinion in terms of cause of death and, what caused the injuries. In her opinion, they need her opinion that she gave at trial. So, I mean, which ultimately means that the defense would be able to cross her then anyway. So, the question then becomes, does the state somehow find a way to avoid putting her on altogether if they decide to pull her from the stand and then just cross her when the state calls her? So let's see what goes on.
All right, if we're ready to go back on the record, we'll maybe pick back up with the last thing that we discussed, which was the issue of the demonstrative exhibits. I did receive those from Ms. Nichols-Cook. And counsel, if you could just clarify for me, there are 3 photos, it looks like, and they have measurements on them. The measurements came from where?
Exhibit 380, page 3. These are measurements. Oops. All right, it's exhibit 380, page 4. These are measurements that were noted at autopsy by Dr. Cruz.
Good, if I can. We've had a chance over lunch to verify that. We don't have any objection to those 3 exhibits.
Okay.
All
right.
This is awesome. There's a whole full-blown post-sanction.
Are we picking back up then with Dr. Cruz's testimony or switching gears?
We're picking back up, Your Honor. Given what was originally indicated to us as for limited availability, we wanted to accommodate her today by having her called out of order, and we want to move this case forward. So, our views about the court's ruling, we respect it, and we'll proceed. I do have one thing to note, which I'll be brief, but I just think this will help head off objections potentially, to just explain one issue for the court before we continue, which is just that the court's ruling was that Dr. Cruz would be limited to the opinions that had been disclosed, meaning, in our view, opinions that she held as of her 2023 deposition. I don't want to open the door to invite, whether she has other opinions that she's developed later, I don't want to invite those. So some of the questions I'm going to ask her are going to be framed in that way, as of your 2023 deposition, so that I'm not opening the door. And I don't want that to be a beginning of a question that prompts objections or some concern about why I'm cabining it. That's the purpose, Your Honor.
Understood, and I would consider that simply to be directing the witness maybe to a specific area rather than hopefully a leading that would be objectionable. And certainly now the council has an understanding that may be coming. We should all be on the same page. So if Dr. Cruz is available, great, thank you.
She was not. She was not. She would not allow them to treat her as adverse.
Welcome back, Dr. Cruz. Go ahead and have a seat, and I would just remind you that you remain under oath. Ms. Thompson.
Thank you, Your Honor. Dr. Cruz, before we broke for lunch, I think you had told us that you made a determination at the time of the autopsy that the manner of Ms. Mullis's death was homicide, and that's where I want to pick us back up. What are the possible manner of death findings that a forensic pathologist can make?
There are 5 options in terms of manner of death. The most common option is natural. So that's death due purely to natural disease. There's suicide, death at the hands of oneself. There's accident, death due to a hostile environment or unforeseen circumstances. There's homicide, death at the hands of another, and undetermined, which is used when you have all the information available and cannot choose one of the other manners, or you have compelling information for 2 competing manners.
And for a forensic pathologist to make a manner of death finding that a death is a homicide, what is the level of proof that a forensic pathologist needs to have?
There's no exact determination. It uses our medical judgment. I set a very high standard for myself, and often in court, it's termed as to a reasonable degree of medical certainty.
Well, isn't there a standard that to make a finding that a death is a homicide, that a forensic pathologist needs to have clear and convincing evidence that that death is a homicide?
I would put that with a reasonable degree of medical certainty. Clear and convincing evidence is vague. It's really up to the pathologist.
To make that finding, well, let me ask you this. Do you disagree that the appropriate standard is clear and convincing evidence?
I find it to be vague, but if that's what other people are comfortable with, I don't have huge issues with it.
Is that the standard in your profession, clear and convincing evidence?
By whom?
By what the generally accepted practices are in forensic pathology.
I need more information on who's making that general principle.
Is there any general acceptance in the field of forensic pathology about what the level of proof a forensic pathologist needs to have to find that a death was a homicide?
The National Association of Medical Examiners gives guidelines for manners of death. Manner of death can be complicated, and different circumstances require different determinations. So clear and convincing evidence, I would really need more information as to what that means to you or another person in a certain scenario.
And I understand, but my question is Dr. Cruz, not what you understand, but what the generally accepted practices in forensic pathology?
I guess I'm not an expert in terms of who you think everyone is in terms of generally accepted practices.
So that's not a question you're able to answer.
I see what you're getting at, but I've seen that term in the same way I've seen reasonable degree of medical certainty. Sure, I do agree, but I haven't polled every medical examiner to see if that's generally accepted by everybody.
So am I right then that you don't know what the generally accepted standard is in your field for making a determination of homicide?
I would argue that no one knows what everybody thinks within my field.
And you understand that I'm not asking you what everyone thinks. I'm asking you what's generally accepted.
Well, I would have to see where that came from for you to tell me that. I've seen that many, many times, generally accepted practices or in terms of how much evidence you need, how much medical certainty you need. So sure, I'll agree with you.
All right, thanks, Dr. Cruz. Was there any evidence at the time of autopsy that Ms. Mullis died by suicide?
No.
Was there any evidence that her death was a natural death?
No.
Am I right that that left you 3 options for manners of death then?
Yes.
And that left you with it being undetermined, an accident, or homicide?
I suppose.
Well, did you have some other possible finding that was available to you besides those 3 once you'd ruled out natural and suicide?
I think it suggests that I considered accident, which was not the manner of death.
Mike, and I appreciate that, but once you had decided it wasn't a suicide and it wasn't natural, we have 3 other possible options left, understanding you picked one of the 3.
Correct, but I'd like to be sure that that doesn't indicate that was my natural order of thought.
Well, understood, and I think that's what we're talking about here today. At the time of autopsy, what was your understanding of the number of times that the CornRake that was at issue in this case had?
It had 4.
And at the time of autopsy, how many penetrating injuries did you determine that Ms. Mullis had in her back?
6.
Did you focus your autopsy analysis ultimately on the cause of those 6 penetrating injuries in her back?
Could you restate that? I'm sorry.
Sure. I mean, was it your determination at autopsy that that the area where those 6 penetrating injuries were in her back, that those injuries were the cause of her death?
Yes, those injuries were the cause of her death.
So that's the area of her body you were focused on ultimately in making your determination about what the cause and manner of her death were?
Sure.
I want to and I think you said this to us a second ago, that that at the time of your 2023 deposition in this case, and let me ask you first if you recall being deposed in 2023.
Yes.
At the time of your 2023 deposition in this case, what was your understanding of why Ms. Mullis's death could not have been an accident?
Could you define what I mean, my understanding, or how I came to that determination?
Well, let me ask you this. At the time of your deposition in 2023, why did you determine that Ms. Mullis's death could not have been an accident?
My determination of why it wasn't an accident goes back to 2018 and has remained the same throughout. So I can explain that determination if you'd like.
Please do.
So an accident, as it was initially suggested, would say that Ms. Mullis fell on the CornRake. There hasn't been, as far as I know, any argument to the contrary in terms of the CornRake causing her injuries. I conceded at the deposition, and I believe it to be reasonable, that a person could potentially fall on a sharp object such as the CornRake once. To think, as a medical doctor, that someone could fall on something backwards, be impaled entirely through their torso, pull that object out through the back of them, then fall on it again, pull it out, and potentially fall on it a third time, which I think seems reasonable, is way outside any degree of medical certainty. There are a number of different injuries that could potentially support a fall, such as blunt force injuries to the posterior surfaces of Ms. Mullis's body, say to the back of her head, her shoulders, her hips, her buttocks, even to her elbows, things that I would see in someone who has fallen, as I have seen many deaths due to falls. None of them were there. So it's lack of supporting evidence for an accident, and also the thought that she could fall on the rake, pull it out, fall on it again, is entirely impossible from a medical standpoint. I also did reason in her additional injuries. She had a number of additional injuries to the anterior surfaces of her body. So to suggest that she fell backward, then somehow sustained injuries to the front surfaces of her bodies, then maybe falling forward, is entirely impossible.
Well, the most compelling finding for you that led you to conclude that this was not an accident was that, and I say this with respect to Ms. Mullis, but I don't really know another way to say it, that there were more holes in her back than there were tines in the rake. Isn't it true that that was the most compelling finding for you that led you to conclude that it was not an accident?
Yes.
And from the testimony you just provided, at the time that you determined that this was a homicide back at the autopsy in 2018, could you envision any way that Ms. Mullis could have fallen on this rake more than once and caused her injuries?
No.
How long did your autopsy of Ms. Mullis take?
I don't recall entirely. I know I had stated in my prior depositions and testimonies about 3 hours.
That is a pretty standard time for you in terms of how long an autopsy would take?
I perform more than one autopsy at a time, so it really depends on the type of cases I have that day. It simply depends.
When you say that you're doing more than one autopsy at once, you have more than one body in the autopsy suite that you're looking at the same time. Is that what you mean by that?
Yes.
In your prior testimony in this case, did you say that your autopsy of Ms. Mullis took between 2 and 3 hours?
I'd have to go back and look, but I think that's a reasonable statement.
Well, if I represented to you that that was your prior testimony, do you have any reason to think that's wrong?
No.
And you said that you do more than one autopsy. Let me start that question again. Back in 2018, you said that you would do more than one autopsy at a time.
Yes.
Does that mean that during the 2 to 3 hours that you would have been looking at Ms. Mullis's body, that you weren't spending that entire time looking at her body?
No, I wouldn't be standing there the entire time.
And that's because you'd be looking, is that because you'd be looking at more than one body over that time period?
It would be a mixture of me looking at other bodies, and I have an autopsy technician who assists me with the autopsy process. There are components to the autopsy that they do alone, and I don't need to be there.
In that process where you are looking at more than one body at once, is your attention divided between different cases and different bodies?
Yes.
Do you know how many different bodies you were looking at during the 2 to 3 hours that you did the autopsy for Ms. Mullis?
I do not recall, no.
Was it more than 4?
No.
Was it more than 3?
It should not have been more than 3 at that period of time. We did no more than 3 in one day.
I do want to talk to you about the information that you had at autopsy. At the time that you conducted the autopsy of Ms. Mullis back in 2018, the time at which, as you testified, you determined that her cause of death was, or that the manner of her death was a homicide. Did you have a short conversation with Dr. Craig Thompson before you conducted that autopsy?
I did.
And Dr. Craig Thompson was a medical doctor, is that correct?
Yes.
Was he a forensic pathologist?
No.
Was he someone who had your same level of qualifications to evaluate injuries?
You'd have to ask Dr. Thompson. I'm actually not quite too sure what type of a doctor he is.
But you understood, at the time you talked to Dr. Thompson, you knew that he was, what did you know that he was not a forensic pathologist?
Yes.
And
Bob, you're muted. Bob, you're muted.
Thank you.
Bob.
So thank you. So here's my thing. So there were 4 tines on this CornRake. She had 6 puncture wounds. That's why this doctor opined that in order for her to have fallen on that CornRake, she would have had to have fallen twice. Apparently, these puncture wounds were so deep that it penetrated through her back enough to rupture her breast implant and exit her front side. So it's almost a through and through, as well as puncture her lung and liver. Wow. So that's why she ended up ruling it as a homicide. So ultimately, what we're going to end up seeing here is a doctor who has a very different opinion as to what happened. But let me ask you this. Like, so if it's not the CornRake that caused these puncture wounds, what could it have been? I mean, it sounds like there was not much time for him to be able to dispose of a weapon, and that it sounds like 1 minute and 40 seconds is what passed by the time he yelled up. And I think he told his son to bring the truck back. And I can't see a world in which, if it's Todd swinging the rake with such force, I'm curious to know if the puncture wounds went in like this or if they went in like this. If you're swinging the rake, they'd have to go in like this. They couldn't go in like this. So this is interesting. You can see why they wanted to cross her. I mean, they're challenging her on how she reached her medical opinion. All right, let's keep going.
do you, at the time that you talked to Dr. Thompson, did you consider that you, as a forensic pathologist, had more expertise in determining the cause and manner of death than a person who was not a forensic pathologist?
All right,
Yes.
that helps explain it. So it's like a pitchfork.
At the time you talked to Dr. Thompson, did he tell you whether he had any concerns about the circumstances of Miss Mullis's death?
He told me, as I recall, that he had concerns about her injuries being non-accidental in nature.
And were those concerns that you, as a forensic pathologist, took with a grain of salt, since he was not a forensic pathologist?
I accepted them. I wasn't dismissive, I think, which is what that suggests. I heard them and said, I will see what I see at autopsy.
When you went, is it true then that when you went into the autopsy, for Ms. Mullis that you had already received information that there was someone who had concerns about her death?
As we established, Dr. Thompson told me he had concerns.
So is it true then that you started with the thought in your mind that there was something concerning about Ms. Mullis's death?
I had heard that someone else had concerns, yes, but I had not seen her yet.
Well, it was your testimony that you weren't dismissive of that. Is that right?
Correct.
So you were considering that?
Right. I didn't hear it and then forget it. I remembered it and did the autopsy.
Did you hear any information before you went to conduct the autopsy that Ms. Mullis's death was an accident?
Yes.
And where did you hear that from?
That came from Dr. Thompson, who said that, I believe, as I recall, he was told that she fell on it, but he had concerns about her injuries. We also received intake phone calls, and to the best of my recollection, that was part of our intake phone call, that she may have fallen on the rake.
That was was it Dr. Thompson who was reporting that to you?
Most likely.
And what you heard from, is it true that what you heard from Dr. Thompson was that he was concerned that it was reported that she fell, but he was seeing injuries that he found concerning in that context?
He thought her injuries seemed inconsistent with a fall.
After talking with Dr. Thompson, well, let me ask you this. Did you take any other information about Ms. Mullis's death into your autopsy other than your conversation with Dr. Thompson?
Their law enforcement attended the autopsy. I can't remember exactly what information I was provided, but I'm open to really any information. Before I perform my autopsy, I consider myself unbiased regardless of what I hear.
As to what you just said about considering yourself to be unbiased, do you consider at the time you start an autopsy that information that you hear could give you implicit bias?
Could you be more specific?
Well, have you ever heard the term implicit bias before?
I have, and actually only in legal settings. And each time I say, can you be more specific and tell me what you mean by it?
Do you have an understanding of what that term means to you?
I think I do, but I actually worry maybe it is incorrect. So you could tell me, that would be great.
Well, I'm not allowed to answer questions from you. I'm sorry. I'm asking you questions. So I'm asking you what your understanding of the term implicit bias is.
I suppose I don't have a strong understanding of it.
Okay. Do you, well, let me come back to that. I want to ask you this. You said that you were open to hearing, and I don't want to misstate your testimony, is it your testimony that you were open to hearing information about a case before you began an autopsy? I just want to make sure I understood your testimony about that. So I apologize if I misstated it.
I'm sorry, what was the question?
Sure. I want to make sure I didn't misstate your prior testimony. Was it your testimony that you were open to hearing additional information related to an autopsy that you conducted?
Yes.
And why were you open to hearing additional information related to an autopsy that you conducted?
Investigative information can be helpful. I do not perform an autopsy in a vacuum.
To anyone that watched this trial, and I think that Jay and I watched a very, very small part of it, can anybody confirm exactly what this corn rake looked like? Like, if it looks like a pitchfork, how is she falling on top of it and impaling herself? Because like a pitchfork is a flat instrument. I was thinking it was more like one of those garden rakes that, has like a 90-degreer, so you've got one piece of metal and then you've got the tines that stick up. Like how? Oh, good, Mavhawk. The points are at a right angle. Thank you. Like a rake, not a pitchfork. There are pictures. Okay, so that's a different thing. We need to be clear on what this thing looked like. Because like a giant fork doesn't make any sense for her to fall on top of it. Somebody email me a picture of what it looks like. Bob at Defense Diaries.
And I think I possess the capabilities to take each bit of information individually and use it if it's appropriate.
When you began Ms. Mullis's autopsy, the information you had about her death came from your short phone call with Dr. Craig Thompson. Is that right?
Most of the information I had was from Dr. Thompson. He's the investigating medical examiner.
And you said most of the information. At the time that you started the autopsy, What information did you have about Ms. Mullis's death that did not come from Dr. Craig Thompson?
Oh, shit.
Travis Hemosath was there. I don't remember if he provided any extra information. Essentially the information is Ms. Mullis was purported to have fallen.
Okay, so that supports the theory that he could, unless, depending on the directionality of the puncture wounds, if they were like this, there's no way Todd Mullis is swinging it like a bat, like with the force that it would take to puncture it all the way through her back to where it's puncturing her breast implant, and at least one of the tines is coming out through the front of her. That would be like this. It wouldn't be like this. This is fascinating.
On the CornRake, and then Dr. Thompson said that he was concerned that her injuries did not match a fall on a CornRake.
Did you talk with Deputy Hemosath before you began Ms. Mullis's autopsy?
Yes.
How long did you talk to him for before you began the autopsy?
I do not recall.
Wow. Oh, man.
Did you have information from any other source
funny.
before you began the
Super funny.
autopsy, other than your conversation with Dr. Thompson and your conversation with Deputy Hemosath?
Not that I can recall at this time.
Now, you mentioned earlier that Deputy Hemosath was in the autopsy of Ms. Mullis with you.
Yes.
Was anyone else in the autopsy with you besides your assistant and Deputy Hemosath and you?
I don't recall. Sometimes I can have law enforcement on multiple cases. I can't say confidently whether or not other people were in the room. There are multiple autopsy technicians as well when I'm doing multiple cases, but no one else relating to the case.
Well, and you said that you have more than one autopsy going.
So Mandy sent me this, which is, that's the puncture wounds. Like, I don't even see how that's consistent with that particular instrument. You guys see that? I don't know. He's swinging it overhead. And then when she's down, well, how does she get down in the kneeling position? See, I thought, I mean, there was some part of his story that he pulled the rake out of her back. So it said that, this is what it said in the appeal, in the opinion. Mullis went into the red shed and found Amy on her hands and knees, face down with the corn rake sticking out of her back. TM yelled for Todd. Oh, TM is the son. Amy was unresponsive. TM checked whether Amy had a pulse or was breathing. Todd ran over and told TM to get the truck and bring it over. Todd did not render aid or call 911 while he waited for TM. When TM brought the truck over, he saw Todd pull the corn rake out of Amy's back. Okay, so, I mean, the corn rake was in there. TM got in the passenger side of the truck. Todd put Amy on TM's lap and they set off. No wonder TM's so traumatized. Jesus. All right.
Going on at a time, is it possible that while you were conducting Ms. Mullis's autopsy, that there were actually other law enforcement officers not even related to this investigation that were also there for the autopsy while you were doing this one?
They would be there for a different autopsy and not involved in Ms. Mullis's autopsy.
Well, they're standing in that situation. Are they standing in the same room with you?
They're standing in the same
Well, I get
autopsy
why you
suite
pulled it
potentially.
out.
We
Yeah,
have
you
different
can.
areas for people to stand, different
pull it out.
stations for the autopsy. They're separated in that manner. They could also be looking through a window. I simply don't remember. But I do remember that the only person I spoke to from a law enforcement standpoint during the autopsy was Travis Hemosath.
Is it true that you have a clear memory as you sit here today of only speaking to Deputy Hemosath during this deposition and no one else?
Yeah, for sure. I mean, you're worrying about the bleed out. Typically you want to keep it in there, but I mean, in order to transport, yeah.
During this autopsy and no one else?
During the autopsy itself.
Yes.
Other people would be within my office, potentially. We have an investigator on the case, the autopsy technician. I don't recall speaking to anyone else about Ms. Mullis during the autopsy, no.
And the autopsy suite that you're describing, is it an open room with more than one table in it for where the bodies sit for the autopsy?
It's fairly open, yes, and there are multiple tables.
How far apart are the tables?
I don't know.
Are they further apart than 3 feet?
Yes.
Are they further apart than 10 feet?
I'm not entirely sure. You'd have to ask somebody with a tape measure to go and measure them.
Was Deputy Hemasath standing near Ms. Mullis's, where Ms. Mullis's body was during the autopsy?
As far as I recall, yes.
Is it correct that he wasn't looking through glass?
Correct.
To make sure that I understand the order of what occurred, am I correct that you had information from Dr. Thompson? You spoke briefly with Deputy Hemasath before this autopsy. You talked with Deputy Hemasath during this autopsy. And then at the conclusion of this autopsy, you made your findings.
Yes.
There is no requirement that let me ask you the question this way. Is there any requirement that at the conclusion of an autopsy, you as a forensic pathologist have to make your cause and manner of death determination right then?
Not that I'm aware of, no.
It's true that there's absolutely no requirement that occur. Is that right?
Not that I'm aware of.
And it's your testimony that you are open to more information related to a case. Is that right?
Always.
In this particular case, did you seek any other information between the end of the autopsy and when you made your finding at the conclusion of the autopsy that the cause and manner of Ms. Mullis's death was homicide?
So in between when the autopsy was complete and when I said it was homicide?
That's right.
Clear? I did not. Is there an example of what I could have done? I finished the autopsy and I said it was homicide.
And you asked about examples. That is what I want to ask you about. I mean, given that you are open to, well, I want to get to the issue that you just raised, but I want to go back to one thing for just a moment. Do law enforcement officers come to every autopsy that you perform as a forensic pathologist?
No.
Did you draw any significance from the fact that Deputy Hemasath was at this one?
No.
How long of a drive is it from where Deputy Hemasath worked as a law enforcement officer to where you did this autopsy?
I don't know.
Was it your understanding that Deputy Hemasath was a law enforcement officer in the community that we're in today?
Yes.
How long of a drive is it from here to where you did this autopsy?
I believe it's about 3 hours.
Is it your testimony that you drew no conclusions from the fact that Deputy Hemasath drove 3 hours to be at this autopsy with you?
No, we have many people visit. Some just come for educational purposes. I encourage it. I think it's important for people who deal with death understand what an autopsy is like.
When you talked with Dr. Hemasath or Deputy Hemasath at this autopsy, Dr. Cruz, did he tell you that he was there for educational purposes?
Not that I recall.
I mean, did he tell you he was there to investigate Ms. Mullis's death?
He did.
It was not your understanding at the time of this autopsy he was there to educate himself about your process?
Well, he may have expressed it and I didn't remember. I'm just saying people drive a long ways to see an autopsy pretty regularly.
Had you ever had Deputy Hemasath at an autopsy with you before this one?
Not that I recall.
During this autopsy, did Deputy Hemasath tell you his understanding of how Ms. Mullis had been found in terms of the position that she was found with the corn rake in her that led to her getting medical treatment in this case?
Yes.
What did he tell you during the autopsy about that issue, the position of the rake in her body?
I was told that she was essentially face down and the rake was sticking out of her back. I believe at that time, I've been told subsequently that 2 tines were said to have been inside her body and 2 tines were outside of her body when she was found.
During the autopsy, did Deputy Hemasath tell you that Ms. Mullis had been found with the corn rake in her back with the handle of the corn rake facing toward her head?
That does sound familiar. I'd have to go back and look. That's how I envision it when I think back.
And to make sure we're talking about the same thing, we understand that she wasn't found in a sitting up position, but I'm not going to get down on the ground for this purpose. But understanding that I'm sitting here today, I'm not in the position that Deputy Hemasath said she'd been found in. Where would the handle of the corn rake have been relative to my body from your understanding of what Deputy Hemasath was describing?
the way you had just described it, I would envision the rake handle poking up toward the head.
Am I correct that given what Deputy Hemesath was describing to you, he was describing the CornRake handle extending from her back up over her head?
Yes.
And we agree that she wasn't in an upright position, but just to make sure we're talking about the same thing.
Yes.
We're talking about the CornRake coming up this way, correct?
Yes.
All right. As you sit here, well, let me ask you this. At the time of your deposition in 2023, was that your understanding of how she had been found?
Yes.
Was that your understanding at the time of your autopsy?
Yes.
As of the time of your deposition in 2023, had anyone ever told you that that was not how she was found?
Not that I recall.
Did you base your opinions in this case on an understanding that at the time that Ms. Mullis was found, the handle of the CornRake was extending up over her head?
No.
And when you say no, can you explain to me what you mean by that?
How someone said they found the rake, the position of the handle, the position of her body, the rake was removed from her body. If I saw the CornRake like that, then maybe I could take it into consideration, but a simple description such as that had no bearing on my determination and was unnecessary to make the determination of homicide.
Why was it unnecessary for your ability to determine whether this was a homicide to try to determine what position the rake was in at the time Ms. Mullis was found?
Ms. Mullis was impaled with the CornRake, and how the CornRake ended up in her doesn't really change the fact that it's homicide.
And I want to make sure that I've asked my question in a clear way. And I'm going to ask with the court's permission, because I don't remember exactly how I worded it. Is it possible for the court reporter to read the question back, Your Honor?
It is.
Thank you.
Why was it unnecessary for your ability to determine whether this was a homicide, to determine what? To try to determine what position the rake was in at the time Ms. Mullis was found?
Was that your understanding of my question when you gave the answer you just gave?
Yes.
Am I correct that it was not important to you to understand the position that the CornRake was in at the time Ms. Mullis was found?
I would need more information to consider it, such as what injuries were associated with that CornRake in the position in which it were found, if you follow.
Well, at the time of your autopsy, what you were doing was looking at her injuries and trying to understand what those injuries were. Is that correct?
Well, I could tell what her injuries were.
Was the purpose of your autopsy to assess what her injuries were?
Yes.
And so when you say that you would need more information, would it have assisted your analysis of whether or not Ms. Mullis, the manner of Ms. Mullis's death was a homicide, to understand the position that the rake was in relative to her body when she was found with the rake in her?
No.
We've been talking about your conversation with Deputy Hemesath at the time of the autopsy. And during your conversation with Deputy Hemesath during the autopsy, did you discuss with him the possibility of Ms. Mullis's injuries being the result of a fall?
We did discuss how they were not the result of a fall.
Well, during the autopsy itself, before you had finished the autopsy, did you tell Deputy Hemesath that it was your opinion that the injuries that you observed during the autopsy were not the result of a fall?
I told him definitively at the end, and he had asked, and we discussed that they were allegedly from a fall, and he asked me, could they be from a fall? And I said no.
Was it your opinion that these injuries weren't from a fall, even before you finished looking at Ms. Mullis's body?
It was determined at the end of the autopsy. Much of the examination is that external examination that begins the entire process. So I had a pretty clear idea before the internal examination began, and did not issue a final opinion until the end. But I was certain at the beginning that it was a homicide, and everything else within my autopsy supported that. I remained open throughout and found no evidence to the contrary.
Did you determine that Ms. Mullis's injuries were a homicide before you did your internal examination of her body?
I Homicide was the manner of choice at that time. However, as I said, I remained open and found no evidence to the contrary.
While you were conducting the autopsy with Deputy Hemosath present, did he ask you if he could bring the CornRake into the autopsy to assist in an analysis of this case?
He asked if he could bring the CornRake closer to Ms. Mullis and her clothing items. I said I preferred to keep them separate. The CornRake itself was within the autopsy suite, which is rather large for the purpose of photographing it. The CornRake did not come in contact with Ms. Mullis during the autopsy.
During the autopsy, did you photograph the CornRake?
Yes.
During the autopsy, did you compare the CornRake directly with the injuries on Ms. Mullis's body?
I examined each separately. As I had said, I did not put them close together, but I examined them separately and within a very small time period.
How far apart were the tines on the CornRake?
I would have to check my notes. I don't quite remember.
Which notes would you like to check to answer that question?
I guess I would have to go back at the photographs because I did not put that in my actual written notes or in my autopsy report.
Was it important to your analysis to know how far apart the tines of the CornRake were?
It was information to consider. Like I said, there had been no information to suggest that anything other than the CornRake caused her injuries. There are some inherent difficulties.
All right, so I was looking it up. There's a couple of videos, 48 hours. I just listened to their. It sounds like it's been edited though, and that's only a 2-minute video, 1 minute 42 seconds. He's frantic. So apparently, it's the prosecutor who's claiming that he called her a cheating whore. I did not hear it in the 1 minute and 42 second. I didn't even hear anything that sounded even remotely like that. So if it's the prosecutor, Rick Allen style, like saying what they think they heard, that's a different thing. Does anybody, if anybody can find the full 911 that's not edited, I'd love to hear that. No, it wasn't Captain Conover. He's the Attorney General.
In comparing a fixed object with the human body, which is malleable and can contort into different positions. So taking straight measurements from an object and comparing them directly with the body is fraught with issues. But measurements such as that are important just to have every bit of evidence possible.
Is there a reason, if it was important for you to have those measurements, that you didn't document them in your notes or your report?
They were documented with photographs, and I can't recall why I didn't simply write it down.
You talked about, during your autopsy, conducting both an internal examination and an external examination of Ms. Mullis's body. And I want to ask you, just as to the external examination, you examined, well, during the autopsy, did you examine her face and her head?
Yes.
Did you examine the front of her chest?
Yes.
Did you examine her hands?
Yes.
Did you examine her knees?
Yes.
And I think you told us a minute ago that you did examine, you had the clothing that she'd been wearing accessible to you at the autopsy as well.
Yes.
What was your understanding of what clothing she'd been wearing that would have covered the top half of her body at the time that she experienced these injuries?
I know on the outer layer she was wearing a thick jacket, and I believe she had 2 additional layers of clothing on top.
At the time that you conducted the autopsy, did you look at Ms. Mullis's clothing for any holes?
Yes.
Why did you do that?
The holes were actually quite obvious when we photographed them. It's within our standard procedure to photograph clothing as it is received. So I make note of everything I see.
How many holes did you see on Ms. Mullis's coat at autopsy?
I saw multiple holes. I did not count them.
Were the holes in her clothing important information to help you determine what the cause and manner of her death were?
No.
Did you photograph her clothing during the autopsy with the holes that you'd observed in the clothing marked?
Yes.
did you take, well, I'm actually going to show you, at this moment, Your Honor, I'm going to show the witness exhibit 524. Is that being displayed?
Yes, she has it now, yes.
You've been shown, Dr. Cruz, what's been marked as exhibit 524. Do you recognize this exhibit?
Yes.
What is it?
It's an autopsy photograph. This is of Miss Mullis's jacket. It has a ruler with our state medical examiner number on it and a number of arrows that point to defects in the clothing.
Does exhibit 24 accurately reflect the holes that you saw in the jacket at autopsy?
It accurately reflects what I saw at autopsy, yes.
Well, did you or your assistant put 4 large arrows on the 4 holes that you saw in the jacket to document those holes in this photograph?
Yes, my assistant did.
Was this photograph the only documentation of the holes that you saw? Let me ask this question again. Was this photograph, exhibit 524, the only documentation that you made of the holes in Miss Mullis's jacket at autopsy?
There are other photographs. I can't recall if they have arrows or not.
Is your testimony that there are, well, let me ask you this. Are there any other photographs with arrows marking the holes that you observed at autopsy?
I just said I don't recall.
We were talking about your conversation with Deputy Hemeseth for a minute. And I believe it was your testimony that it did not matter to you what position the rake was in at the time Ms. Mullis was found in terms of the ultimate cause and manner of death determinations that you made about Ms. Mullis's death. Is that right?
What someone says in terms of the position, yes. And that's taking someone's description at face value. So no, I did not take it into consideration and did not need to.
Well, did the information about how the rake was found in her body help you to make it clear what caused the injuries?
The fact that a rake was found in her body was helpful, yes.
Did it help you to determine which injuries Ms. Mullis experienced in what order?
No.
Did it help you to determine, well, is it your testimony today that the fact that the rake was in her body in a certain way was not important to your assessment of the cause and manner of her death?
The fact that someone says they found the rake in a certain position was not something I considered or needed to consider.
At the conclusion of your autopsy, did you feel confident that Ms. Mullis's death was a homicide?
Yes.
If you had not been confident at that time that Ms. Mullis's death was a homicide, what would have been the appropriate finding in your case?
I would have pended the case for further review, investigative materials, etc.
And you did not pen the case at the conclusion of the autopsy?
Officially, I did on paper, but verbally, no, I did not. It was determined to be a homicide.
Was the reason that you penned the case on paper because law enforcement asked you to do that so that they could continue an investigation?
I don't have a recollection of if I was asked to. It's something I would have offered to do. It's pretty standard in our practice. We will withhold cause and manner of death so law enforcement can continue with their investigation so it doesn't jeopardize their investigation.
At the conclusion of this autopsy, was whatever was on paper, in your heart, this was not a pending investigation in terms of the cause and manner of her death. Is that right?
In my brain, it was not pending.
All right. You did have one, well, let me ask you this. Did you have the toxicology request that was still outstanding at the conclusion of the autopsy?
Yes.
What type of toxicology request did you make at the end of this autopsy?
I ordered what we call a basic panel. It looks at drugs of abuse and alcohol.
Does this basic panel look for prescription medications beyond drugs of abuse?
No.
For Ms. Mullis's autopsy, could you have submitted a request for a toxicology panel that covered prescription medications other than drugs of abuse?
Yes, I could have.
Is that something you did?
No, I did not.
You told me a minute ago that you were open to, that you, in your general practice, are open to other information about your cases other than what you see and observe at autopsy. Is that right?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about where exactly her body had been found?
No.
Did you want any context at the time you determined this was a homicide about where on the Mullis property she had been found?
No.
Did you want any context at the time you determined this was a homicide about what the materials were, what the floor was made of in the area where she was found?
Out of all the information you provided, that would be the most interesting, because I do think she did sustain blunt force injuries that could be related to hitting the ground. So I think that information would be useful, yes. But it would not change my manner, sorry.
At the conclusion of your autopsy, how did you know that it wouldn't change your opinion what surface she'd been found on if you didn't know what surface she was found on?
She was impaled in the back with a corn rake, so what she was standing on didn't really make a difference. But it's important to be able to understand all different sorts of wound patterns. And in addition to the injuries on her back that caused her death, she had some blunt force injuries.
Was it, well, as to the blunt force injuries, at the time that you determined that Ms. Mullis's death was a homicide, did you know what had caused any of the injuries that you say were blunt force injuries on her body?
No blunt force. None of them had a pattern that could tell me definitively where they came from.
Is it true then that you did not need to understand what those blunt force injuries were in order to determine that Ms. Mullis's death was a homicide?
I did not need them, no.
I mean, is it true that those blunt force injuries then were not relevant to deciding whether or not Ms. Mullis was the victim of a homicide?
They were supportive, but not absolutely necessary for that determination, no.
Dr. Cruz, how could they be supportive if you didn't even know what caused them?
They were supportive, as I had said earlier. She sustained a number of puncture wounds to her back, suggested to be from a fall, which would make the manner of death an accident, which is seemingly the only other option than homicide. If someone falls backwards, they don't get injuries to the front of them. So that supported that she was impaled with the corn rake and did not fall backwards on it.
Is that the only reason in your mind that determining what caused the blunt force injuries wouldn't be relevant to your determination about whether or not this was a homicide?
I think relevant is misleading. It's important to document everything you see and not be dismissive of it. So I take my findings and I do my best to interpret them appropriately. Seeing an injury and then getting additional information as to what could have caused it is always helpful and important for every pathologist to take that into consideration. I did not need them to determine that her cause of death was due to the sharp force injuries of her back. Her death was not due to blunt force injuries.
Was it possible in your mind at the time that you completed Ms. Mullis's autopsy that there could be an explanation for every single one of the blunt force injuries that you observed on her body that would explain that those injuries were caused by her everyday life or an accidental source or something that did not have to do with her being struck by, in your mind, struck by a corn rake?
Are you saying there are explanations like that for them?
I'm asking you, did you consider that possibility at the time you determined this was a homicide?
Blunt force injuries are difficult to interpret, so it's always important to consider that they could have come earlier in the day and may not have been associated with the injuries that caused someone's death. The sheer number of Ms. Mullis's injuries and the nature of them is highly suggestive that at least most of them are associated with her death.
Is that because of, in your mind, the number of other things you observed?
I've performed many autopsies, and the number of her injuries was substantial. And I do not think they were incurred during the course of her everyday life.
Well, at the time that you determined that Ms. Mullis's death was a homicide, did you take any steps to learn what the cause of any of the other, what you say were blunt force injuries on her body were?
As I stated, blunt force injuries can be difficult. None of them had a clear pattern to them. So you could take steps to postulate as to how they happened, but there's no way to know for sure. And to say you know exactly for sure how they happened is incorrect.
And Dr. Cruz, isn't it true you were taking steps up?
Yeah, that sounds like reasonable doubt, though. Yeah, I listened to 6 minutes of that 911. I don't hear jack shit that sounds like him calling her a cheating whore. I mean, do prosecutors just like literally say shit and hope that it sticks? If that dude's like his son's sitting right next to him. Which call is it, Julie? Like, how many 911 calls are there? Send it to me. Like, I want to hear it. Gotta tell you, Julie, it sounds like bullshit to me, but this doctor's full of shit.
Postulate how they happened by postulating that in your mind, because of the number of them, they must have been associated with her death?
I'm not saying exactly how they occurred, which is what you asked me.
But it was your testimony that because of the number of them, it was unlikely that they were injuries that occurred in the course of her everyday life. Wasn't that your testimony?
Yes.
So you were postulating that based on the number of them, even though you didn't know what they were caused by, they were related to her death.
That they were most likely related to her death, at least most of them.
So isn't it true that you were postulating what those injuries were without really having any understanding of why they were there?
I do not know exactly what caused them. However, in my expertise, my medical opinion, those are not due to everyday life. And that's an important determination we need to make as forensic pathologists, because we often get cases, more often than not, when there's concern because someone has a number of injuries, then law enforcement may think that their death may be due to an injury. And we then determine if those injuries could be due to normal everyday life. That's something that's standard to my practice, and I feel very comfortable doing that.
Did you have any way to distinguish at the time of Ms. Mullis's autopsy whether what you say were blunt force injuries on her body were injuries that she experienced in a fall versus from some other source?
Like I said, you can't say exactly what it is. It could be from a fall, absolutely. Striking objects while falling, striking the ground, absolutely.
And if the blunt force injuries that you say you observed on her body during the autopsy are consistent with a fall, then how could any of those injuries be supportive of the idea that Ms. Mullis's death was a homicide?
The blunt force injuries are on the opposite side of her body to the other injuries. So either she fell forward or backward, you can pick one.
Is it true that at the time of Ms. Mullis's autopsy, that because you could not envision a circumstance in which Ms. Mullis sustained these injuries, other than someone impaling her with the corn rake, that is the reason you determined that this was a homicide?
There is no other way. Yes.
And that's your opinion based on the autopsy that you conducted and your conversations with Deputy Heneseth?
I'm not sure how my conversations with him helped me come to that conclusion. Without speaking to him, I would have come to that same conclusion at autopsy.
That would have been your conclusion based solely on what you observed at autopsy?
Yes.
And that's because you did not take any steps to learn any context about, for instance, what the surface of the floor was in the area where she was found?
I was able to make that determination without that information at that time, yes.
And you didn't seek that information out?
No, not at that time, no.
Did you need to know at the time that you determined that Ms. Mullis's death was a homicide, whether she had been found with her face resting on a surface for some period of time?
I was aware that her face was on the ground, and I am aware you have someone saying that her face was resting on the floor for such a period of time. She sustained a very large abraded contusion on her jaw. I don't think that's an appropriate explanation of that injury. Especially given that she has additional injuries to the left side of her head, such as bruising to her left ear, bruising behind her left ear. But if that's what another forensic pathologist wants to say, then it still doesn't change my opinion.
Well, Dr. Cruz, that wasn't my question, was it? I mean, my question was whether at the time you determined that her death was a homicide, whether you had information at that point about whether her face had been resting on a surface.
I don't recall. I know that I was told that she was prone, so face down, so her face could have been resting. It's a possibility.
At the time you made your determinations, did you take any steps to learn that?
Where her face was?
Yes.
Not that I recall.
At the time that you determined that Ms. Mullis's death was a homicide, did you know where she had been injured?
I'm sorry, could you repeat that?
Sure. At the time that you determined Ms. Mullis's death was a homicide, did you know where it was that she had been injured?
Meaning, the location? Not
the location on her body, but the location in the world.
I'm very body focused, if you haven't noticed. I was told she was injured on a farm in a shed.
Well, you were deposed in this case, isn't that right?
I was deposed twice.
You were deposed in this case in 2023?
Yes.
And isn't it, do you recall being deposed in this case?
Yes.
Did you testify at your deposition in 2023 that you did not know where it was that she had experienced these injuries?
Correct.
So at the time you determined that her death was a homicide, you did not know where it was that she'd been injured?
No, I was told where she was found. And all that's just information from other people. I have absolutely no idea where she was injured.
At the conclusion of your autopsy in this case, did you certify the death certificate for Ms. Mullis?
I waited. That's a pending cause and manner. I eventually did certify it.
And I understand, I was not intending to imply that you did that immediately, but at some point after you completed the autopsy, did you certify the death certificate for Ms. Mullis?
Yes.
What does it mean to certify someone's death certificate?
A death certificate is a document that has a number of bits of information about a person. The part that I'm responsible for as the medical certifier include the cause of death, the manner of death, how injury occurred, and some other little bits of information. So to certify the death certificate means to place that information into an electronic record, and then I electronically sign it.
By certifying a death certificate, are you certifying that the information on that certificate is accurate?
Yes.
I'm going to show you what's been marked as Exhibit 354. Your Honor, we're going to show the witness what's been marked as Exhibit 354. I want to take a record that there is some personal identifying information on this record retrieved redacted, but otherwise this is a true and accurate copy of Exhibit 354.
Okay, the record will reflect that.
Are you saying Exhibit 354?
Yes.
What is Exhibit 354?
This is Amy Lynn Mullis's death certificate.
Do you see that her birth date and her social security number are redacted?
I do see that, yes.
Other than those redactions, is Exhibit 354 a true and accurate copy of the death certificate that you certified as to Ms. Mullis's death?
That portion that I described that I certify, I can say yes. The decedent information portion is the responsibility of the funeral home, so I'm not necessarily comfortable saying that's true. I don't know where she lived.
Other than the decedent information section, did you complete the remainder of this death certificate?
Most of it, yes, not that funeral home portion at the bottom, but really that central area.
Understood. Did you complete the portion of this death certificate that provides a medical cause of death?
Yes.
And what did you certify as the medical cause of death for Ms. Mullis?
Sharp force injuries of torso.
Is it your opinion in this case that the injuries that Ms. Mullis had on her torso were sharp force injuries?
Yes.
And this death certificate does this death certificate provide a space to explain what the injuries that you identify as the cause of death are due to or as a consequence of?
Yes, that's what it said. In this case, there really wouldn't be anything appropriate to put underneath that.
And why is that?
So sharp force injuries of torso are essentially, well, there are two components of the cause of death on a death certificate. There's the immediate cause of death, whatever condition, injury that ultimately led someone to die right away. That can be due to something else, which is called the underlying cause of death. That immediate cause of death sometimes can be so specific, it really doesn't belong on the death certificate, because ultimately a death certificate is for vital statistics purposes, tracking diseases, injury trends. So that underlying cause of death is really the most important, which is what I put. So the sharp force injuries of torso is that underlying cause of death. If you wanted to put something above it into immediate cause of death, like pneumothorax, something along those lines, you could. But in my opinion, in this case, the sharp force injuries of torso is perfectly sufficient for cause of death.
And did you identify in the certificate the immediate cause of death as you just described?
I did not. And in this case, with an injury that happens quickly like this, one could argue you're getting into mechanism of death territory, which we are instructed not to do by the CDC. So to me, her death was sharp force injuries of torso.
Did you include on this death certificate what the place of her injury was?
Yes.
And what did you say on Ms. Mullis's death certificate the place of her injury was?
Farm building.
Isn't it true that at the time, that by your testimony, at the time you determined the cause and manner of her death, you did not know in your mind where she'd been injured?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about what Ms. Mullis had been doing earlier that day?
Want is an interesting word. I do like having information about the circumstances surrounding the death, so sure, I would want more information such as that.
At the time you determined that Ms. Mullis's death was a homicide, did you have any information about what Ms. Mullis had been doing earlier in the day that she was injured?
I believe I did. I believe she was working on the farm in some capacity.
Where did you get information about her working on the farm at the time that you determined that Ms. Mullis's death was a homicide?
That would be from law enforcement.
Isn't it true that that's not information you learned until after you had determined that this was a homicide?
I suppose I can't recall clearly. We received a lot of information in a short period of time, so it's definitely possible. I learned it after, but it's a pretty simple bit of information. I don't think it would take too much digging to get that.
Well, in this case, Dr. Cruz, did you receive a lot of information in a short period of time before you determined that Ms. Mullis's death was a homicide?
I guess it's your opinion is that a lot of information. I had information about the circumstances surrounding her death. I didn't have finalized law enforcement reports. And as we established, I can't recall if I had her medical records or not. So I didn't have what one would consider a ton of information, but I didn't need it.
The only information you had at the time you determined this was a homicide was information that you saw at autopsy and that you got from talking with Deputy Hemostat and with Dr. Thompson, correct?
As far as I recall, yes.
And that was not a lot of information.
I suppose that's your opinion.
Well, I'm asking if, in your opinion, was it a lot of information?
Jackson hasn't answered. She's also being argumentative at this point.
Sustained.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about the prescription medications that Ms. Mullis was taking?
No, but I had it. Oh, I'm sorry, after the autopsy, I did get that information.
And to be clear, I'm asking about at the time you determined this was a homicide. At that time, you did not know anything about prescription medications that she was taking?
Not that I recall, no.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about what emergency responders had observed when they provided her with medical aid?
I do want information about what emergency responders saw, and very much so about what they do, or what they did as part of their resuscitative efforts.
You testified a moment ago about being concerned in your testimony today about injuries that were on the front of Ms. Mullis's body. You know now that Ms. Mullis had resuscitative efforts on her way to the hospital, is that right?
Yes.
Did those resuscitative efforts include her receiving CPR?
Yes.
And did those resuscitative efforts include the use of something called a Lucas device?
Yes.
Can CPR and the use of a Lucas device bruise someone's chest?
Yes.
Is it common for those actions to bruise someone's chest?
Bruise or abrade the chest, yes.
And so the blunt force, any blunt force injuries that you observed on Ms. Mullis's chest that were in the area where CPR is performed, are those injuries that you would expect to be associated with CPR?
It can be difficult if someone has injuries to begin with and CPR is performed in that same area, but I think it's reasonable to say that at least some of the injuries could be from CPR.
Well, in this particular case, would you as a forensic pathologist assume that injuries in that area would be connected with CPR?
I think it's most likely, and I did so. She had a sternal fracture that I determined to be related to CPR.
And you mentioned this a moment ago. At the time that you determined that Ms. Mullis's death was a homicide, did you have any of her medical records from Regional Medical Center?
I do not recall.
Do you remember what day of the week you did Ms. Mullis's autopsy?
Yes.
What day of the week was it?
Monday.
And what day of the week was Ms. Mullis brought into Regional Medical Center?
It was a Saturday.
Isn't it true that you did not get Ms. Mullis's medical records until after you conducted the autopsy in this case?
I think that's the most likely scenario.
At the time you determined that Ms. Mullis's death was a homicide, had you talked with any biomechanical expert?
No.
At the time that you determined Ms. Mullis's death was a homicide, had you talked with any incident reconstruction expert?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have an understanding of the angle of the wound paths on Ms. Mullis's torso?
Yes, I determined, well, the direction of the wound paths within the body. I did not have a specific angle.
At the time you determined that Ms. Mullis's death was a homicide, did you want to figure out the specific angle of the wound paths?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have in your mind of exactly how the corn rake entered her body?
She was impaled with it by another person.
And I understand that your opinion is that she was impaled by another person, but at the time you determined this was a homicide, did you have any understanding of how she was impaled?
Could you be more specific?
Sure. Did you have an understanding of whether the corn rake was swung into her body?
I did not, no.
Did you have an understanding of whether the corn rake was pushed into her body?
What led you to the opinion that she was impaled? Like, you can't just jump from, okay, I don't think she fell on it, so she must have been impaled. That's not science. That's not medical science at all. She's asking, what did you do in terms of measurements, angles, to try to determine? Like, it's exactly what I was saying when I was talking about if he's swinging it, like that shit. Did she do that analysis? It doesn't sound like it. She sucks, hot doc or not.
No.
Did you have any understanding of whether the corn rake entered her body in some other way by a person, in your opinion, causing it to enter her body?
It could have been swung, pushed, kicked. Someone else impaled her in the back with the corn rake multiple times.
Was it important to you at the time you determined this was a homicide to try to determine which of those routes this was?
That's not something I could do.
At the time you determined this was a homicide, did you want to understand why there had been blood found on Ms. Mullis's hand?
Did I? No.
At the time you determined this was a homicide, did you want to figure out why there was blood on the handle of the corn rake?
Want, again, is a hard word. I was aware that there was blood on the rake. I was told that she was found with a rake in her. To me, it supports the implement that caused her injuries. So I already knew all that at autopsy.
At the time that you determined Ms. Mullis's death was a homicide, did you want to understand if there was some connection between the blood on the rake and the blood on her hand?
The blood on her hand has so many potential sources. As you yourself indicated, she received CPR and pretty lengthy CPR. I just don't know the nature of that blood, so to try and connect those two would be inappropriate in my opinion.
Did you take any steps to learn the nature of that blood?
As I said, given all the events that followed Ms. Mullis being found, I don't think anyone could reasonably determine where that blood came from.
And you mentioned earlier that there's an issue in connection with a death where you have a cause and a manner and then also a mechanism. Is that right?
Yes.
What is a mechanism of death?
Mechanism, it's a really specific sort of derangement within the body that causes someone to die. It's discouraged in terms of putting it on the death certificate. Some examples that we see quite often are cardiac arrest. Someone's heart stops beating. Respiratory arrest. Someone stops breathing. Sure, those are ways people die, but really not a cause of death. What made their heart stop? What made them stop breathing? So the mechanism is that final thing of how you actually die, but a cause of death is what led to ultimately to that death.
And I understand your testimony that you did not need to list the mechanism of death on the death certificate, but at the time that you determined that Ms. Mullis's death was a homicide, did you know what the mechanism of her death was?
Yes.
Did you identify the mechanism of her death in your autopsy report?
No.
Did you identify the mechanism of her death in any of the reports that you prepared about your autopsy?
I did not say it explicitly. The description of her wounds from a medical standpoint, it's quite clear, but I did not explicitly state it, no.
What did you testify at Mr. Mullis's criminal trial in 2019 was the cause of Ms. Mullis's death?
Sharp force injuries of torso.
And what did you testify at his criminal trial was the mechanism of Ms. Mullis's death?
As far as I recall, it's the chest cavity being compromised by the corn rake tines entering into it, which caused entry of air and some blood leakage into the cavity, albeit not that much. She also had direct injury to her organs.
In that testimony in Mr. Mullis's criminal trial, did you identify which side of her chest had air entering into it as you just described?
Looking back.
The defense attorney is doing a fine job, even though she's limited to direct. I mean, she's able to, it's got a cross vibe, but they're not cross questions, meaning they're not leading.
I believe I had only said the right side, but obviously the corn rake tines also entered into the left side of the chest. That would introduce air into both sides of the chest, some blood, and then only on the right side did she have actual injury to organs, and then on the right side of the abdomen as well.
Have you looked back at your criminal trial testimony since the time of the trial?
Yes.
Is your testimony at Mr. Mullis's criminal trial about the mechanism of her death wrong?
It isn't comprehensive, I would say. I was focused on the direct injuries to organs on the right side of the body. I described how air enters into the chest cavities. So I said right, when in reality it should have been both chest cavities. I did explain quite thoroughly how there was injury to the left side of the chest as well. So it was implied but not stated explicitly.
Was it important to you in testifying at Mr. Mullis's criminal trial to be correct about the mechanism of Ms. Mullis's death?
I would like to have been, yes.
Do you agree with me that your description, even by your account today, of what the mechanism of her death was incomplete?
Mullis's lawyers shit the fucking bed. Like that's on the defense attorneys. Like when she has gaping holes in her report and she wasn't challenged like this on cross-examination during his trial, you know that his attorney shit the bed. I mean, that's why I always say, you know, for a fair trial, you need both parties. You need competent lawyers on both sides. That's, you know, you really do.
I'd have to look at my wording if I said this is the exact mechanism of death to see if it was truly incomplete or if I was just describing part of the way she died.
And I'd like to show this. The criminal trial testimony for Mr. Mullis's criminal trial, volume 3, is exhibit. One moment, Your Honor.
See, I muted so I could eat pistachios. Steph, that's cool. That's wild. What was the word on the street? What were people around town saying? Were you guys able to, I mean, were people talking? Let us know in the chat. I'm dying to know. I'm dying to know. Anybody know these people? Anybody know the family? Give us all the deed. We want the dirt. Let's go.
Sorry, what is it? Thank you so much. 349. And I'm going to refer the witness to page 98. 98. Tell me when that's there. And let me ask you, would it refresh your memory to look at your trial testimony to recall exactly what you said?
I'd like that, yes, thank you.
I'm going to, if the witness could read page 98, I know that's not up quite yet, and I'm going to direct the witness to line 13 of page 98 through line 3 of page 99.
She thirsty. She thirsty.
Here, I have a paper copy if that would assist us in moving forward, that I'm happy to show the witness.
I think we have it on the screen.
All right.
There's not much worse than being on the stand in a matter like this and having your work just picked apart with a fine-tooth comb. It's not fun. It's not fun. She's not having a good time up there. You know, it's like, and this attorney has been digging very, very deeply into this autopsy report and what exactly this Emmy did not do. She's not having a great day.
Thank you, Your Honor.
Yep. Would you like me to read it out loud? Sorry.
No, just to yourself. And I'm directing you to page 98, line 13 to page 99, line 3.
We can go to the next.
Patty, I like this question. If this was accidental, why would he get on the stand and say that he did this? I don't think that he got on the stand and said that he did it. I think he was forced to agree because his attorneys decided to concede to the state's theory that this was in fact a murder and not accidental, which is why you're going to be hearing about ineffective assistance of counsel here. Like if you relate to it, Patty B, trial strategy is left to the lawyer's discretion. I mean, you know, we're the ones who understand the law. We understand what's going to be admissible, what won't be admissible. So trial strategy, excuse me, is always left to the attorneys, not the defendant. So they went through the entire state's case in chief, not arguing or putting any resistance up to the state's theory that this was a homicide, that it was an intentional death. So by the time he got in the stand, he had no choice. Like he can't like his lawyers never on any witness ever challenged that this could have been accidental. They just I guess it was a Saudi defense. Some other dude did it, not our guy. But I guess he acknowledged that it was murder against his will. So, I mean, that's part of what this particular thing is. That's why you're going to hear the ineffective assistance claims come raining in.
Next page for me here.
I mean, typically that means that one of his or both of his, I don't know how many lawyers he had, is going to get called to the stand. Which, talking about being uncomfortable with somebody picking apart your performance at your job, lawyers getting up there. Whew. I don't know.
Nicole, can you scroll down?
Just that one paragraph.
Well, looking at the piece of testimony that I just directed you to, did that refresh your memory about what you testified to at Mr. Mullis' criminal trial about the mechanism of Ms. Mullis' death?
Yes.
All right. And I think the question I asked you before you reviewed that testimony was whether in your testimony at his criminal trial, you testified about which side of her chest the issue with air coming into the chest cavity was on.
Could you go back to the previous page? I'm sorry, so I can look at it again. Thank you. Yep. I see reading it now, and I think I was swayed a bit by reading your expert's opinion. It says that I said it only went into the right chest cavity, that I simply say it goes into her chest cavity singular, but I don't say what side. But I do accurately describe what's called pneumothorax, which is air entering into your chest and causes issues with your vital organs there. Something that your expert also agreed was appropriate and accurate.
Well, your testimony at Mr. Mullis' criminal trial was that the issues with pressure in the chest were on the right side of Ms. Mullis' chest, right?
I said that she had injuries to her right lung, which caused leakage of blood. I was not specific as to what side the air came into, but I do say chest cavity singular, so I suppose it's up to interpretation.
Isn't it true that at the time of your autopsy in this case, you actually didn't know which side of Ms. Mullis' chest had what you described as a pneumothorax?
That's something that's difficult to identify at autopsy. Upon review of her medical records, it's clear that she had a large pneumothorax or air in her left chest cavity. It's also clear from my autopsy and the medical records that she had a right-sided chest tube placed. Notes indicate that air was released from that right-sided chest tube, meaning that she had air in both of her chest cavities, which simply makes sense.
Right, and does the fact that you didn't appreciate a left pneumothorax at autopsy, which I understand your testimony is you might not have appreciated that at autopsy. Mm-hmm. I mean, does that suggest to you that you hadn't looked at the medical records from the hospital that would have allowed you to identify that there was a left side tension pneumothorax?
I did not review the medical records at that time. I'm not sure what difference it actually makes. From a medical doctor standpoint, her having pneumothorax should have happened. So if you asked me without even seeing the body, give me that scenario, I would tell you that's what happened. And that was confirmed with the medical records. She died because she was impaled with the CornRake and the effects of having that CornRake inside of her body, which includes air in the chest cavities.
Was the left side tension pneumothorax the actual cause of Ms. Mullis' death?
The x-ray that identified the left-sided pneumothorax was taken after that right-sided chest tube was placed. The medical records indicate that it was pretty significant. So if she had left-sided pneumothorax alone, absolutely. But to say that it was the only thing that contributed when she also had right-sided pneumothorax, she also had direct injury to her lungs and to her liver, I think would be insufficient.
Well, if Ms. Mullis hadn't had the left-sided pneumothorax and only had the injuries to the right side, those were injuries that she could have survived. Is that right?
She could have survived the left-sided pneumothorax as well. Prompt medical therapy can treat pneumothoraces. It can treat injury, direct injury to lungs. I don't see a difference.
Your testimony at Mr. Mullis's criminal trial suggested that there was bleeding in Ms. Mullis's chest as part of the mechanism of her death. Did you see that in what you just reviewed?
I did.
Was there actually very much blood in Ms. Mullis's chest at the time of your autopsy?
No.
Is it correct that bleeding into her chest cavity was not really a part of the mechanism of her death?
If you were to have that alone, no, I don't think that would have caused her death.
And I want to make sure I understand your testimony. Is it your testimony that whether or not she had the pneumothorax on the left or the right side of her chest wasn't important in your assessment of whether or not this was a homicide?
No, those are consequences of being impaled with the CornRake. It's a homicide because she was impaled in the back. Those are things that happen from being impaled in the back by another person, which made it a homicide. What happens to the body doesn't make a difference. Someone gets shot in the head, and I talk about bleeding on the brain, really doesn't make sense. They were shot in the head.
Did you know at the time of her autopsy which injuries Ms. Mullis experienced first? The injuries on the left side of her back or the right?
No.
And did you know how much time, if any, passed between the time that she experienced any of these injuries on her back?
I do not know, no.
Would it have been important to your analysis to have known that?
How would I have known that?
Well, that's my question for you. Did you have a way to determine that?
I wasn't there, so I wouldn't know.
Exactly.
Were you open in your investigation to receiving information that would have helped you understand that?
Who would provide that information to me?
At the time that you determined Ms. Mullis's death was a homicide, could you think of a single person who could have assisted you in understanding that?
Other than the person who impaled her, no. And it really doesn't make a difference. Someone impaled her in the back with a CornRake.
I mean, does that question that I'm asking you today seem silly to you?
To ask if there was a time period between someone impaled her in the back once with a CornRake and then again with the CornRake again doesn't make sense or really matter. She was impaled in the back with a CornRake by another person. Whether they took a beat before they did again doesn't make a difference to me.
If Ms. Mullis experienced the pneumothorax, the tension pneumothorax on the left side of her chest first, how quickly would that have caused her death?
Something like that would not be immediately fatal. She very well could have had many minutes before she lost consciousness and ultimately died. It's hard to know for sure, but minutes likely went by.
Would Ms. Mullis still have been breathing?
Yes.
Would Ms. Mullis
I'll
still
check
have
it
been
out,
able to
Amanda.
move?
Thank you.
Most likely, yes.
Um,
Do you hear him calling her a cheating hooer, Amanda?
Would the pneumothorax have led to a situation where air entered Ms. Mullis's, where liquid developed in Ms. Mullis's lungs?
Oh, we're fluid. Then build up. But yes, yes.
You're the doctor, so fluid is a better word.
No
I appreciate
problem.
that.
Yep.
Would that have led to a situation where Ms. Mullis was breathing out foamy fluid out of her mouth and potentially her nose?
Yes.
Were there any errors in the autopsy report that you created about Ms. Mullis's death?
Yes, I do have a typo.
What typo is in there?
It's an unfortunate one. It's in the opinion section. When I state wound direction, I say from front to back instead of back to front. It's the danger of repeating something over and over again. It's the only typo I could find.
And when you say that's an unfortunate typo, what do you mean?
Well, it's important to determine whether it's front to back or back to front. It's a fact and obvious, but should have been written appropriately.
Is it true that that's not a typo that you caught when you finalized this report?
No.
And Did anyone else who reviewed your report catch that typo?
No.
Have you issued a corrected autopsy report at any point about Ms. Mullis's case?
No.
Fuck it. He's convicted. What do I care? He impaled her.
After you determined that Ms. Mullis's death was a homicide, did you continue talking with investigators who were investigating Ms. Mullis's death?
Yes.
And I think it was your testimony earlier that you did tell those investigators your opinion on the cause and manner of her death before your autopsy report was finalized. Is that right?
Yes.
Did you talk with investigators from DCI after a couple of days after your autopsy, after you conducted the autopsy on Ms. Mullis's body?
Yes.
Why did you talk with investigators? Well, let me ask you this. Did you talk with them on November 14th of 2018?
Yes.
Did those investigators ask to have a briefing with you about the autopsy?
They asked to discuss the autopsy, my findings. Yes.
And you did you talk with them on that day?
Yes.
Did those investigators give you information about their investigation at that briefing on November 14th of 2018?
Yes.
Did they tell you at that briefing on November 14th of 2018 that they believed that Mr. Mullis had a motive to hurt his wife because of what they told you was affairs?
Yes.
And did you know why on November 14th of 2018 they were telling you that?
You would have to ask them, but it's not unusual information to receive.
Is it not unusual because you're part of the law enforcement investigation into people's death?
I'm not part of it. People often like to share what they've learned. I had already determined cause and manner of death, so you'd have to ask him why he wanted to share it.
Did you tell investigators on that call on November 14th of 2018 generally what the conclusions of your autopsy were?
I believe so, yes.
And what did you tell investigators on November 14th of 2018 about, in your view, how many times it was that Ms. Mullis had been impaled on this CornRake?
At least 2 times. Given the orientation of the wounds on her back, there's a high likelihood that it was 3 times.
Did you tell them in this briefing that it was possibly, or that there was a high likelihood that it was 3 times?
I believe so, and I maintain that.
Do you agree with me that your case log notes don't reflect that you told them that there was a high likelihood that it was 3 times?
That's my investigator's case log notes, and I'd have to look at it. But if it doesn't say it, it doesn't say it.
Well, don't you participate in maintaining those case log notes as well?
One person types them. So say there are multiple people who are a part of a meeting or a discussion, one person will type up the notes.
Do you check those notes?
I read them, but I do not edit them. I don't want to alter them. There as another person remembered them.
Do you initial those notes?
No. Oh, I'm sorry. Just to be clear, I do not initial notes. I do not write.
I want to show the witness at this point, Exhibit 573. And I'll just say that we've made some slight modifications to the original photograph of this 573 just for purposes of privacy for this hearing. Is that Exhibit 573 in front of you?
Yes, that's what it says.
Is Exhibit 573 a true and accurate photograph of the condition of Ms. Mullis's back during the autopsy that you conducted on November 12th of 2018?
It appears so. You said you altered it in some way, but it seems appropriate.
And I'll just represent you that it's cropped a little bit.
Okay. Yes.
From your original photograph.
It seems fine to me.
Okay. You mentioned, we'll come back to Exhibit 573, so you can remove that, Nicole. During the briefing that you had with the investigators on November 14th of 2018, did you talk with them about other defects that you noticed on Ms. Mullis's body aside from the 6 wounds that we've been talking about that were on her back?
I noted other injuries, yes.
And you've talked a little bit in your testimony about some of the other injuries that you observed in your assessment of them, but I want to ask you a couple of questions about that. I mean, in your briefing with investigators on November 4th of 2018, did you talk to them about this injury you've referenced to the left side of Ms. Mullis's chin?
You say this, I'm not looking at anything, to be clear. Okay,
Understood.
and injury to the left side of her chin. I most likely did, yes.
I mean, you've referenced in your testimony an injury to the left side of Ms. Mullis's chin. And when I say this injury, I'm talking about the injury you previously identified in your testimony.
Yes,
Did you talk to the investigators about that injury at this meeting?
I most likely did.
Well, did you tell them that that injury did not have any associated injury to the inside of Ms. Mullis's mouth at this conversation on November 14th of 2018?
I know you're referencing notes that I did not make. She also had an injury to her lip, so I don't know if inside of the lip injuries were relating to a lip injury. To say that there were injuries to the side of her chin and then talk about the inside of her lips seems to be a little bit of a jump.
I don't want you to make any.
I don't recall exactly what I said, and I don't recall exactly how they were written in those notes by another person.
I don't want you to make any assumptions about what I'm referencing. So let me be a little more straightforward. When you observed Ms. Mullis's face at autopsy, did you note in your autopsy report any injuries to the inside of her mouth?
No.
I mean, she didn't have any scrapes on the inside of her cheeks, did she?
Not that I saw, no.
Did she have any abrasions or cuts on her tongue?
Not that I saw, no.
Did she have any damage to her teeth?
Not that I saw, no.
And you're referencing that she had a cut on the middle of her lip?
I believe it was a scrape, yes.
So she had a scrape on the middle of her lip?
The way you're asking me makes me want to look at my autopsy report. Is that okay?
Of course. It's Exhibit 225.
I have a copy here. Is that all right, or do you want me to wait?
I was wondering where that copy is. So is that not correct to stand to?
Yeah, I usually bring it to the stand. I don't have to look at it.
Okay, we'll show
I
you
asked.
Exhibit 225. Is Exhibit 225 a true and accurate copy of your autopsy report? And we can scroll through for you if that's helpful.
This is a photo request. It's not part of my normal autopsy report.
Can you scroll down? I think you identified that there's a photo request on the first page of Exhibit 225.
Yes,
Other than that photo request, is Exhibit 225 a true and accurate copy of your autopsy report?
yes.
And is there,
I'm sorry, can I look at page 5?
I was going to ask you what page, so we'll take you to page 5.
Thank you. So yes, the very first sentence says there is a 1/8 by 1/8 inch red brown abrasion in the center of the upper lip. So that's a scrape.
Was this scrape a small scrape?
It was 1/8 inch.
Is that small in your opinion?
Whatever you think 1/8 inch is. Lips are quite small, so in relation to the lips, it might be large. In relation to your back, it might be small.
Did you consider this to be a small abrasion or a small scrape?
Sure.
Were the injuries that you noted on Ms. Mullis's face consistent with Ms. Mullis having fallen?
They could be caused by a fall, yes.
Were these injuries more consistent with a fall than with another explanation?
No, they didn't have any sort of pattern to them that would lead me in one direction or another. So they're called blunt force injuries. They're injuries that occur from the impact with an object that has a flat surface. So that could be the ground. That could be something else that simply has a flat surface to it. It's hard for me to know exactly how they occurred, but a fall is absolutely a possibility.
Did you tell investigators during your briefing with them on November 14th of 2018 that Ms. Mullis's facial injuries were perhaps more consistent with a fall?
I don't recall saying more consistent with a fall, but absolutely could be due to a fall.
Your Honor, we have two exhibits that we've put side by side just for comparison purposes, which are Exhibit 570 and Exhibit 621. And I'll just represent that we've made some redactions just for privacy purposes, but otherwise these have not been altered.
What was it?
570 and 621. Are you seeing two images in front of you?
Yes.
All right. Do you recognize one of these photographs to be a photograph that you took during your autopsy?
Yes.
And is that a photograph of the area of Miss Mullis's chin where some portion of her face has been redacted?
Yes.
And which side of the screen that you're looking at does that the photograph that you took autopsy appear on?
On my right side of the screen.
Okay.
With a ruler.
And do you see a photograph on the other side of the screen as well?
Yes.
Do you recognize where that photograph is from?
No.
Have you ever seen the photograph on the left side prior to today?
I do not recall having seen this before.
Do both of these photographs that you're seeing on the screen in front of you depict the area of Miss Mullis's chin?
As I said, I've never seen the other one before. It looks like a similar injury to the injury I saw on Miss Mullis, but I can't even say that's her.
Prior to your deposition in 2023, had you ever seen any photographs of Miss Mullis that were taken at Regional Medical Center or Region Medical Center?
I had, yes.
And do you recognize the photograph that appears on the screen in front of you that is not the one you took to be a photograph from that set of photos?
I assumed it was, but as I stated, I don't recall having seen it before.
In your view, does the chin injury that appears on the photo that you took and the chin injury that appears on the photograph that you don't recognize, do those chin injuries appear different?
There are many similarities between them. The shape is similar. Differences include the injury at autopsy is that there's drying of the wound, so it's much darker in color.
Do you see any other differences about the appearance of the wound on the chin other than the drying?
The bruising around it appears to be more pronounced, I think, in my autopsy photo. I don't know if there's anything else you're looking for.
Are there any other differences that you note?
It's darker in color, the bruising appears more pronounced, but it maintains its same general shape.
When injuries on a person's body are exposed to air, can that lead to drying?
Yes.
And what does drying impact the appearance of abrasions, for instance, on someone's body?
Yes.
How can drying impact the appearance of abrasions?
Well, this is a good example. It changes the color of the wound, may change the size slightly. It doesn't really change much else. Experience helps you interpret them appropriately.
Well, does the injury to the chin on the photograph that you took at autopsy look more pronounced than the injury to the chin in the other photo?
The dark color from the drying makes it stand out more.
Is the injury to Miss Mullis's chin that's depicted in the photographs, or the photograph that you recognize of the two that are in front of you, is that injury consistent with a fall?
It could have occurred with a fall, yes.
And is there any evidence that the chin injury that's depicted in the photograph that you're looking at was caused by anything other than a fall?
There's no pattern within it that I can tell that tells me what caused it. So it's from the impact of an object with her body, and the object has a flat surface. So it could be the ground, it could be an object as she's in the process of falling the ground when she falls, or another object striking her while she's in another position.
See, this is the examination that should have taken place at trial and didn't. I mean, you can see how she's struggling on a lot of answers, evasive on a lot of answers, admitting to mistakes, things that weren't noted, things that weren't contemplated, things that she just drew just like bald face conclusions on with no basis in science. You know, once she landed on, oh, she was impaled, that was it. Like, she didn't try to figure anything out. Like, the question still remains is, how did she reach the conclusion that these puncture marks were, or wounds were, caused by being impaled by another person as opposed to her falling Is her answer because of the number of puncture wounds? Because there were only 4 tines? Is that it? It seems like that's it. I mean, look, these are like people's lives in these cases that we watch. You gotta that's what I'm saying. I mean, you have to vet the evidence at trial. If you have shit defense attorneys, you're going to get shit results. And what it's going to mean is that they're just going to railroad people. You have to give the resistance. If the evidence is there, if the evidence supports the conviction, it will win out. It will win out. To let it go in unchecked leaves everybody wondering what happened. Can I trust this conviction? It's the whole point of a trial. I know Mandy just sent me an article about his 2 turd defense attorneys at trial. I'm starting to read it now.
In your testimony at Mr. Mullis's criminal trial, did you tell the jury that this injury to Ms. Mullis's chin was consistent with the fall?
I don't recall saying that, but I maintain that today is consistent with a fall. It's also consistent with any other type of blunt force injury.
Did anybody ask you?
When did you get in here, Free Radical? You've been in here for the whole time, just not chatting? She's been very evasive and defensive. I don't know if you saw the part. They wanted to treat her as hostile, meaning that they would be able to cross-examine her, ask leading questions. They had a bit of an argument, legal argument, and the judge denied it. So they're performing it as a direct, which allows her to answer open-ended questions. I mean, you don't have to have somebody losing their shit on the stand in terms of being able to tell that they're being evasive. So I disagree with you, Free Radical, and I've been watching the whole examination. So we can agree to disagree.
At Ms. Mullis's trial, whether this injury was consistent with the fall?
I would have to look at the transcript.
And we'll come back to that. And I want to go back to her ears, because that's something that you mentioned earlier. And if you need to see some photographs of her ear to refresh your memory, I can show you that. But in your conversation with the investigators on November 14th of 2018, did you tell those investigators that any bruising around Ms. Mullis's ear could also be consistent with her falling?
I don't recall, but independently now I say, yes, it could be from a fall. She has earrings in, and she had bruising to the backs of her ears and on her earlobes. And that could be from her hitting the ground and the earring causing injury to her ear and the skin around her ear.
Could the bruising that you noted around Ms. Mullis's ear be consistent with bumping her head against some surface as she walked? For instance, hitting her head on a door jamb as she walked through a door.
Yes.
Could it be consistent with banging her head on some object hanging from the ceiling as she walked through a space?
If that injured her ear as well, then sure.
I mean, is there any way to distinguish the bruising on her ear from someone's everyday activities?
It has the standard definition of a blunt force injury. I can't tell the nature of the injury, so it could be from sort of activity of daily living.
Did you tell investigators on this call on November 14th of 2018 that Ms. Mullis had a pretty low baseline hemoglobin?
I did say that, yes.
Right, and can having a pretty low baseline hemoglobin be something that can lead to anemia?
Well, that's what anemia is.
You're identifying that Ms. Mullis had anemia?
Yes, from the medical record, she was anemic.
Can anemia lead to dizziness?
Yes.
Can it lead to weakness?
Yes.
Can it lead to people falling?
Yes.
Ms. Thompson, is this a good spot for?
It is. It is, Your Honor.
Let's go ahead and take 15 minutes. We'll plan on resuming at about 30 or just before. Court's in recess till then.
All right. Let's see how much blooping we have. I think we should be good on the bloops. Let's see. Oh, shit. Guess we're not good on the bloops. We caught up. We're real time. Damn it. Damn it. I hate real time. Yeah, I mean, remember, this thing's just getting started. So this is a state's witness. She's obviously not changing her opinion, but that's not the point. Like, the defense attorneys know she's not going to change her opinion. That's why they have their own expert. That's where this is going to get interesting. This is where it's going to get really interesting. I don't know if I want to watch the trial openings, Julie, just because of the fact that I think we're going to hear information like, his defense attorneys tried it in a way that they were conceding that this was a murder, but it was just somebody else that had done it. I mean, does it help us? Does it help us for this? I guess, well, let me say this, Julie. Let me reserve that until after this thing's done. Because there's not, the judge is not going to, I would think, not going to rule from the bench at the conclusion of this. I'm assuming that she'll take it under advisement probably for a hot minute to go through it all and reach a conclusion, because it's obviously a huge decision. So at the conclusion of this, if I think that it's warranted, maybe we go back and check out openings and closings, see what they had to say. But, I mean, until we hear all the witnesses they're going to put on, it's going to be, Sarah, I don't know if that's what Mandy sent me. I don't know if did you, when you say the Us, are you talking about Us Magazine? US Magazine, Us? All right, put this on play. Yeah, I'm not gonna lie, the case that I'm still kind of like reeling about is the Zachary Hughes case. That's a case that I want to actually go back and watch the whole damn trial, because and I actually want to go back and watch people were saying that the pretrial hearings were not regarding the ability to use the defense of others, affirmative defense was not allowed, and it was I guess that argument took place in chambers. I don't know. It's an interesting case. That case is an interesting case. I always, frankly, in terms of my favorite cases, it's never whodunits. It's never circumstantial homicides where it's a whodunit, because you're never going to get an answer, an actual answer. We're all left, either thinking the state met their burden or they didn't, but it doesn't give us a definitive answer as to what happened. I'm saying that all the time. Whereas with self-defense cases or like the Hughes case, we know who did it. But it's a matter of, was it justifiable? It's a completely different type of case. Because cases where you just never are going to truly know the answer unless there's smoking gun direct evidence. I mean, you're always depending on the power of the circumstantial evidence. I mean, there's certainly cases where circumstantial evidence is beyond. Like I would argue, I anticipate that the circumstantial evidence against Rex Heuermann is going to be very powerful, to where we have no doubt that he's the creep. But it looks like they're crawling back in here. Yeah, I don't know. I wish I could see a witness list. I don't know how many witnesses they have. Hey, Tracy, if you're still in here, have you seen or can you try to dig up the post-conviction petition for this? It's going to be big. If you have to pay for it, don't worry about it. I'll see if I can pull it. It's obviously Iowa. See if you can find it. I'd be interested in reading it. Because I didn't know this was going on. I forget who it was. It might have been MB. Somebody was like, "You need to cover this," and I'm like, "Ooh." I'm like, "All right, let me peep this," and then immediately I was sucked in. So I'm like, "Oh my god, this looks amazing!" And I completely forgot that Jay and I covered a little bit of this. We definitely didn't do the entire trial, but I think we definitely did like the ass end of it. I believe. Um, and if you're new to the channel or you're just dipping in, please make sure you like, share, subscribe, all the YouTube things that help us get out into the algo. It helps. Every little bit helps. Really does. Whoa, are you shitting me? 40 witnesses? Wow. Wow. But tonight, 7 o'clock Central Standard Time, the incomparable Joshua Schiffer, my friend. He's brilliant. He's hilarious. Like if you haven't messed with Josh, dude's next level smart. Really a really bright guy. I love having him on. I'd like to make him a regular, to be honest with you. And he's probably up for it. He's so bright, so funny. Really knows the law. The guy's cream of the crop, in my opinion. And then tomorrow, don't forget, the one and only Vinny Politan is joining us at 10 a.m. I was just texting with him. We're talking about I'm hoping that it's during the Reed hearing. And I'd love to have Vinny on while that's going on so we can dig in. If that happens to be over, because it should be right when that thing's starting, I think. Is that starting at 9 Eastern? Because it could be, if it's 9 Eastern, that's 8 our time. And then in theory, if it goes a couple hours, it depends on what she's doing. Oh shit, 11 Eastern. Oh, all right. So that's right when Vinny comes on. Perfect. Because he was asking me, he's like, "What are we talking? Are we going to talk Delphi or are we going to talk Reed?" I'm like, "We're going to talk both, bro." But I really want to cover that Reed thing pretty heavily, obviously. But I always love to get Vinny's opinion, and it's great to have Vinny off of Court TV because we can get authentic Vinny, which authentic Vinny's awesome. Court TV Vinny's awesome, but authentic Vinny's different and awesome. He can let his hair down a bit when he's out here in these streets. He doesn't have the restraints that he has on Court TV. But I love hanging with him on there too. So that'll be great. And again, that's 10 a.m. tomorrow. So tonight, Josh, and we're gonna start putting our weekly schedule up. I was real proud. I was real proud of myself that I actually got a schedule so that you guys have some normalcy. I want it to be where like, oh, it's Tuesday. Bob's on at 7, and then like clockwork. It'll be like every Thursday back when it was Friends, Seinfeld, like that shit, where it's all like in stone, consistency matters. I think it really, I think it makes a difference to people. Plus, I think it will create kind of an effect where people will just know when we're going to be on. I think it'll drive traffic to the channel as well. I think it's all good things from having a schedule. It does really, like, I think this week's lineup is pretty killer. I don't know about y'all. We got Josh. We've got Vinny tomorrow. Wednesday. What am I doing Wednesday? I forget. Somebody else on Wednesday. I already forgot the schedule. Let's see. I gotta look at the schedule. I already forgot it. It's all blending together. Let's see. Okay. Okay, here we go. Let's see, Wednesday. Oh, Joel, STS Joel. That's right. And then so he'll be talking Ellen Greenberg case. We have not covered that. I think that it's high time that we dig into that case. If Ellen needs another loud voice out there and it's warranted, then I'm certainly up to the task. Thursday, we've got Lauren Conlon coming on, who's going to get us all up to date on the privileged and wealthy battle between Lively and Baldoni. See what's going on there. I really enjoyed Steve's live last night, by the way. If y'all aren't checking Steve out, you should. I thought Steve did a really nice job with it. He did some stuff that I'm not going to do. I'm not going to have a bunch of clips, but I really appreciated being able to watch it because it raises a lot of questions. It raises a lot of questions about actors and actresses. Actually, I just call them all actors these days. You know, actors in terms of these scenes that they do with one another. You know, it's like it seems like that shit's ripe for people getting sniped. So and Lauren knows all the stuff. Like that's right up Lauren's alley. She loves the I mean, it's pop crime TV for God's sake. So you know she loves that kind of stuff. And then Friday we're going to be doing Felonious Friday, which will be a norm. And so we're going to have the schedule weekly. The following week, I haven't gotten the date nailed down, but we are going to be having the forensic phone data expert Stacey Aldridge rather from the Delphi trial, the defense's phone expert on. I'm really excited about that. I have a million questions for her, so that will be an interesting live, to be certain. And like leading into that particular Felonious Friday transitions not into Feral Friday, I will always be portaling y'all to Steve, especially on Monday and Wednesdays, because I'm going just before Steve goes on Monday and Wednesdays. I had to because of Scarlett's volleyball schedule. I'm trying to make it so Allie can be with us, or I can be here, and we can both be on because we have to transport her to and from her travel volleyball practices, which are on Monday and Wednesdays, and they're instead of just having them at the same time, they have them at different times. So it's 5 to 7 one day, and then it's 7:15 to 9:15 on Thursdays or on Wednesday. So Monday and Wednesday. So because I never try to step on Steve's feet because I love him and he's a wonderful guy and he's my friend and I'd want his channel to grow. So I'm going to try to keep those Monday lives around an hour 10, and then I'm going to try to get Steve to push back his lives to maybe 9:15 Eastern, so he gives me a little bit of a buffer. And then YouTubers don't have feet. The fuck you talking about, Mandy? Of course they do. Looks like we're getting ready to get back on. But what I was saying, the schedule will always be, there's obviously going to be trials that we're covering that may impact nightly. Or, I mean, what Allie wants to do, like I'm going to have a hard time getting Allie sitting through like sitting through full trials with me. She's very much of the let's do it like Peter does it. Let's do kind of recaps at the end of the day. Whoa, 20,000 a month. What channel's that? What are they doing? What's the magic sauce? What's the secret sauce? I mean, I'm pretty happy. We just broke 38. I think with the consistency. You know what? I knew that it was a thing when we pulled all of the podcast episodes that were showing up as videos off. We got back in the algorithm. Like they literally, because the metrics on those were terrible because people who come to YouTube come for video. And little did we know when we put them in as podcasts that they put them in as videos as well. So people would click on them. And then when you look at the metrics, people would drop off in 9 seconds, which tells YouTube, oh, well, this content sucks or the content sucks. So we're not going to put it in the algorithm. Once we got that off, it changed like immediately. So I'm glad that we did that. Oh, that's interesting. It sounds too political for me. You're always trying to drag me into politics, Megan, and I just won't do it. It's like I have enough shit that I eat being a defense attorney. Like I don't need any shit like the political stuff. That's not my game. That's not my game. There's plenty of other channels out there that do that. I take enough beef trying to. Why can't we hear it? What the hell's going on? Is this on them?
The 201, a complete an management staff.
Yes.
Document.
What do they say that you
How
should
do you
never,
keep these case log notes in terms of what kind of?
What are the 3 things you should never talk about at the dinner table? Politics. What are the other 2? Religion. What's the other one? I forget.
Document.
I follow
It's
that.
digital.
Are these kept as a Word document?
No, we have, it's our sort of medical management system that holds information about decedents in our office and has a space for us to write notes.
Is Exhibit 201 a complete and accurate copy of all of the case log notes that your office kept about Ms. Mullis's autopsy?
To my knowledge, yes.
Okay. I also want to show you Exhibit 380. And while we're pulling up Exhibit 380 for you, as part of your autopsy of Ms. Mullis, did you measure the depths of the wounds in her back that we've been discussing?
Yes.
Did you, and we've talked that you photographed the outside of those wounds, is that right?
Yes.
Did you photograph, did you or your staff take any photographs during Ms. Mullis's autopsy that would capture or reflect the wound paths inside Ms. Mullis's body?
Not of the organs or as they entered into the back of the body, no.
Do you agree with me that you and your staff took only 2 photographs of the inside of Ms. Mullis's chest during this autopsy?
Yes.
And do you agree with me that those 2 photographs don't really show the wound path inside Ms. Mullis's chest?
Correct.
They're just in the way that her body was autopsied. There's some portions of her body that are really obscuring her chest in those photographs. Do you agree?
Yes, her ribs.
All right. I'm going to now show you Exhibit 380. Is that in front of you?
Yes.
And if you need to have us scroll down, we'll do so. But do you recognize Exhibit 380 to be a true and accurate copy of the postmortem examination notes for your autopsy of Ms. Mullis?
Yes.
I'm going to direct your attention to page 3.
Poor Julie.
Does page 3 have some exemplars of the human body on which you've taken notes?
Yes.
Is this your handwriting on page 3?
Yes.
And
oh, I'm sorry. At the top with her name, that's not my handwriting, but everything around the body is.
I appreciate that clarification. Page 3 is page 3 your notations at the autopsy of things of note that you observed during the autopsy?
Yes.
And does page 3 capture all of the defects in Ms. Mullis's body that you appreciated during autopsy?
No.
is it your testimony that there's some defects that you, well, let me ask you this question. I'm going to have you turn to page 4. What is different between page 3 and page 4 in terms of what you were noting at autopsy?
Page 3 describes defining characteristics and other noteworthy features on Miss Mullis that would belong in my report outside of injury. So it had her hair color, her eye color, if she had medical therapy, jewelry, things like that. I used a separate body diagram, as you called it, page 4, to document her injuries.
Does page 4 capture all of the defects on Miss Mullis's body that you observed at autopsy?
Yes.
And do you see a little chart at the bottom of page 4? And if you need us to zoom this, we can. Do you see a little chart sort of at the very bottom of page 4 that has some, what I would call little carrots and some numbers next to it?
Yes.
What is that little section of page 4?
That section of page 4 has each of the 6 puncture wounds. In between each puncture wound is a measurement of distance.
Looking at page 4 and that area, here on page 4, you've measured the depths of the wounds in Miss Mullis's back. Is that right?
Yes, I see depths here. Sometimes I'll notate it on the other page with internal injuries.
Well, do you agree with me, and if you need to look at some other paperwork to answer this, I can show this to you, but do you agree with me that some of the penetrating injuries that we've been talking about on Miss Mullis on her back, some of those penetrating injuries were not very deep?
Similar to the injury to her lip, I think that's kind of a matter of opinion. Some were deeper than others, absolutely.
Which one of the penetrating injuries to her back were deep?
The deepest of the penetrating injuries, she had 2 that had an approximate depth of 6.5 inches. In terms of my autopsy report, those were puncture wounds B and E.
You're saying B as in boy?
B as in boy.
And E. Wound A is the wound that is to the furthest right of Miss Mullis's back, is that right?
Yes, really on the side of her chest.
More underneath her armpit, is that right?
Yes.
Did wound A go all the way through Miss Mullis's body?
It did.
Was there one of the wounds on Miss Mullis's back that was just 2 inches deep?
Yes.
Which one was that?
That was wound D. It was the inferior most wound.
You have described the wounds in her back that we've been talking about as sharp force injuries. Is that right?
Yes.
Is it more accurate to call these injuries blunt injuries from a puncturing device?
No, I would prefer to say sharp force injuries. Blunt force injuries, as I indicated, have a flat surface that can abrade or contuse the skin, potentially cause a laceration with impact. A sharp object will cut and divide tissue as it enters the skin. Obviously, it's a unique object for someone to be impaled with. In my opinion, sharp made the most sense.
Are there different characteristics for injuries that are caused by a blunt object being forced through someone's skin, like as a penetrating injury?
It's more difficult to penetrate the body with a blunt object versus a sharp one.
is it true that you don't know, as you sit here today, how much more difficult it is?
It depends on the type of object, if you're comparing to.
Is there any difference in your mind between how, other than that it would be more difficult to penetrate the body, between how a blunt object being through some mechanism forced into someone's body, is there any difference in terms of how wounds caused by the blunt force object being forced through would appear or would operate in the body from a sharp object being forced into the body through some mechanism?
So the impact of a blunt object with the body, like I said, can cause abrasions, scrapes on the skin, bruising. If it's a significant impact, you can cause a laceration or a tearing of the skin, which I suppose would allow the blunt object to further enter into the body. Lacerations are irregular, and we have what's called tissue bridging, so little pieces of tissue may still connect each side of the wound. This is in contrast to a sharp object, which, as I said, cuts and divides tissue. So you shouldn't have that tissue bridging. It should be a cleaner looking wound.
Besides what you just identified, are you aware of any other differences in how a blunt object being forced through some mechanism through someone's body would operate versus a sharp object being forced through someone's body?
I'm not quite sure what you're getting at. It's vague when you say a blunt object through some mechanism. I don't know what object you're talking about or what mechanism, so I don't know what conclusions I can draw.
Well, when you examined the corn rake at issue in this case, were the tines on this corn rake blunt?
They were pointed, and both pointed and slightly rounded. So I suppose you're trying to characterize it as a blunt object.
To be clear, I'm asking you your characterization.
I
I'm not trying to
characterized
characterize it as anything.
I characterized it as a sharp object. It cut and divided the skin as it entered into it, as characterized by the well-formed round holes in Ms. Mullis's back after she was impaled with it.
Well, if I hit my head on the edge of this table, that could cut and divide my skin and enter to some extent into my body, right?
That would cause a laceration, which is an irregular tearing of your skin.
But that could also enter my skin.
If a blunt object impacts your skin, that force would cause the tearing of the skin. I suppose if you were to remain in that same spot for a period of time, say the edge of the table could slightly enter into the laceration, sure. Entering in your body is, I think, misleading.
Is it true, as of your deposition testimony in this case in 2023, that in providing professional opinions about cause and manner of death, that you tend to shy away from saying that something is a possible defensive wound?
I do, and you can go back to my previous testimony today where blunt force injuries are hard to interpret. There are injuries that are considered defensive type wounds, but at the end of the day, they're simply blunt force injuries.
Have you become shyer over the course of your career in characterizing wounds as defensive wounds?
I maintain my same position on that. Some wounds are considered defensive in nature due to their position on the body, but at the end of the day, they're blunt force injuries. And without a pattern, I can't say definitively how the injuries occurred.
Has it been your experience that sometimes in your career, people who might be calling you to testify at a trial might be pushing you to identify certain blunt force injuries as possible defensive wounds?
Yes.
And is that because identifying something as a defensive wound could have an impact on what people perceive about what the cause or manner of someone's death was?
So I determine cause and manner of death. I don't use these so-called defensive type wounds in my determination of cause and manner of death. How they're perceived in legal proceedings, I do understand that may have an impact on a jury for them, but I do not use it for my determination of cause and manner of death.
Have you gotten better over the course of your career at pushing back on attorneys who might be asking you to characterize certain wounds as defensive wounds when, in your opinion, there's really no way to tell?
I suppose potentially we all become stronger as we get older.
And at the time you performed Miss Mullis's autopsy, you were newer in your career.
Yes.
I mean, did you start your job as a medical examiner here in Iowa in July of 2018?
Yes.
And is it true that your autopsy of Miss Mullis was a few months after you started?
Yes.
Was your job as a medical examiner in Iowa your first full-time job since you finished your fellowship?
Yes.
And I'm not asking for personal details of your life, so without identifying anything about where specifically you've lived in your life, you did not grow up in a farming community, did you?
No.
Do you have limited experience with farming?
Yes.
Did you testify in Mr. Mullis's trial in about a year after you performed the autopsy of Miss Mullis?
Yes.
And at the time you testified at trial, had you performed about 600 autopsies?
If that's what I said, then that would be accurate. I don't recall now.
Do you know, as you sit here today, how many autopsies you'd performed in your career that were unsupervised before you performed the autopsy in Miss Mullis's case?
Before I did, no, I can't recall.
2.
Had you performed about half the autopsies in your career before you performed the autopsy of Miss Mullis?
In my career as I sit here now?
I'm saying that as of the time of your testimony at Mr. Mullis's trial, you performed about 600, correct?
If that's what I said, then yes.
All right. And as of the time of performing Miss Mullis's autopsy about a year earlier, how many of the 600 had you done at that point?
Well, if I performed about 300 or so with my training, then I see what you're saying, then about half of that.
Okay. Was there a time in Mr. Mullis's case where counsel for Mr. Mullis sent a letter to your office requesting to meet with you about Mr. Mullis's case?
I know we were sent a letter. I don't recall if it said meet. There was information about some expert opinions that they had gathered, and there was a question as to if I wanted more information, but to meet, I would have to look again.
Did that letter ask if you'd be willing to communicate with counsel in some way, whether in person or on the phone or through some method?
I think I have a similar answer to that. I don't recall that. I'm not saying that's not what it said. There was a part of it where they said I could ask for more information. So if that's inviting a conversation, then that's along those lines, yes.
Did you decline to speak with counsel in response to that letter?
I did not.
Don't object as relevant.
The answer will remain in the record.
Well, is there a process in forensic pathology where a forensic pathologist can change their medical opinion?
In all of medicine, you can change your medical opinion.
Is there an ethical obligation for forensic pathologists to change their opinion if they learn information that should change their opinion?
An opinion should always reflect the pathologist's true opinion. So sure, if your opinion changes, then it should be reflected in the death certificate reports, et cetera.
Is there a process to change a death certificate?
Yes.
When you became aware of the letter that counsel had sent to your office about communicating with you about information related to Mr. Mullis's case, was there any moment where you considered potentially talking with them about the information that was provided in the letter?
I did read the letter, and due to its contents, no.
Did that letter include some excerpts of what was represented in the letter as being additional expert opinions about Mr. Mullis's case?
Yes.
And at the time of your deposition in 2023, was the information that was provided in the letter, those excerpts, the only information you had about whatever additional experts might be saying about Mr. Mullis's case?
I'm sorry. Yes, I believe so.
And was it based on those excerpts and the content of the letter that you determined that you were not going to communicate further with Mr. Mullis's counsel about this case?
Yes.
And I think you mentioned that that letter offered to provide you with some additional information. Is that your memory?
Yes.
Did you take counsel up on that offer of providing you with some new information that you hadn't had previously?
No.
Have you at some point since your testimony at Mr. Mullis's criminal trial sent text messages to Deputy Hemaseth about Mr. Mullis's case?
Yes.
And in those text messages, have you expressed some disdain for Mr. Mullis's efforts to seek post-conviction relief?
I would have to look at them. I don't know.
I can show them to you. I'm going to have you look at Exhibit 230. If you need to look through more of 230, I will show it to you, but it does Exhibit 230, screenshots of text messages between your cell phone and Deputy Hemaseth's cell phone?
Yes.
And I'm going to refer you to page 11 of the exhibit. Let me have you read page 11 and let me know when you've done that.
You're muted. Bob, you're muted.
That fucking
Bob,
annoys
you're
the shit out of me.
muted.
All right, I got it. So, like, I wanted to address polygraph. If the dude has a shitty defense, that sucks. Really don't think it's going to matter who represents him. If he gets a new trial, no jury is going to buy this was an accident. He's done. So, what happens if during this hearing they put on an actual doctor who really is going to look into, not that she's not an actual doctor, she is, but one that is going to look at it objectively and gives a different opinion that's compelling? You know, like, I mean, the thing about the first trial is his lawyers came in conceding that was murder, like completely against what this guy wanted his defense to be. He's like, I don't think anybody else killed her. I think it was an accident. You know, and they employed their own strategy to the extent where this guy had to get on the stand and say that, yeah, I guess somebody else killed her, even though that's not what he believed. I mean, this guy has always said that it was an accident, starting with the 911 call. So, look, here's what I can tell you. about post-conviction relief act petitions. Essentially, aside from writs of habeas, post-conviction relief act work and habeas, writs of habeas corpus, which is over on the federal side, are the last gasp. It's typically the last gasp that you have, your last shot. And post-conviction relief act petitions always sound in newly discovered evidence, which they have here, and they often sound in ineffective assistance of counsel. So what I'm suggesting to you, Polygraph, is that you just table trial one. Let's hear it out. 40 witnesses, 10 days. If at the end, but there's a lot of procedural hurdles to get to where we're at today, meaning a full evidentiary hearing or trial. 40 witnesses, it's like it's a trial, or a very, very lengthy hearing. So there's something there, because these just don't happen all the time. You've got to really clear so many hurdles to get to the point where they're willing to sit in the court for 10 days and listen to 40 witnesses. They've compelled some people to think that it's worth a listen. You know what I'm saying? People that know a lot more about the case than we do, namely this judge. This judge is the one who agreed to it. So, because usually PCRAs go back to the trial judge. Like Allie and I's are one of our first cases fresh out of law school was a Philly case. It was Muti, who just got out last year. His son found us. We were outside smoking cigs outside of our office in Philly. And that was it was a post-conviction. And we actually got the judge to order a new hearing. It's a big thing for us. Yeah, I mean, farming accidents happen all the time. Like, what are we talking about? Look, my point being is that they've called this ME in order to show how little work and how little actual analysis she did. She had tunnel vision. She keeps saying it. I didn't need to look at anything else, because to me, I saw 6 puncture holes and there were 4 tines on the thing, which meant that she was hit on multiple occasions. There's no reasonable explanation for that at all, other than somebody impaled her. So once she was there, that was it. She didn't do any kind of she didn't look at the wound patterns, and she looked at nothing. So, we're going to hear this other, 10 days worth of witnesses. I'm here for it. People get convicted for shit they didn't do. It happens, Polly. Believe it or not. And in this case, they built a nice little narrative about the controlling, psychotic husband whose motive to kill his wife was that he didn't want to give up his farm. I'm hoping that one of the witnesses is going to be a divorce attorney that this guy consulted that told him it's not marital property. You wouldn't be losing the farm. That kind of destroys the theory that he was worried about losing the property. That was one of the reasons that he killed her. The other being that he was under the impression that she was having a second affair. The timing of it with the son kind of wandering around seems strange to me. If he doesn't make sure that she's deceased, knowing that his oldest son is walking around the farm, and that son is the one who discovers her, and he doesn't know for a fact that she's deceased, which I don't know if there was enough time for that to have happened, she's going to say, your dad did this to me. You got to think these things through in terms of plausibility. Again, I don't know what the time frame was. I just saw something about 1 minute and 40 seconds. I know that the 2 younger kids were in the farmhouse and that the older kid was wandering. And so it's I don't know. I'm here for it. I'm going to listen to all of it, and then I'll judge it. I'm certainly at this point not saying anything about him getting a new trial because they got a long road to hoe. But I'm here to listen for it and listen to it.
I'm done.
Does reviewing page 11 refresh your memory about whether you've ever expressed some disdain for Mr. Mullis's efforts to get post-conviction relief to Deputy Heneseth?
I wouldn't characterize it that way. I would characterize it as I expressed disdain for the manner in which the case was being revisited, specifically some pretty nasty things said about me by your co-counsel.
What? Tracy, is that true? Adding on shit this week?
Did you share in text messages with Deputy Heneseth a video that purported to recreate sort of what had happened in Miss Mullis's case?
He shared with me a video.
Did you watch that video?
I did.
And did you express some disdain for the sort of way in which that video was produced in your messages with Deputy Heneseth?
I would characterize it more as I found it amusing. It's by an individual who was harassing me, and I wasn't quite sure.
See, but Pammy, in a trial where the defense is putting forth no defense, just kind of limping along, of course he's going to seem guilty as fuck. You know what I'm saying? It's like, let's see, like I'll be curious. Like I've gotten the sense that a lot of the people that have watched this trial think that they got it right. I'll be curious. All right, I'm going to make a poll. I want to make a poll only for those who watched the first trial in its entirety. It'll be an interesting exercise because we'll check now and then at the close of the evidence of this post conviction. Let's see if we move the needle. I'll see if we move the needle.
For what it was showing, so it was an interesting thing to see.
I want to come back to that topic, but I want to ask you about one more topic, and I'm almost done with my exam here, Dr. Cruz. At the time of your deposition in 2023, am I right that you did not know at that time the order that the 6 wounds on Miss Mullis's back occurred?
Correct.
At that time, did you know which, if any, of these injuries happened together, meaning that more than one tine of the CornRake went into her body at the same time?
I do not.
And at the time of your 2023 deposition, did you have in your mind's eye any particular idea of how exactly someone put the CornRake into Miss Mullis's body other than that in some way that occurred?
I don't know exactly how she was impaled with it. I just know someone else impaled her with it.
And I appreciate, and I don't want to belabor this point, that you've said multiple times now in this testimony and elsewhere that you do not believe it is possible for Miss Mullis to have fallen on this rake more than once. So understanding that that is your opinion, you do believe that a person could be impaled by this CornRake by falling on it one time?
I do think someone could fall on it once.
I mean, it is your belief that falling on this rake once could generate the necessary force for someone to be impaled on it?
I think it's possible, yes, for someone to be injured by a CornRake by falling on it.
And for you, is the issue with determining whether Miss Mullis fell on this CornRake then, that while it is possible for someone to fall on a CornRake once, it is not possible, in your view, for someone to have fallen on this CornRake more than once?
Not just fallen on it more than once, fall on it, pull it out of your entire torso, fall it in again, likely pull it out, and then fall on it again with enough force to generate puncture wounds.
Can you envision a mechanism as you sit here? Well, I want to ask you a different question. At the time of your deposition in 2023, could you envision a mechanism where someone fell on a CornRake, impaled themselves on all 4 tines of the CornRake, were able to extract some of the tines, but not all of them, from their back, and then fell back on the corn rake for the tines that had come out to re-impale into their body.
I do not think that's possible. I think significant force is required to generate those wounds. And then you're suggesting that the second fall is from a very short distance.
Did you testify? Well, I want to understand this. At the time that you testified at your deposition in 2023, did you believe it was possible for someone to have pulled some or all of the tines of the corn rake out of their body one time?
I would have to look at my deposition if I was asked that. It's hard to go back in time.
Would it refresh your memory to look at your deposition?
Sure.
And I'm going to have your 2023 deposition pulled up for you. We're going to come back to that issue because I want to pull a page for you to ask if it would refresh your recollection. But while we're doing that, as you sit here today, do you know the force that would be necessary for an object like a corn rake to penetrate just the clothing on someone's body?
No.
Have you, as of the time of your deposition?
I mean, to get it through not just the clothing, but all the way through her body is like Al Capone baseball bat in the Untouchables level of swing, I would imagine. You guys remember that scene from the Untouchables where Al Capone caves that dude's head in like a melon? It's like that type of a swing.
In 2023, were you aware of any scientific sources that you could consult to answer the question of how much force would be necessary to penetrate the clothing on someone's body?
Mandy knows.
I don't know of any specific people who would tell me that, but I suppose I could look.
And to be clear, when I'm asking about any source, I'm not asking just about people, but any type of source that scientists would use, including reference materials or any other type of academic source. As of the time of your deposition in 2023, did you know any source that you could consult to answer that question?
Not that I recall.
All right. I want to then go back to your deposition as to my prior question. And I'm going to show you for your 2023 deposition, page 19. I'm going to have you read page 19, line 6 through line 13, just to yourself. And I'm going to ask you if that's refreshed your memory after you've done so. Yes, sorry. Page 19. This is 2023. Page 19. 6 through 13. Line 6 through 13. Yeah, the deposition.
And this is exhibit 322, right?
Thank you very much. Yes, exhibit 322.
Okay.
Have you had a chance to review that portion of your deposition?
Yes.
Did reading your deposition, that portion of your deposition, refresh your memory about whether in 2023 you believed it was possible for Ms. Mullis to have pulled the rake out of her back one time?
Yes.
And what was your opinion about that at the time of your deposition?
I said that it is possible, but would likely be incredibly difficult and unlikely.
And again, as with the idea of being impaled on the rake, was it your belief in 2023 that while it was possible for someone to remove some or all of the tines of a corn rake from their own back one time, you did not believe it was possible to do that more than once?
Correct.
All right. Just one moment, Your Honor. Dr. Cruz, as we've been discussing at length today, you're a forensic pathologist, correct?
Correct.
Do you have any expertise in the field of biomechanics?
No.
Do you have any expertise in the field of biomedical engineering?
No.
As of your deposition in 2023, had you ever consulted a biomechanical expert on a case?
No.
As of your deposition in 2023, had you ever consulted an incident reconstructionist on a case?
No.
As of 2023, was it your opinion that the field of biomechanical engineering is a scientific discipline?
I'm not incredibly familiar with
What?
it,
What are you saying?
but it sounds like it would be true.
I mean, do you believe, as you sit here today, that qualified biomechanical engineers are scientists and have scientific expertise?
Like I said, I'm not familiar with them.
Anja, it happened in late fall, like November, mid-fall of 2018.
But I would agree that they probably consider themselves scientists.
At the time that you were deposed in this case in 2023, did you have any opinion on whether a biomechanical engineer could contribute to the understanding of what happened to Ms. Mullis?
It's not something that I considered in terms of needing it for my cause and manner of death.
And as of the time of your 2023 deposition, did you maintain your opinions about the cause and manner of Ms. Mullis's death without reading the full reports of any of the experts that Mr. Mullis had consulted in his post-conviction case?
I'm sorry, could you repeat that one more time?
Sure. As of the time that you were deposed in 2023, did you maintain your opinions about the cause and manner of Ms. Mullis's death without having read the full reports of any of the experts that Mr. Mullis had consulted in this case?
Yes.
Just one moment.
Hey, Todd, do you have any questions you want me to ask her? Tracy, did you have any luck finding the PCRA petition for this? It's Fun Pa, Dan. Fun Pa. People are getting used to it. They were they thought I was going to cave. Oh, Jay's going to love the comb over on this guy. Yeah, it's basically Van Gundy. Actually, a little worse. Like his hair is a little longer than Van Gundy's was, but same exact concept of comb-overism.
One additional issue, Dr. Cruz. At your trial testimony in Mr. Mullis's criminal case,
Thanks, Trey.
were you asked to identify a photograph?
Feels
of
prosecutory.
the CornRake in this
Right.
case as part of your testimony?
I would have to review, but if the record shows that, that sounds fine with me. I think that sounds appropriate.
Alleyhan, see you. She's done, but they're double checking. See if there's anything else there.
Your Honor, we have Exhibit 62 from the underlying criminal trial, which we're going to show the witness. That is not, we have a photograph of it from EDMS, which I think we'll show to the state, Erica, if you want to do that we'd like to approach the witness with.
Approach. Wow. 38 votes.
Yeah, counsel, if you can just show it to the state before you bring it to the witness, but then you can certainly approach the witness whenever you're ready.
53% don't think the jury got it right. Interesting.
It's so hot. Sorry, Ken.
Thanks for your patience, Dr. Cruz. This is the last question we have for you.
Thank you.
We've shown you as best we could a copy of State's Exhibit number 62 for Mr. Mullis's criminal trial. Is that in front of you?
Yes.
Do you see that photograph?
Yes.
What is depicted in this photograph?
This appears to be the handle portion of the corn rake. In it, there's a ruler with our state medical examiner number indicating that the photograph was taken at autopsy.
Do you agree that this photograph does not depict the tines of the corn rake?
Correct.
From looking at Exhibit 62, can you tell anything about whether the tines of the corn rake are sharp or not?
No.
Hey, give me a hug.
Your Honor, I don't have any other questions. Thank you.
Thank you. Mr. Brown?
I'm gonna try to be done by 4:30.
Okay.
Younger.
Chance, I'll try to get
Healthier.
Dr. Cruz, I don't think came planning to stay this evening. Yeah,
No.
I didn't think so. So, yeah, I'll try to get through this. If I may approach the witness, I'm gonna do this real fast.
You may.
I'm gonna show you 3 exhibits, A, B, and C. Those one. What is A?
A is my CV.
Is that up to date?
I've since earned a certificate at Drake University in the education portion that I recently updated it with, but other than that, it's appropriate.
What is B?
B is, it starts with that letter to Deputy Hemastath about his request for photographs and then continues into my autopsy.
Is Jay stuff in the ballot box? Is that what's happening here? Is that what I'm seeing in chat? Is Jay voting early and often?
Autopsy report.
Is B the entirety of your autopsy report?
What?
Yes.
And then what is C?
Gotta ask Camden.
C is a quality assurance paper as part of our standard protocol at my office. All cases that are deemed homicide are formally reviewed by another pathologist in our office.
Is that a record that's normally maintained in your office as part of your certification?
Yes.
Okay. In as much as they're not admitted, we'd offer A, B, and C.
Any objection? They will be admitted.
All right, Dr. Cruz, you were asked about a deposition where
No, Dan, him and his son, his mother, most likely deceased mother, was on his son's lap while they were driving to the hospital. He called 911. The dispatcher asked him to pull over so that the ambulance could try to get there for life-saving measures. So that's what happened. He didn't get pulled over on the way to the hospital.
it was page 19. Do you recall? It was just a minute ago.
Yes.
All right. And on the page, do you have that page in front of you?
No.
You guys have that one? Please. I'm not connected. Page
Would
19.
you mind if we just showed this copy?
Tell me more about it, Dan. I don't know. I haven't heard of it.
Her testimony.
I'll Google it.
Thank you.
See page 19 of the deposition?
Yes.
Right, and then was lines, I think, 8 through 11 you were asked to review.
Yes.
And lines 8 through 11, you said that she could have pulled it out of her once, meaning the rake, correct?
Yes.
All right, the next sentence is the difficulty of that in someone's back with the depth of the tines to me seems incredibly unlikely. True?
Yes.
All right, then what's the last line? I don't believe that was mentioned. What was the last comment that you made in that deposition on page 19?
I say, and then the thought that she fell on it again, pulled it out, and again, it's just not a feasible possibility.
Okay. Any of those opinions or characterizations, have those changed for you at all over this course of time?
No.
Okay. All right, I want to talk a bit about the process that you follow at the medical examiner's office. Where is the medical examiner's office?
Ankeny, Iowa?
And are there other forensic pathologists that work there?
Yes.
How many?
At the time, there were 3 other forensic pathologists.
Okay, and currently there's also 3 others other than you, is that right?
There are 4 others now.
Sorry, I missed one. And who is the state medical examiner?
Dr. Dennis Klein?
And would Dr. Klein have been the doctor that hired you?
Yes.
All right. And as you have other assistants at the medical examiner's office, can you just briefly describe that for the court?
Sure. So in terms of our office, we have Dr. Dennis Klein. He is the chief state medical examiner. We have Dr. Jonathan Thompson. He's the deputy state medical examiner. He's also the one who formally reviewed my report. At the time, Dr. Michelle Catalier was the other associate state medical examiner with me. Currently, the associate state medical examiners are Dr. Jacob Smith and Dr. Allison Haid.
And as part of your work and routine in examining cases, do you frequently consult with one another?
Yes.
Okay, does that happen on a daily basis?
Yes.
Anytime you might have a difficult case or something that might be confusing to you, can you rely on them to help you?
Yes.
And in this case, whenever you did the autopsy of Amy Mullis, would that same support system have been in place for you?
Yes.
Do you also have the use of investigators in your office?
Yes.
What does an investigator in the medical examiner's office do?
Our medico-legal death investigators are each assigned one person to a case. They will communicate with law enforcement. They gather law enforcement reports, medical records. They talk to family and gather any other information that we may need for a determination of cause and manner of death.
And would you have had that resource available to you in the investigation and the autopsy of Amy Mullis?
Yes.
Is there a quality control process in place at the medical examiner's office?
Yes.
Describe that for us, please.
Part of our regular quality control is for any case where both cause and manner are undetermined, or where manner is homicide, the case is formally reviewed by one of the other pathologists. They fill out a form where they say if photographs, documentation, our ultimate opinion are all correct, and if they agree, and then they sign that form. We also review random reports throughout the year per name guidelines on cases that are natural, suicide, and accident.
You had mentioned earlier in your direct that you were performing more than one autopsy at the same time as Amy Mullis. Is that right?
To the best of my recollection, yes, that's standard.
Okay, so that's what I'm getting at. Is that a standard practice?
Yes.
Is there any concern in your mind that cases get confused or that creates any type of issue with either one of those cases?
Never. That's my normal day.
Okay. And do the other pathologists, the forensic pathologists in your office do the same
You remember
thing?
D.
Yes.
Warner.
And
Remember
at
that.
those autopsies, even though you're doing more than one, do you have the resources available to you that you've just described?
Yes.
Now, from beginning to end on autopsy, you were asked that the physical autopsy that you do was about 2 to 3 hours. Is that correct?
Correct.
But the whole process takes much longer than that. Isn't that true?
Yes.
Can you describe that for the court, please?
The physical autopsy itself is really the shortest portion of the whole process. The autopsy examination is performed with the photographs and the collection of evidence and other items. I then write my report. I review photographs as part of that report writing process, and then I wait for the results of any ancillary testing to return, such as toxicology, histologies, looking at things under the microscope. That takes time, can take a matter of weeks. During that time, law enforcement reports, medical record reports, any other information is gathered as well and then reviewed by me. Once everything is back, everything is re-reviewed by me. My report is edited and then ultimately finalized. Since, for example, in this case, since it was a homicide, before the report was officially finalized, it received a QA by Dr. Thompson.
All right. So what date did this case present to you? What was the first day you would have started working on it?
The autopsy was performed on November 12th of 2018.
And when did you sign out the final report?
The final report was signed on December 17th of 2018.
So nearly a month.
Yes.
And at any point in that time frame, if you would have received other information that would have either contradicted your findings or caused you to change your opinions, would you have done that?
Yes.
Since the autopsy report has been finalized, you've been provided a lot of other information, correct?
Yes.
You've reviewed a report that essentially has criticized your findings. Is that true?
Objection, Your Honor. This goes to the issue raised about cabining her opinions to her 2023 deposition.
I think you opened the door on that, Ms. Thompson. Mr. Brown, do you want to respond?
Well, yeah, I mean, they want to sit here and complain about Dr. Cruz's opinions. They keep pigeonholing her to only go to the 2023. Clearly, they have other information that they're going to offer that criticizes Dr. Cruz's opinions. She has reviewed that information, and I expect her testimony to be that she has not changed her opinion, even based upon that. That's what I'm getting at. They cannot open this door and then close it on us. This is clearly admissible.
This has to do with the court's pretrial ruling about the purposes for which she was designated in this case, and her designations not designating her as a cross-expert to respond on the applicant's experts, Your Honor. I mean, if the court determines I opened the door in my exam, while I might disagree, I would respect that, but this was the court's pretrial ruling.
And I agree, which is why I was surprised by some of your questions that we were going there. I'm just looking back at my notes, but I understood some of your questions to be quite broad and to open the door. So I think this question at least is fair. So the objection's going to be overruled. Do you remember the question at this point?
I would ask that it be read back.
Well, and there was an objection, so it'll have to be, so.
Thank you.
Thank you.
You didn't finish the question.
Okay. Is it your belief that the quality control process in place at the medical examiner's office is consistent with other quality control practices across forensic pathology?
It's in keeping with requirements by the National Association of Medical
Wait, what
Examiners.
just happened?
I don't think you were asked why you didn't do that. So why wouldn't you have expanded that panel with the toxicology lab that you?
Wait, did that? What?
I understood some of your questions to be quite
That was
broad.
not me that
and
made it
to
fast forward like
open
that. That was
the door.
crazy.
So I think this question at least is fair.
It jumped.
So the objection's
Didn't you
going
guys
to
see it
be
jump?
overruled.
I didn't hear him ask the question. All of a sudden, it's
Do
like
you
we're
remember the
asking
question at
questions.
this point?
I would ask that it
Andy?
be read back.
Well, and there was an objection, so it'll have to be, so.
Thank
I'm
you.
going to quiz you as soon as we get off stream. Live stream quiz. 10 questions. You have to at least get 50%.
You reviewed a report that essentially has criticized your findings. Is that
May I continue with that, Judge?
You may.
So you've reviewed a report that has
Shit.
essentially criticized your findings in this case, correct?
Yes.
Has that, and you've done a thorough review of that report?
Yes.
Is that from Dr. Hammers?
Yes.
And has that review caused you to change any of the opinions that you've given in this case?
No.
Shocking. What do you think? She's going to sit up there and say, yeah, I fucked it. Really shit the bed on that one.
During an autopsy, there was some questions that you were asked concerning law enforcement being present.
Yes.
How often does that happen in autopsies that you perform?
On a pretty regular basis, I imagine potentially weekly.
And is that something your office invites?
Yes.
That you want that assistance?
Yes.
What's the purpose of a law enforcement officer being at the autopsy?
Oh, there you go.
Law enforcement officers can learn a lot from the autopsy. We encourage them to come. They interact a lot with family and may learn how to better investigate a case. You know, it's not disturb the body in a certain way that might affect us at autopsy. We think they benefit greatly from it. Also in terms of, wound interpretation or any other sort of questions, if they're available at time of autopsy, that's beneficial to us.
And other than Deputy
See?
South, was there any other law enforcement that
She's
you
an agent of the state.
consulted during the autopsy of Amy Mullis?
No.
Okay.
Remember that whole little mild rant earlier about how she's an agent of the state? Because cops are always in there planting seeds. Yeah, we're pretty sure he.
Concerning how Amy Mullis was found, you've been provided a description of that. Is that correct?
Yes.
Do you know the source of that information?
It's my understanding the source is her family, her son, and her husband.
Okay. Is there any, as far as you know, any law enforcement that made those observations?
No.
How could they? They weren't there. Stupid question.
Did you read these? I can't see your screen. You gotta go to the document.
When do we think nut allergies started? It's weird to me. It seems environmental. Like when I was in school, no one had nut allergies. They seem to be like a recent thing. What do you guys think causes nut allergies? It's weird. Like no one had peanut allergies or nut allergies when I was a kid. Like I like all my years of school, I never saw any kid like bust out in hives and have his throat close up like from having peanuts around him ever. Strange.
Okay, Dr. Cruz, there were some notes that were reviewed with you by counsel that related to a conversation you had with John Turbot.
Yes.
There was a comment in there concerning injuries being consistent with the fall.
Yes.
What was that? What were you referencing?
Well, those are his notes. And as we established earlier today, the blunt force injury she sustained have been from a fall.
So the blunt force being what? The injury to the chin?
Correct. Her abrasions and her contusion.
You are not meaning to reference the injuries from the tines of the rake?
No.
Okay. Dr. Thompson is the local, or was the local medical examiner at the time of Amy Mullis's death?
Yes, he's a county medical examiner who I believe was covering for Delaware County while the regular medical examiner was out of town.
Just to put this into context, every county has its own county medical examiner, is that right?
Yes.
And this is usually just a local doctor that goes through some basic training.
Yes, they have to be a physician and experience and training vary.
Right, and that training is provided by your office.
Yes.
Dr. Thompson would not be qualified to perform the examination that you perform, correct?
Correct.
All right. They're just local boots on the ground, so to speak.
Yes, who have medical training to assist them with their judgment.
Prior to November of 2023, did you know Dr. Thompson personally?
No.
Had you ever worked with him before, as long as you know? Had you ever worked with him at all?
No.
Was he the first person that brought this information to your attention that there were injuries that he thought were suspicious?
We have a morgue attendant who answers our phone at the office who would.
It's funny. I was looking at that dude's haircut, man. It's like, it's kind of looks like he put like a little, like it's kind of shaved on the side there. And he just kind of put like a little rug right there. Bloop, 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 bloop. And it does make his head kind of look flat.
Would have connected me with Dr. Thompson. The only other person who would say that beforehand would be just someone letting me know Dr. Thompson called. He has concerns, give him a call back. But direct concerns came from him.
And you would certainly consider that, at least initially in your examination of Amy Mullis, correct?
I respect his medical opinion.
As you would if any other autopsy where the county medical examiner would provide you some information, correct?
Correct.
You were asked about the toxicology panel?
Yes.
All right. I want to get a couple questions with that. I'm just about done. You were asked whether or not you looked for prescription medications.
Yes.
All right. You said no.
Some were included on that basic panel, but outside of prescription medications of abuse.
I don't think you were asked why you didn't do that. So why wouldn't you have expanded that panel with the toxicology lab that you work with?
Expanded toxicology panels are ordered when the drugs in a person's system may have contributed to their death or directly caused a person's death. In a case where someone has an injury that caused their death, drugs within their system are usually irrelevant. In this case, I deemed them non-contributory to Ms. Mullis's death. We order toxicology routinely, so I ordered the basic panel. The expanded panel, which would be in addition to most cases, was not appropriate at all in this case. I knew her cause and manner of death at the end of autopsy.
And you would have access to even consulting with a forensic toxicologist if needed. Is that right?
Yes.
Did you feel that was necessary in this case at all?
No.
And context, you were asked about the context of how the body was found and where it was found. I believe you said that you did not consider that at all, or that didn't factor into your opinions?
Correct.
Okay, can you tell us why not?
I am able to interpret wounds on a person's body. Information about how a person was found needs to be considered carefully. I did not know those things to be true. The way the handle was sticking out of Miss Mullis has no bearing on the fact that she was impaled with a corn rake more than once. It doesn't change my cause of death. It doesn't change my manner of death.
And whenever you say she was impaled with a corn rake theoretically could have been swung, correct?
Yes.
Could have been pushed into her?
Yes.
Like a knife?
Yeah, Mello, I just asked the robot, and the robot had a pretty similar answer to that.
Knife?
Yes.
Right? Or in some other way, correct?
Yes.
You know that the
Thank
rake
you
was
for your generosity, Mello.
The rake was what caused the injuries that caused her death, correct?
Yes.
All right, that's all I have. Thank you.
Any redirect?
Extremely briefly, Your Honor. You've described the quality control process at the medical examiner's office, Dr. Cruz. Did the quality control process at the medical examiner's office catch this error that you described in your opinion section that was I think you used the word, and I don't want to misstate your testimony, but an obvious error or a glaring error?
Yeah, I don't remember if I used those words either, but no, it did not catch the error.
That's an error that you immediately recognized in re-reviewing your report. Is that right?
I did.
Okay. Is it your belief that the quality control process in place at the medical examiner's office is consistent with other quality control practices across forensic pathology?
It's in keeping with requirements by the National Association of Medical Examiners. I don't know what other offices do.
You testified that you later learned some information about how Miss Mullis was found, and I think it was your testimony that the source of that information was members of the Mullis family. Is that right?
Yes.
Did anyone ever provide to you recorded interviews of Todd Mullis and Tristan Mullis talking about this issue?
Not that I remember.
As of your deposition in 2023, did you have any idea what Todd Mullis and Tristan Mullis had said to law enforcement about this issue? In terms of directly from them?
Not that I recall.
And you described that you had resources at the medical examiner's office that were at your disposal to conduct a further investigation into this case. Is that right?
We have investigators who can help me gather information about the case.
You told me earlier in your exam, which might feel like a long time ago to both of us, that there was no requirement after the physical examination portion of your autopsy for you to make your findings at that time. Is that right?
Correct.
And in fact, I think your testimony was that that's the shortest part of the process, correct?
The autopsy itself is, yes.
The physical autopsy isn't even really the end of your basic process for collecting information about an investigation. Is that right?
Correct. I gather information after the autopsy and consider all that information before finalizing my report. In this case, my opinion always stayed the same.
In this case, you made your determination after the physical examination and did not change it after that.
Correct.
No other questions, Your Honor. One moment, Your Honor. I'm sorry.
Of course.
I'm sorry, Your Honor.
It's hard to say, Kraken. I mean, it would have been a very different trial. They would have challenged all this evidence, state's evidence. You know what I mean? It's like when they're conceding that it was murder and intentional homicide, it changes the entire scope of the trial. So I couldn't even begin to guess. I mean, he certainly wouldn't have testified that it was murder. You know, like once he testified it was murder, they're gonna be like, well, who the hell else did it? Like the boyfriend or the boyfriend's wife? I mean, that's how law enforcement thinks. They're like, nah, who's this dude?
You ain't getting her hands on the family farm, fucker.
Your Honor, we are seeking to admit the exhibits
Iowa
from today,
Shooter.
which I think if the parties are in agreement, this doesn't require more foundation or authentication. I think we can address that tomorrow potentially. I just don't want to lose my chance to solve that problem, but I don't believe there is an issue with anything we offered.
Yes. Yes, Your Honor. I think the parties had talked informally during the break, and we came to an agreement on all the exhibits that were referenced, I believe. If there's a specific exhibit you want to clarify, otherwise.
I don't want to waste the court's time with this at 4:40, so I think the parties are in agreement. They've conferred, and we can address that tomorrow with the court's permission.
That's fine with me, as long as you guys are comfortable that we won't have any hiccups with it.
I think we're fine, Your Honor. We've conferred, Your Honor.
Okay. Any recross, Mr. Brown?
No, Your Honor.
Okay. Dr. Cruz, you may step down. Thank you. It is time to recess for the day. We'll plan on picking back up tomorrow morning at 9 o'clock.
Ooh.
Okay. Thank you. Have a nice evening.
Day one in the books, y'all. Day one in the books. All right. So a little impromptu live. Got a nice little crowd in here today. I think this could, I think out of all the days, this is probably going to be the driest. That's what I'm guessing. So I think it's going to pick up steam. I've been searching also, Tracy, for the PCRA petition. I'm not seeing it. I'll put Allie on it too. She might have to go into the docket to pull it because these are filed in state court. It's not, you're not going to find it in the appellate courts or anything like that. These petitions are filed with the court. All right, you guys are amazing. We have portaled you to welcome to the fam. Aw, family hug. Welcome, Mello. Mello and Lana, who's gone. Thank you guys for your generosity. Thank you. I don't think I got any, I don't have to call out any delicious Venmos or Cash Apps, I don't think. I didn't see anything. So you guys are amazing. We portaled you to the show at 7 tonight, and then we are portaling you after that. My boy. I mean, at this point, I feel like Dan has completely abandoned Steve, much to my chagrin. Like Steve is just manning the ship over there, like the champion that he is, the bearded champion. So yeah, we'll see you guys tonight at 7 with Josh Schiffer. It's going to be fun. He's really funny and smart. You guys will like it. We're going to talk Reed, as that's coming up tomorrow. I'll figure out what we're going to do with these. Obviously days that I've got more, like, because we have plans. You know, we're covering this, we're covering Adelson, and we're covering Walsh, all three of those hearings. We are not abandoning Iowa versus Todd Mullis. Had I known this was going, I still was going to watch Karen Reed for sure. Definitely was still going to watch Donna. Probably would have dipped on Walsh, depending on what the motions are. I'm going to double check and see what the motions are. If they're a bunch of bullshit, then maybe we'll dip on that one. We'll play it by ear, but I'll figure out how we're going to incorporate the CornRake murder trial post-conviction. Aw. Hi. All right. So you guys, I love you. I will see you in 2 and 2 or in 2 hours. 2 hours. Go get yourself something to eat. If you're across the pond, get your ass in bed. It's time for night. And you'll have to watch Josh on replay. And I look forward to hanging with Josh tonight. We'll see you guys in a little bit. Because if you guys weren't here, it'd just be me. And that would be an old man talking about a lot of cases. Ciao!
Hot